Yo, how are we? I don't know why you haven't got audio. I literally have no idea. So the other day I played that and everyone said that they had audio and I didn't. So I just went with it. So I blame all of you in the chat. It's all your fault, people. Um, so yeah, I blame all of you. So how are we this morning? This fine day. We got a lot of people in here. We got KD's in here, Badazza's in the house, Sarah P's in the house. Who else we got here? Just Jugs is in the house. Rhonda, sweet Rhonda Hinkley's in the house. Yeah, I think everyone. Like obviously Sarah P's given links here. Thank you, Sarah P. She actually pulled her finger out for once and did some work. So thank you, Sarah P, for working for once. Thank you. I do appreciate you, Sarah P. Right, what's happening? We're a bit behind. So I've spent literally 10 minutes, if not more probably, trying to um, um, trying to figure out how to go live. So I try to do I try to be, you know, I try to use my initiative by trying to stream onto Twitter and here. Hello, Rehab. Hello, my darling. I try to stream onto Twitter and here, but it doesn't work. You have to upgrade it to do that. So I'm on the free version at the minute. I'm trying everything out, and I can subscribe for like $30, $20, $25, whatever it is. I don't even 100% know how much it is. So I've not done that yet. But if I do that, I can then stream onto Twitter and other places as well. So I couldn't figure out, and once I figured that out, I couldn't do that. I couldn't figure out then how to start the stream. So, as they would call in France, there was a bit of a la nightmare. La nightmare. Thank you for whoever's pressing the hearts and stuff like that. I love that. So reactions do help. So yeah, keep pressing the hearts and stuff. I love it. So yeah, that's where we're at. We're on to day 3 today. I didn't realise Kat Williams is doing this as well. She's done yesterday she covered a stream on when they I haven't watched it because I didn't want to watch it live, about when they asked for this judge to be recused and stuff. So that was quite interesting. But yeah, seems that this judge and this defense attorney do not like each other. So the stream has started. It started probably about, I don't know, half an hour ago. So Law Crime did go back and forward on different things about times, but they have started. They've got a sidebar they've had, and I've not watched it, but we'll watch it now together because we are good. Also, I get errors on my side of stuff. I don't know why I get errors. I really don't understand it. Anyway, we'll try and fix that. Why is chat gone all quiet for? Motherfuckers. How can the chat ever be quiet with Badazza in the chat? Right, let me try and make this bigger. That's what she said. Right, that's not the one I want. This is the one I want. Yes, that's the one I want. So, yes, I'm not sure if the widget's going to work today or not. I don't know. Why is my chat gone? I don't know, but I don't know what's just happened now. I've just lost everything. Oh, no, it's there. Fine, right, let's get going because no one's talking, so might as well go. Right, is this it? Chat is on there. Oh shit, I switched it off today. Sorry. There you go, that's there. I'll make myself smaller. I wish I could just make myself smaller. Thank you, Rhonda, you're too nice. Rhonda's always nice to me. The rest of you're all bitches to me. But Rhonda's always nice to me. People say, why is Rhonda one of your favourites? I'm like, well, because she's always nice to me. Do you know what I mean? Be nice to me like Rhonda is, and we'll be all good. Sherry Berry's in the house. Hello to my darling. Nice to see you as well. Right, hang on. Let me make... Again, I want to say let's make this bigger, but I wish it was that simple. Right. So here we go. As I say, we're a bit behind, which is fine, because we can skip then over lunch and stuff like that. Then you know what I mean. So I was just wondering what I was getting the blame for now. That's all, Delan. You get the blame for pretty much everything. Dana's no longer watching the channel, so you get it. You've taken Dana's role. Right, here we go. Let's go. Oh, fuck. Alright, hang on.
SU calendar.
Alright, here we go.
State of Georgia versus Edrick Faust, SU 24 CR 0547. It is now 9:28. The call of the calendar was supposed to be at 9. Tomorrow morning we need to start at 9. A half an hour delay is not acceptable. 9 o'clock tomorrow morning, unless I say otherwise. All right, I want to take care of a few matters before I bring the jury out. There may be new faces in the audience. So there are media present here, and the media who are here have filed the appropriate motion to be allowed to use certain media. That includes cell phones and cameras and video. We have gone over that with them, with the parties here. So I'm saying all that to all of you for this reason. If there are people here who are not in the media and who have not been given permission to use any media, I need you to understand you cannot use your cell phones. So anyone who has a cell phone, it needs to be put away. It can't be on, right? Certainly that would disturb everybody. But most importantly, you can't use it to text, to do any research or anything of that nature. Law enforcement is exempted from that as well. Law enforcement needs their cell phones to conduct business in this building. I understand that. But everybody else, please put your cell phones away. I just want you all to be aware that if you are using your cell phone and you don't have permission, the deputy is going to ask you to leave and you will not be able to return. It's very serious. All right? Thank you very much for your cooperation. All right. Is the state ready for the jury to come out?
We are, Your Honor. I'll just note for the court that on the PowerPoint that we're going to use with Mr. Grove, and I've discussed this with the media, there is one sensitive slide. Okay. Before we click to that slide, I will indicate that we're about to see a sensitive slide. And then after we click off of that slide, I'll indicate that there are no more sensitive slides.
Thank you. Mr. Cruz, are you ready for the jury to come out?
Sure. I have one issue that I need to take up with the court. I can take it up on the record, Your Honor.
Go ahead.
We sent out our subpoenas for today. All witnesses were supposed to be responsive today. We have a witness by the name of Mr. William Ricketts that was non-responsive to our subpoena. So I asked the court for either one or two things. First, we'd ask the Honorable Court to enforce our subpoena and set a date certain that we could have a motion to attach the subpoena hearing for Detective Ricketts. Or two, if the Honorable Court is disinclined to allow us to attach a subpoena to Mr. Ricketts under the statute, we would ask that at the start of the defense's case in chief, if he still has not responded to that subpoena, we're granted a continuance to try to locate Detective Ricketts. But
grant a continuance of what?
We need him. He will be our initial witness.
Judge, I can probably shorten this up.
Sure.
We had discussed this issue previously with the court, not as it relates to Bill Ricketts, but as it relates to any person who is going to testify as a state's witness.
Yes.
And also had been subpoenaed by the defense.
Yes.
Mr. Ricketts has been very communicative with the state. He checked in earlier this week to see when we would need him. In the same manner that we did with Lieutenant Liedall, after he concludes his testimony for the state, he'll obviously speak with Mr. Cruz about, when he may be needed and establish some reliable means of contact. I honestly don't know whether or not Mr. Cruz has spoken with Mr. Ricketts outside of just sending him a subpoena. And I'm not asking. I don't think he has to necessarily tell me or the court that. But him showing up is not going to be an issue, Your Honor.
Thank you.
What I would ask to avoid us moving for any attachments, if the state is aware of the witnesses that we've subpoenaed as well, that they've subpoenaed, if they could just give us a list so we could know who is going to be called and who we may need to attach.
I'll let y'all work out that issue at the lunch break.
Sure.
But you're asking for a continuance? I mean, the state hasn't rested yet.
Well, I won't need it based on what the state just advised on.
All right. your request is denied in terms of a continuance, but I'll let you all work out the witnesses you all have in common. If you have a witness you can't get a hold of and you have subpoenaed that person properly, I'll hear it later.
Yes, ma'am.
All right. Anything else before we bring the jury out?
No, ma'am.
All right. Thank you. You may bring the jury out.
Thanks.
So, welcome to, you see, Caitlin's in the house. She's studying to become a attorney. Okay, jury's not quite ready to come out, but that's where we can zoom it in a second. So, good morning, Josie, my darling. How are you? So, yes, hello, Caitlin. Nice to see you, my darling. Hope you are doing well. Hope everyone's doing well as well. Right, let's skip this a little bit. I mean, this is Dave's girlfriend. Even
Time. CR0547, is the state ready?
State's ready, Judge.
Is the defense ready?
Yes, ma'am.
All right, thank you. You may call your first witness, Mr. Yellowman-Shilley.
Your Honor, we would continue with the testimony of Grove from the ATF. Mr. Grove, I would just remind you that you continue to be under oath, sir. As we finished yesterday's questioning, I think we had reached the point at which you had discussed fire dynamics with the jury and the three pillars, or the three legs as you described them regarding what it takes to create a fire. Did you, and we established that you had received contact and a request to assist in this particular case. As part of that request, did you receive any information about the case?
I did.
Okay. And did you review that information?
I did.
As part of your analysis, did you conduct any testing based on that information?
Yes.
All right. And you generated a report, is that correct, sir?
I did.
All right. Did you also generate a PowerPoint as a demonstrative aid in order to assist with your testimony?
I did.
All right. Judge, if I could show Mr. Cruz, and then after that, approach Mr. Grove. Mr. Grove, I'm going to hand you.
Right. Can you, Melissa, hello, Melissa. How are you doing, my darling? Can you all hear me now? I don't know what's wrong with my audio, people, but, you know, I don't know. But hopefully it's okay, but the main thing is that the court is okay. So here we go. We'll go back to it.
It's been shown to Mr. Cruz and what's marked as State's Exhibit 97. Do you mind taking a look at that and tell me if you recognize what it is?
I do. It's a
What is it?
it's a thumb drive that you had me initial this morning before court.
And have you had an opportunity to review the contents of that thumb drive?
I have.
And what is contained on the thumb drive?
It's pretty much figures directly from my report.
Okay. And is it in the form of a PowerPoint?
It is.
And is that the PowerPoint you created?
Yes.
And Judge, I'd move to tender 97 just as a demonstrative aid.
All right. Any objection, Mr. Cruz?
Yes, lack of foundation and hearsay.
Okay, I'm going to overrule that objection. You may proceed.
Yeah, I'm not a fan of this, Judge. I'll be honest, I'm not a fan. I would go as far as to say that she could be even worse than Bev.
And Mr. Grove, I'm going to go to the second slide in the presentation. What are we seeing here?
So that's figure one from my
Your Honor, I have a motion.
All right.
Outside the presence of
All right, ladies and gentlemen, if you'll go back into the jury room, please don't discuss the case.
Oh, fuck. Well. Oh, shit. Well, she's going to go fucking ape shit. This judge is about to go ape shit, is my prediction. There may be trouble ahead. Strap her in or strap her on, ladies. Let's hear what's going on. Fantasma. Oh shit.
Y'all may be seated. Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia Appeal, 373, 2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further, experimental or demonstrative evidence, like any evidence offered at trial, should be excluded if it's probative value and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce its demonstrative. Once the bail is wrong with the jury, it cannot be unwrong. As we've said throughout this trial, Mr. Faust's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Faust's due process rights, violation of Mr. Faust's due process rights, and the entry of this exhibit, we would ask that the Honorable Court grant our motion for mistrial.
Thank you. Mr. Yalman-Chile, any response?
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any of the questions as far as, what testing was done by Mr. Grove. We went through his qualifications. So, one, the motion is untimely, but even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Font Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information. He tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury in. It's certainly, one, it's not even improper, but two, it's not grounds for
Mr. Cruz, you got Mr. Cruz, I'm going to let you respond because it's your motion, but you need to let Mr. Yalman-Chile finish his statements. Go ahead, sir.
I said that the evidence is not improper. I am making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for a mistrial based on this, which is properly authenticated and admitted evidence as a demonstrative aid, Judge.
All right, thank you. Mr. Cruz, anything further?
Absolutely, Your Honor. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstrative. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yalman-Chile feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Faust did it. I say Mr. Faust is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they could present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on just denying our objection. So, Your Honor, Mr. Faust is not receiving his due process rights. I am requesting a mistrial.
Thank you, sir. All right. So first, I just want to respond, Mr. Cruz, to your comment that the defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. There are no grounds for a mistrial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding, again, that the evidence is, at this point, not improper. This is a demonstrative aid, and I'm denying your motion. You may bring the jury out.
Yes, ma'am.
She does seem to hate him, though. She said, cat covered it. I might play that on lunchtime because to see what the motion was to accuse this judge or why and stuff. But I'll be honest with you, I think, I love bitches, you know that, but I do not like this bitch. I do not like it one bit. She's not part of the nosy bitches. She's not part of this chat. She's just a bitch.
All right, you all may be seated.
Hey, Dave.
Mr. Yalman-Chile, you may continue.
Thank you, Your Honor. Mr. Grove, the question I asked you before we paused there was, do you recognize what is in slide 1 here?
I do.
Okay, and what is that?
That's figure 1 from my report. It's the front of the house. We would call that side A.
Okay, and so side A would be the front, is that what you just said?
That's correct. And if you go in a counterclockwise direction, side B would be to the left, side C would be a clockwise direction. Side B would be on the left of the house, side C would be in the back, and side D would be on the right of that picture. When I look at that, what it's telling me is that there was some soot inside the attic space, and it was pressurized such that it pushed that soot out the soffit vents on the front of the house. You can see soot stain on the brick, as well as a little bit on the gable vent on side D of the house.
Okay. And I'd like to take you to slide number 2. I guess it's technically slide 3 because the first one was a cover sheet, but we're going to go forward to that. Can you tell me what you see here?
So that's side C of the house or the rear of the house. There's a tarp over what is presumably a hole in the roof, as well as some damage to the soffit. And boarded up is the window to the room of fire origin.
And I'm going to go forward to the next slide. Can you tell me where this still image came from and also what you see here?
So this was a video that I was able to watch after I wrote my report. This is a screen capture from that video, and it shows a good view of the tarp. So clearly there's no ceiling in this room. The ceiling's collapsed, as well as some pretty extensive damage to the roof over the window in the room of fire origin.
And what do you see in the window itself?
So regarding the window, the glazing has been broken out in the top part of the window, but is intact in the lower part of the window.
All right. And I'm going to go forward to here. What do we see here?
This is a sketch showing the house. The room of origin is in the upper left-hand corner, labeled bedroom number 3.
And this next image, what are we seeing here?
An interior shot of the room of fire origin from the perspective of the door. You can see that there's some collapse of the ceiling joists, as well as some pretty extensive thermal damage in the upper part of the room, including some consumption of the mattress.
Okay. And our next slide here, what are we seeing?
So that's a close-up view of the bed. You can see that the wood part of the frame, while it has some soot staining, is still pretty much intact. There's some gypsum wallboard from the ceiling that has collapsed onto the bed. There was some consumption of bedding materials.
Okay. And Your Honor, the next slide that we're going to show has some sensitive information on it.
All right.
And Mr. Grove, what are we seeing in this slide?
This is figure 6 from my report. It's the room of fire origin looking down at floor level. And what's important there is the lack of damage to the carpet, as well as all the generally combustible materials in that room. So it tells me while there was some heat damage to the upper part of the room, the upper part of the walls, the ceiling, we really didn't have a lot of fire damage down below. And so that tells me that that room did not transition through flashover. There was not a fully developed fire that was burning in that room for an extensive period of time.
Okay. And I'm going to go forward to the next picture, but then I do want to ask you some questions about some of the words that you just used in that response. I'm going forward to the next slide. The sensitive information has been removed from the screen.
So this is the range in the kitchen, and what's important here is that all 4 of the what we call infinite control switches, or the knobs on the stove, are turned to the high position.
Okay. And backing up to something you said about the damage in the room, where it was significant, where it wasn't significant, you used the word flashover. Can you please tell the jury what that means as it relates to fire dynamics?
So a good definition that ATF uses and teaches our investigators is that it's a transition from a fire in a room to the whole room being on fire. And it's something that we as fire protection engineers really try to prevent when we design buildings, because post-flashover conditions deteriorate very quickly. There's a lot of damage and a lot of threat to property and people, as well as making the job of a fire investigator pretty difficult.
Okay. And if we could, I know that we backed up a little bit. You had testified already about what you saw in this image. I'm going to take you forward to the next image. What are we seeing here?
So this is a close-up of the left front burner, and we see some burn material around the element.
All right. As it relates to the specific requests that you received in the request to assist in this case, were there particular questions or scenarios that you were asked to consider and test?
Yes, one of the hypotheses that was presented to me was that, and this is coming from Special Agent Will Perdue, that a blanket was taken out of the bedroom, placed on that element that was in the high position, and the element was used to ignite the blanket, and then the blanket was transported back to the room, to the bedroom, or the room of fire origin, to set the bed on fire.
Okay. And as it relates to kind of those two things that you just mentioned, I'll start first with the ignition of a blanket on a stove burner element. Is that something you tested?
It is.
Okay. And how did you go about testing that, given the information that you already knew from having received information about the investigation?
So we were told that the item that was most likely ignited was a chenille type fabric. So I did an internet search and purchased what I considered to be similar fabrics. I selected 3 different materials, synthetic materials like polyester, and then natural materials like a cotton and I think a rayon, which is a bamboo type of fabric.
Okay. And as far that's the selection of the blanket. As far as the ignition on a stove burner eye, what did you do in order to test that scenario?
We ran 3 different types of tests, but regarding ignition, we cut the fabrics that I purchased into roughly 1 by 1 foot squares and then placed them on the burner. We laid them in a flat configuration, and then we also bunched them up and put them bunched up on the burner.
I'm going to go forward to this next slide. This is a cover sheet, but what does it say?
Range tests.
Okay. And I'm going for range test. Would that be referring to the stove eye?
Correct.
Okay. I'm going to go forward to the next slide. This is test A. What does that refer to?
So I labeled my tests A, B, and C. A is just the ignition test with the 1 by 1 foot square fabric samples.
Okay. What am I seeing here?
This is just an example of one of the samples that was cut. It happens to be 100% cotton.
And I'm going forward. Is that the approximate size of each of the samples that y'all cut for placement?
It is. I think in my report I said roughly plus or minus 2 inches.
Sure. What is this depicting?
So this is an ignition of one of the samples, and this happened 1 second after being placed on the burner. So we put that sample on the burner. Within a second, it ignited.
And which sample would this have been?
Looks like this is what we call I'm going to call that RACO sample.
Okay. I'm going to go forward to the next slide. What am I looking at here?
This is from test 6. So we used 2 different stoves in these tests. One was manufactured by Hot Point. The other was GE. This is also a burner in the high position, and this is 2 seconds after one of the samples, and it's a different sample than you saw before, but being placed on the burner.
All right. And I'm going to go forward to the next slide. You mentioned placing samples on the eye of the burner kind of in different ways. What are we seeing here?
So this is one of the samples. Rather than being placed flat on the burner, we crumpled it up and put it on the burner, and it took about 4 seconds to ignite. And the trend that we saw was if you crumpled it, generally it took a little longer to ignite than if it was laid flat. And I think that's just because there's less surface area available for that textile to come into contact with the burner element.
Okay. Go forward. What were tests B in your scenario as it relates to the blanket and the burner elements?
Test B, we were looking at ignition, but we were also looking at upward flame spread. The idea if someone were to take a blanket or whatever it was and hold it over the burner and then carry it like this, what might that look like?
Okay. In general terms, can you describe the rate at which flames spread on material that's stretched vertically as opposed to one that is not?
Sure. Upwards flame spread, or what we call concurrent flame spread, is much faster than downward flame spread, approximately 2 orders of magnitude. And then we can also think of lateral flame spread. If you lay this material flat on the ground, how does the flame spread across something flat on the ground? And it's also very slow compared to upwards flame spread.
Do you mind talking about what orders of magnitude means?
Sure. It's so let's say it's and I'm going to draw some numbers here. Maybe 100. Actually, I'm not going to do that. It's much quicker. So rather than say 1 centimeter per second, it might be 100 centimeters per second or something like that.
Okay. What am I seeing in this figure?
This was our experimental setup for phase B.
Okay. And what is this table that we're seeing now?
So these were the 12 tests that were run in the B phase. Each test was done in duplicate. You can see in the second column or the middle column the 6 different types of materials that we tested. And then the last column on the right is how that material reacted. And so if it's if it's a natural fiber like a cotton, it burned very readily, very vigorously, and we had a relatively high heat release rate. We talked about that in units of kilowatts, so we had a lot of kilowatts, basically a large fire. And if it was a synthetic material, we did not get such a large fire. A lot of those materials dripped, and it was a very slow upward flame spread. And I think one of them actually might have gone out. Yeah, ignition wasn't sustained in test 14.
Okay. And I'm going to go forward to the next slide now. What are we seeing here?
So this is 2 minutes post-ignition. What we would do is take the bottom of that fabric, move it over to the burner element while it's hanging. Once we get ignition, we let it go, and then we just document the upward flame spread, as well as we measure the heat release rate or the size of that fire. And so you're looking at an image that's 2 minutes post-ignition.
Okay. What are we seeing here?
This is a different sample, but you're looking at 1 minute and 12 seconds post-ignition. So this is a comparatively very intense fire.
And what do we see here?
This is a synthetic fiber, so it does not burn as readily, particularly when we're looking at upward flame spread. This is 2 minutes post-ignition, and you can see it's a very small fire, a lot of drips to the ground, and it's hard to get that flame to move up the fabric.
Go forward to the next slide, and that puts us at test C. What were test C as it relates to your analysis of some of the scenarios related to this case?
So test C, we're looking at ignition, but also lateral flame spread across the fabric if we were to bunch it up. So if someone, rather than carry it like this, and I'm using 2 hands to hold it, they would maybe cradle it in their arms, and so it's kind of bunched up. And rather than having someone hold it, we just put it on the ground.
What do we see here?
So this sample has been ignited, and it's burning on the ground. I labeled this as a setup photo.
Okay. Going forward to the next slide, what is this table?
These are the 12 tests that were done in Phase C. We have the same 6 textiles, and the tests were conducted in duplicate. And then on the right-hand column, I'm looking at the peak heat release rates that were measured, and those were noticeably smaller than when we held that textile up vertically. And the synthetics actually performed generally a little better than the natural fibers in this configuration, which is different than when the fabric was held vertical.
Okay. Going forward to the next slide, what are we seeing here?
This is 2 minutes post-ignition. This would be a natural fiber, and that's what the fire looked like.
Go forward again. What are we seeing here?
This is about 7.5 minutes post-ignition. This is a synthetic fiber, so that's a much larger fiber than a much larger fire than the natural materials.
Okay. And I'm going to go forward to the next slide now. Fire development analysis. What does that mean?
So one of the questions that was asked of me was to figure out how this fire, if it was started on the bed, would grow in the room to the point where we get flames through the roof such that they were observed by firefighters. What's the chronology of those events, and then how long might that take to occur? So building a fire timeline for this case.
Okay. Can you talk to me a little bit about the Kinston test?
Yeah, so the Kinston tests were conducted in 2001. It was a research project using 4 houses in Kinston, North Carolina. Those houses were, I think, in a floodplain. FEMA bought out the owners, so the city was going to destroy them, and we were able to run some tests on them. They were modest-sized houses, probably about the size of this house. And what we were looking at was if you were to spill a lot of gasoline in a house and then ignite it and allow that fire to progress through flashover, be a fully developed fire, meaning there's flames blowing out the windows and the door, and we had allowed the flames to go through the roof, and then in some cases the roof actually collapsed into the house. Are there any indicators left over that gasoline was used? And it turns out that's not the case at all. Gasoline only burns for maybe 20 or 30 seconds when it's spilled. So all that damage to the house is from the contents in the structure itself.
Okay. And so we talked yesterday a little bit about fuel limitation and ventilation limitation. Can those factors affect the rate at which a fire spreads?
Absolutely. So fuel-limited fires, I have a couch burning out in my front yard. That fire can only get as large as the amount of vapor that I can burn. If I take that same couch and I move it into my living room, it starts out as a fuel-limited fire. It's somewhat small. It's using the oxygen in that living room, in that space. But if the fire doesn't have access to additional air or additional oxygen, it becomes ventilation limited, meaning the size of the fire is dictated by how much fresh air we can get into that space. And with an open door or breaking a window or something like that, fires generally don't do as much damage and sometimes go out on their own.
As it relates to the Kinston test, how did y'all set the fuel factors and the ventilation factors in that case?
So we were really just trying to get fires that developed very quickly. We had fuels that were readily ignited. I think we had a stuffed chair. We took wood pallets. We stuffed polyurethane foam in them. Some of the, excuse me, some of the fires were, we had 8 gallons of gasoline used to get the fuels that were already in that space involved. Others we ignited without gasoline. So a readily combustible large fuel load, as well as an open exterior door, and we had some open windows in the space. And we also had access from the living room, which was the room of fire origin, to the rest of the house, except for the kitchen. So really optimal conditions to allow a fire to grow very readily and very intensely.
All right. Would you like me to get you a glass of water?
Nope, I've got this right
You got
here.
it? Okay, all right. Oh, yeah, thanks. I'm going to go forward to the next slide. Can you show me or tell me what we're seeing here?
So we ran 4 tests in 4 different houses. This is test house 1. 1 and 3 were non-accelerated. 2 and 4 were accelerated. I only used 1 and 3 in this analysis.
Okay. And what do you mean by accelerated?
Accelerated with 8 gallons of gasoline.
Okay. And I'm going to go forward to the next slide. What are we seeing here?
This is typical for all the tests, but it's the fuel load inside the living room. So you see the stuffed chair, you see the pallets with some polyurethane foam on them. And then next to that, you see a futon. So that is the room of fire origin with a pretty substantial fuel load. And then in some of the bedrooms, we had pallets as well for some additional fuel.
All right. Going forward to the next slide. What are we looking at here?
So this is test house 3. This is post flashover. We have a fully developed fire. We've vaporized so much fuel that there's not enough air inside the structure to burn it all, so we see a lot of burning taking place outside the structure. At this point, we might have a hole through the roof, or it just could be the asphalt shingles that are burning. We had cameras set up on the front and back of the house, and people monitoring those cameras and kind of dictating what they saw during the fire.
Going forward to the next slide. Can you talk to me just about some of the key timelines in the Kinston test?
Yeah, so this is test 1. These are observations at the rear of the house. I actually took a lot of this data from a previous case that I testified in Atlanta, and a lot of this data comes from that report. But this was me reviewing those videos, so using my eyes to see what I saw in the video, as well as hearing what the folks next to the camera were, what their observations were. I have time in the first column, so the first row is 3 minutes and 15 seconds would be the time, and the observation is that there's smoke visible above the house. 3.5 minutes, there's flashover in the living room. And this is someone at the rear of the house, video at the rear of the house. 10 minutes, we have fire out a rear window and door. 13 minutes, smoke venting around a chimney. We get to 25 minutes, and we have flames coming out around the chimney. So what I was doing here was kind of using these as a baseline. How long might it take to get flames through a roof under really optimal conditions? And in test one, it took 25 minutes.
All right. And after we walk through the Kinston test, I am going to ask you some questions about how the conditions at this particular scene compared to the Kinston conditions.
So these are just observations at the front of the house. And once again, at 25 minutes and 20 seconds, I wrote that the porch is fully involved and there's fire venting out the roof above the living room, and that is the room of fire origin in this particular fire.
Going forward, another slide. This is Kinston test 3. What are the key time points here?
So the same process, but at 20 minutes and 30 seconds, I wrote fire appears to be venting through the roof. In some cases, it's kind of hard to tell whether it's flames through the roof or the asphalt shingles are burning. But at 22 minutes and 30 seconds, there was significant flame venting through a hole in the roof above the kitchen.
I'm going to go forward one more slide. What are we looking at in this table, and what are the key points?
These are observations at the front of the house at 21 minutes and 30 seconds.
You know, sometimes I ask, why do you think people don't stick around this channel? Why do you think people get so easily offended by this channel? And I look at chat and I'm like, hump, cans, rocks, jugs. Oh, friggin' Nora. If we ever question again why people don't come to this stream or this channel, just look at chat. Oh, fuck.
I wrote that fire appears to be venting through the roof in the area above the living room.
Okay. We've talked about the conditions that y'all set up in the Kinston test. How were the conditions at 160 Fawn Drive different from the Kinston test?
They're different in terms of the fuel load. In that space, we only had a bed, which is a decent fuel. The mattress, they burn pretty well, but probably not as well as an upholstered couch or something like that. A bed's a flat surface, whereas a couch has some vertical surfaces, and they tend to get involved a little quicker. But the biggest difference would be ventilation. So in the Kinston test, we had an open front door, we had open windows in the house. In this particular case, the room of origin was just the bedroom. My understanding from reading some firefighter statements was that when they made entry into the house, it was smoky in the main living area, but they couldn't find flame until they kicked in or broke in the bedroom door, and then there were some flames up high. So the big difference would be ventilation, where closed door and closed window, so that can really affect how long it takes a fire to develop.
Okay. Can you talk to me about fire spread to an attic and the methods in which that can occur?
Yeah, so in this case, I was presented with the theory that a blanket was ignited on the burner. That blanket was transported to the bedroom, whether it was held like this, 2 hands on it, or kind of cradled in someone's arms. You could ignite that blanket and bring it into the bedroom. That blanket was then put on the bed, or maybe at the foot of the bed, maybe igniting the bed clothing, maybe igniting the pillows. And I say maybe because we just don't know. So fire grows on the bed. At some point, whoever did this left that bedroom, and at some point, that interior door or the window was shut, depending on how someone left. So now this fire is growing in this compartment with the door and window closed. It forms a hot upper layer in that compartment. An unknown amount of time goes by. We can start to stress out the upper part of the window, We know that heat rises, so if we think of heat soaking or materials absorbing heat, it's going to happen at the ceiling much more readily than at the floor, the upper part of the walls rather than the lower part of the walls. So the upper part of the window rather than the lower part of the window, but that window is going to heat soak. We're going to induce stresses in the glass, and at some point that glass can begin to crack, and eventually those cracks can lead to pieces of that window falling out. Sometimes windows fall out all at once. Sometimes you get little holes and pieces kind of come out piecemeal. But now we're getting some fresh air into that space, so the fire can now grow again because it's getting the piece that it was missing, which is fresh air. And then we look at fire spread into the attic, and that can occur in one of two ways. Once the window's broken, we may get flames out the window, which hit the bottom of the soffit. If there's a soffit vent directly above the window, then we have pretty much direct access for flames to get into the attic. If not, then we have to burn through that wood, but still we can get flames into the attic. If flames didn't spread through the window, we could have had failure of the gypboard ceiling, which we know occurred because the ceiling was on the ground, the insulation was on the ground, on the floor. And then flames can get into the attic through the interior of the house, through the ceiling. Either way, we're getting flames into the attic. Now we're going to burn the bottom of the wood material on the roof, anything else that happens to be up there. It's a nice vertical surface, so we can get some pretty good flame spread up that vertical surface. Air for that fire would come in through the soffit vents or through the window and the hole in the ceiling. So that's kind of what the inlet is, or the supply of the air. And then the exhaust would be the gable vents, and at some point the hole in the roof itself. So once we get fire into the attic, things can happen fairly quickly. In the Kinston test, it was about 10 to 17 minutes of burning in the attic before we had a hole through the roof. But that was kind of the chronology of events. So fire developing in the room, does it spread into the attic through the interior of the house, or does it spread into the attic through the exterior of the house, through the window and into the soffit? And then I tried to look at each one of those things independently and, where possible, assign some times.
Were you asked anything about the possibility of bed ignition by placement of a flaming item on the bed?
Yes.
Okay. And did you make efforts to test that particular scenario or hypothesis?
No. So we have a lot of test data that we have for other cases, other research projects. So I used data that was conducted prior to this case. This particular slide is burning on a queen-size bed. It was done for a criminal case in which it's believed that flaming paper was put on the bed, and that was used to ignite the bed.
Okay. I'm going to go forward to the next slide. And what are we seeing here?
So this is the queen-size bed with the bed clothing still burning. This is what appears to be a synthetic fiber, and we're looking at a very slow flame spread across the flat surface of the bed. Now we're burning some of the material hanging on the edge. But the important thing here is this is 30 minutes after placement of the flaming paper. So this is pretty atypical. It's a very long, what we call incubation period, meaning that the fire just takes a long time to get going. But it can certainly happen.
I'm going to take you to the next image. What are we seeing here?
This is 50 minutes after placing that paper on the bed.
And the next image?
This is 58 minutes after placement of the paper. And this fire really got going once the pillows became involved. The drapes you see are...
I'll back up one slide.
If you back up before, you see there's some drapes there. It's a nice vertical fuel surface which burns very readily. So when you go to the next slide, you can see they've already been consumed. This is a very large fuel limited fire, but it took 58 minutes to get to this point. But I should note this is atypical. This is, in this test series, I think like 12 tests were run, and this was by far the longest. Some of them are maybe like 4 or 5 minutes, 3 minutes, something like that. It all depends on where that flaming piece of paper is placed.
And so you said it was fuel limited in the sense that it was the bed. What were the ventilation factors in this particular test?
So this was done on one of our burn room floors, and that bed has access to all the air that it needs to burn. It is 100% limited by the amount of fuel that can be vaporized.
Okay. And so this would be a ventilation-rich environment, I guess, is that?
It's a way to look at it, but air is not inhibiting, air for combustion is not inhibiting the size of the fire.
Okay. What are we seeing here?
This was another case that we ran tests for. I believe this was in Moscow, Idaho, and the issue here was fire timeline. It was an apartment complex. There was a bedroom being the room of fire origin, and the fire was discovered by a person in the unit above the first floor there. So he ends up seeing flames coming up past his window, and he calls 911. But the important thing here is that prior to failure of the glazing, you can get leakage around the window. So oftentimes neighbors will report smelling smoke, something's burning, but we don't know where it's coming from. This is just an example of how that can happen.
Okay. And what are we seeing here?
This is an infrared image of that same window, and it shows the heat soaking to the top part of the window relative to the bottom pane, which is relatively cool. Blue is 20 degrees Celsius or 68 degrees Fahrenheit, and red is 100 degrees Celsius. So not really that high of a temperature, but it just shows you where the heat soaking occurs, which would be similar to what would have happened in our space.
Okay. And 100 degrees Celsius, can you quickly convert that
12 degrees Fahrenheit.
to 12? And
Yeah.
is there anything significant about that temperature for common everyday purposes?
Water boils at 100 degrees Celsius, but that's just the scale we had on the image.
Okay. So the bottom portion, I think you said, was approximately 68 degrees Celsius, while the top portion was, 68 degrees Fahrenheit, while the top portion was 212 degrees Fahrenheit. Is that correct?
That's correct.
Okay.
And that image is really just showing what happens when you have a fire not right up against the window, it's somewhere else in the room, and the heating by that window is radiation from the flame directly itself, as well as the hot layer that's formed. Had there been a couch right up against the window, that would look dramatically different.
Can you, and that's the end of the slideshow, but I do have some more questions for you. Can you talk to the jury about the ways in which, in a ventilation-limited environment, HVAC systems can affect a fire and its development?
Yeah, so we had a case in West Virginia. There was a fire in a bedroom. Neighbors reported smelling smoke throughout the morning. No one could determine where this fire was. It was a suburban single-family house type neighborhood. A person reading meters happened to be walking by the front of the house and then saw flaming debris on the floor of the living room through glass panes on either side of the door. 911 was called. Shortly after getting to the scene, a window in the bedroom broke out, and then we ended up getting some of the roof, I think, involved. But what was unique to that scene was that we had 2 holes burned in the floor. And so we were using the holes to try to get an understanding of the fire timeline. And so we studied how long it might take to burn these holes in the ground, or through the floor. On one of those tests, it took like 2 hours and 12 minutes. And so it takes a while to form the hole, and then the window broke out subsequent to the hole. So we know that sometimes window breakage can take a long time. And then there was 3 scenarios we ran with the ventilation. One, we had no ventilation. The second, the fan was running 100% of the time. And then the third, the fan was cycling. I think it was on for 10 minutes, off for 15 minutes, and I can talk about those as well if you like.
And if you would, please talk about how those differing cycles affected the fire development.
So with no mechanical ventilation, no HVAC, the fire was started on the bed or on the ground near the bed clothing. Fire grew for about 5 minutes. Pretty good increase in fire size. It ran out of air. It became ventilation limited and went out. So limited damage to the materials inside the bedroom. No holes in the floor. One of the scenarios was HVAC running all the time. So we're just blowing air into this room through a simulated HVAC system. Fire is lit, and rather than going into decay because it's running out of air, it's able to continue burning. We actually ended up getting some small flames through the ceiling assembly. We put those tests out, and we had some pretty extensive damage in that space, but no holes in the floor. Fire cycling on and off, so when it's on, the fire's growing. When it's off, the fire begins to go into decay. We ended up running through 6 cycles of that before we got a hole through the floor. So HVAC can certainly lend itself to a longer duration event prior to maybe a window breaking out. So in a scenario where a fire might die out because it's going to lose air, HVAC can kind of keep it alive until a window fails and you get a lot of air into the space, and then things can really take off.
Did you draw any conclusions about the viability of the scenario that was presented to you in this case?
Can you be more specific?
Sure. What, if any, conclusions did you draw regarding the ways in which chenille fabrics can ignite in the scenario put before you in this case?
So chenille fabrics, they can certainly ignite on a stove when it's set on high. That blanket can be transported to the bedroom, and a fire certainly started that way on the bed.
Okay. As it relates to the Kinston test versus the West Virginia scenario that y'all tested, are the environmental factors, fuel load as well as ventilation being limited or not limited, in this case, closer to the Kinston test or closer to the West Virginia scenario?
Definitely closer to the West Virginia scenario. The Kinston tests were a good starting point. If I'm really trying to get an aggressive fire very quickly.
Objection, Your Honor. Undisclosed expert opinion. We don't have anything about a West Virginia test in the documents provided to us from the state.
All right, Mr. Yeoman, Mr. Yeoman, shall you care to respond to the, well, what is your objection, Mr. Cruz? Yeah, go ahead.
I apologize, Your Honor. Undisclosed expert conclusion. We don't have, in the documents provided to us, we don't have anything about a West Virginia test.
All right, thank you. Mr. Yeoman, any comment on the objection?
Your Honor, hold on one second.
All right.
I'm looking at Judge, I'm looking at page 16 of the report, and I may be referring to it by different terminology, but it's in the report.
Anything further, Mr. Cruz?
If I could approach Mr.
You may,
Cruz.
certainly.
I would stand by my objection. There was no disclosure of a West Virginia test.
Mr. Yeoman, your take on it is that it is in the report.
It's in the report. I might be referring to it by a different name based on my conversation with Mr. Grove, but all of the information that we just went over is in this.
The only thing
Yes, sir.
I'll ask, he makes it very clear for the jury what he's referring to, as opposed to referring to it as a West Virginia test.
All right.
Based on what's been shared with us.
All right, thank you, Mr. Cruz. I'm going to overrule the objection. You may continue.
Thank you, Judge. Ms. Grove, I kind of lost where we were in the questioning. I think it was you were in the process of explaining the way the Kinston test was set up when we stopped. Is that right?
That's correct. So the Kinston tests were designed to get a very rapidly, very intense fire. We were not looking at how long it takes to get flames to the roof, but we had that information, so I used it. It took 20 to 25 minutes. That was kind of a starting point. And then I was able to look at some of the factors that might change that for this particular case in Athens, using some other data from previous cases. The West Virginia case, or the test that we ran with ventilation cycling on, off, or with ventilation on, off, or cycling, and what we found is if the ventilation's off, the fire goes out, doesn't put a hole through the floor. If it's on, we get flames, small flames through the ceiling prior to burning a hole through the floor, and if it cycles, we end up getting a hole through the floor. And it just happened in that case, the window broke out after the hole. So it's a good example of a long duration fire where window breakage does not occur right away, which, you know, sometimes that can happen. And I think the takeaway here is, if you asked me, hey, I start a fire in a living room and there's an open window, I can bracket that pretty tightly in terms of how long it'll take to get flames out that window. It might be like 4 to 8 minutes or something like that. If you close that window, it's a different story. It really depends on how long it takes that window to break. The Kinston tests were set up to burn very quickly. In this particular scenario, maybe that happened in terms of ignition of the bed, and maybe it didn't. If we're setting an incendiary fire, there's probably motivation to allow that fire to develop very quickly, but there's no saying for sure that occurred. It could have been a relatively ineffective ignition and early fire growth.
Okay. Judge, I don't think I have any other questions for Mr. Grove.
Cross-examination, Mr. Cruz.
Good morning, Engineer Grove.
Good morning.
I want to thank you for being here. Is it okay if I ask you a couple of questions?
Absolutely.
Did the prosecution ask you to prepare this report?
Yes.
Was it?
Well, so I was working for Special Agent Perdue, knowing that this case might go to court. The report is addressed to Special Agent Perdue, and it comes to the court that way.
Sure. So this report was prepared for the purposes of this litigation?
Correct.
When was the report requested? Just year. You can just give us a year.
I think 2024.
Were you aware that this fire happened in 2001?
Yes.
Okay. So you wouldn't have any reason to disagree with me that they asked you to conduct this test 23 years later? Would you have any reason to disagree that you were asked to conduct this?
No.
You would agree that Mr. Faust was arrested on May 9th, 2024. Is that correct?
I don't know that.
You're not clear with that? Okay. Is it fair to say, and please correct me, have you ever visited the Deer Park neighborhood?
No.
Did you ever walk through Miss Baker's home?
No.
Did you see a video of a walkthrough of her home?
There were several short videos that I was able to look at, yes.
Okay, can you describe those videos for me?
It was dark, smoky. I focused on the ones in the bedroom.
Sure.
So it's just someone walking through with a camera, kind of looking around the bedroom.
Sure. Can you tell us the square footage of Miss Baker's home?
Ooh, in my report, I looked at the square footage from a website. I think it was used for taxation purposes in Athens, and was able to get an idea of what the square footage was. Off the top of my head, I think it was like 40 by 36 feet was the entire footprint of the house.
What is that? I chose law because I'm not good at math. So what is that if you give us that number?
Oh, in square footage?
Mm-hmm.
Well, let's do 40 times 30, so that's like 1,200 square feet.
Okay, excellent. What were the sizes? Excuse me. What was the size of the locations used for the test?
For which test?
I believe it was 4 Kingston tests. So we'll start with the 4 Kingston tests.
Yeah. I don't know the exact footage. The houses were probably a little bit smaller, but they were single-family houses, so living area, kitchen, a few bedrooms. I would say slightly smaller than the Athens house.
Do you have a copy of your report with you?
No, but I think I can probably get it.
Okay. I would like you to look at. Excuse me. Page 6 of 39, third paragraph, first sentence.
Your Honor, if we are refreshing his recollection with that, it probably needs to be marked for purposes of the record. It wouldn't go back with the jury, of course, but.
That's correct.
That's not. Forgive me, give me one second. Let the record reflect that I am marking excuse me. Let me get the proper title. Court's indulgence. I am marking Engineer Grove's report as Defense Exhibit 18.
All right, and this is the state's copy, though, is that right?
That's correct,
Okay.
Judge, but it's a printout of a PDF.
Okay. I mean, we can make a copy afterwards and give it back to the state and make this the exhibit if you want to, but I'll let you talk about that later. Go ahead.
You said page 6,
Of 39, third paragraph,
Sentence.
sentence 1.
Sentence 1. That says figure 12 shows the front of the house used in test 3.
Sentence 2.
In parentheses, the author does not have any pictures from test 1 in parentheses.
May I see that report, please? Sentence 3.
Each house had a floor area of approximately 130 square meters, 1,400 square feet, based on scaling from photographs.
Okay, so the test house was 1,400 with the Kingston test. Is that correct?
That's what I'm approximating, yes.
Yes, sir. And all the information you used to conduct your testing was based on information that was told to, you said his name, Special Agent
Purdue.
So information told from someone to Special Agent Purdue, and then from Special Agent Purdue to you. Is that right?
Well, yeah, for background in the case, yes.
Sure.
But in the particular measurements of the house, I got that from tax records from Athens.
Fair. Just background.
Yeah.
Just background of the case.
Right. Background of the case, photos, and I guess is Detective Leadhall's report.
Excellent. If some of the information that you received was incorrect, could it affect the outcome of your testing?
Sure.
So can you tell us what type of chenille blanket was used to start the fire? Was it a chunky knit chenille blanket? Was it a woven fringes chenille blanket? Was it a lightweight chenille blanket? Do you know that?
Yeah, I sure can. And we get this question fairly often where, a lot of times we don't know. So I got a variety of different fabrics. Some of them were really kind of thick and fuzzy, which chenille fabric is. Some were polyester, some were natural fibers. So I have no idea what the actual blanket was.
Yes, sir. As far as the mattress Ms. Baker had, do we know if it was an innerspring mattress, a foam mattress, a latex mattress, or a hybrid mattress?
I would say that it had springs that kind of popped out in the photographs, if I remember. But in terms of the materials in that mattress or any details on that mattress, I have no idea.
Yes, sir. Do you know the type of material Ms. Baker's bed frame was made out of?
It appeared to be wood.
Okay, what type of wood?
That I can't tell you. Was it a press board? I have no idea.
What about, do we know if it's cherry, oak, mahogany?
We sure don't.
What were the items in Ms. Baker's room that contributed to the size of the fire in her room? Do you know?
I'd say the primary fuel load was the bed itself, the mattress, maybe a little bit the box spring. There was some charring of the wood frame. I think in the report there's written notes that there's some consumption of parts of the frame. But that was the bulk of the fuel load. Certainly fuels on the floor were generally in pretty good shape.
But do you know any of the other items outside of the bed that may have contributed to the fire?
Yeah, looking there were a limited number of photos and sometimes fuels that might get involved weren't involved. So I would say the primary fuel is really where the bed itself and the bed clothing, whatever that might have been. If it were blankets, pillows can burn fairly well.
Do we know what the bed clothing, or were you provided the information?
No.
On the bed clothing. The Kingston's test was done in August of 2001. Is that correct?
Yes.
Okay.
That's my recollection.
But that had nothing to do with Ms. Baker's case. That was an independent test that you all conducted as an agency.
Yeah, that was a research project. That's right.
Your Honor, I would ask permission, if I may speak to the state, I would ask permission to use their demonstrative during the examination of this witness.
I'm going to let you have a conversation with the state. I'm going to, this is a good time actually for a restroom break. So I'm going to send you all to the jury room. Don't talk about the case. And hopefully this is a good break for you all. And I'm going to allow the attorneys to have a 10-minute recess to have a restroom break. So we'll be off the record until 10 minutes to 11. Thank you.
So, we're on break. Hello, J-Mac. J-Mac is going for cancer treatment today. Hope it goes well, my darling. Nice to see you. I was having a conversation with J-Mac earlier on. She was saying that she likes everything to be above 12 inches, but that's a different conversation. How is my audio? Melissa, can you hear me now? Can you hear me now? Melissa. Some people have had this...
So I'm just going to give them again. There are permissible media allowed in the courtroom. They have filed the appropriate motion to be able to use either their cell phones for pictures or note-taking or for video circumstances, and obviously you all see there is video in here. The media have applied properly to the court, and the court has given permission to the media. I'm telling everybody this who is new to the courtroom, may have come in after we started, that because of that, it is impermissible for anyone else in the courtroom to use a cell phone while court is in session. And so I'm just asking all of you, if anybody has a cell phone, to make sure you put it away. Obviously, if you could turn it off, that would be great. It'd be difficult for it to go off, obviously, in the middle of court. But please don't use your cell phone. If somebody does, as I've stated earlier, use their cell phone during court, the deputy will ask you to leave and you will not be able to come back. So I just wanted to make sure everybody was aware of that rule. All right, we'll be in recess for 10 minutes. Thank you.
So, I'm lower than the court, fine. The reason is, I think, because the court... So what the court volume has been boosted so much on my side that you guys may have lowered your side, which means that I'm lower. So maybe you have to increase your side. Just test that out, Badaza, maybe. I hope, Josie, I'm not sure if you saw it, but if you do hashtag stop, not hashtag stop, sorry, exclamation mark stop, your little command comes up. So Dave has an infatuation with this judge. He does really like her. He said he likes to be dominated. So I do not like this judge. I think she is a piece of shit. And I'm trying not to use too much language on that, but I don't think it matters what the defense do, you know. I just don't like her. And I'm not saying every decision she makes is wrong. That's not what I'm saying. It's more she's got this kind of snarl about her because the defense attorney has tried to get her not banned, but removed from this case. And she probably holds a grudge. So, I don't know. I don't like it. Am I still low now, Badaza? I haven't been able to hear you without my headphones on since your new setup. Everything else you play is super loud. I know. Okay, so maybe I will turn down my 35 for me. So hang on, would that make? So Dave says, oh right, okay. So what I've done, right? What I've done is I've turned down the court audio. So you should be able, mine should come up a little bit better. And mine's increased. Mine's 100%. And the court is now at 40 something. At 40%. Because Josie says, I haven't been able to hear you without my headphones on since your new setup. Everything else you play is super loud. I don't know if that is just me though. So I've reduced. So what I've done is I boosted the audio for court and stuff so loud, and probably mine was lower. So now mine's 100%, and the rest is at 40%. So we'll see if that works or not. Let me play something. Not myself. Let me play something good. Not myself. Hang on. Let me find something here. Right. Can you hear me now? Ba 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 ba. Right. Let me get something. Shit, hang on.
And the way it works is when he died, basically, she took over the entire estate with the directive that everything be sold at some point with no deadline for when anything was going to be sold.
I remember that,
so
right.
There's no one out there, like, for example,
So
if it is...
That's the court. That's the, if that would be the court. How am I now compared to that?
Is you're going to sell the team and you're going to give the money to this
I
person,
should be
like
louder.
charity. So nobody's saying, damn it, sell the team, I want my money. And also, as time goes by, the value keeps up.
Right.
But what we learned over the weekend, courtesy of the Wall Street Journal, is that the NFL, according to the Wall Street Journal, the NFL denies this. The NFL denies it vehemently, and the Wall Street
How
Journal
is my
still
audio,
posts the story, which
Badaza?
tells me they must believe their sources, even though the NFL says they didn't do it.
Can you hear me better now, Badaza? Melissa, if you're in the chat, hello to you. Let me know. Josie, me darling, hot mama, how is this for you? Hey, this way up. You are louder than the court, but that's good. Yeah. Yes, I should be louder than the court. I am. And have my volume all the way up to be able to hear you. Now you are a little louder than though. Now you're a little louder than those Super Bowl guys. But can you still hear, J-Mac, the main thing is, am I still low or am I okay now? Hey, Dave, blue collar. Dave. You're loud but very clear. Yes, so mine is at 100%. I can't go higher. And the desktop one is at 40%. Let me just do it again so you can hear that.
According to the report, the NFL fined the Seahawks $5 million for taking too long to sell the team.
Yeah.
And this is all coming to a head now. It's a storyline now, and we'll see what happens after the Super Bowl. I think that the Seahawks and the league just want to get through the Super Bowl, and we'll worry about it later. But we knew that the Seahawks are going to be for sale at some point. We just didn't know when.
Yeah.
It feels like we're getting closer to the point where it's going to be for sale.
Is there a rule that says they have to sell it in a certain amount of time by the NFL?
Well,
like, how would they be able to levy that fine? And just on top of that, because I want to hear you on both of these, okay, how can they levy?
So Melissa says now the court volume is low. Maybe boost the court volume just a little more. So I've literally taken it down to 40%. So I can definitely increase it. It's not a problem. It's just more of a. Well, let's try that.
Be that fine. And then 2, I just want to go. What was my second point there? For either way,
I'll
just
answer
answer
the
that
first one.
part. Right.
The NFL, and this was in the aftermath of the Titans situation when Bud Adams
So
died,
that's
and
the
he had
difference
3
now between
branches
us.
to the family, and he gave none of them
That's the difference.
control of the team.
So you've heard them, you've heard me. Maybe even if I do, my volume will be higher. So let me know how it is now. I can boost it again. I can boost the court again. I cannot boost me again. I am at maximum. Maximum for me. But how is the court?
They're very
I
insistent
say court, you know what I mean? This friggin' stream.
now that there always be someone who is in absolute control of the team who can show up at the meetings with the votes. As it relates to Paul Allen, the idea that he died and his wishes are the team will be sold.
Right.
The NFL initially
Love
let
it.
the Seahawks continue because there was a clause in their stadium deal that if they had sold the team before May of 2024, 10% of the proceeds would have gone to.
Okay, so for KD, it's fine. Just remember, this is all tweaking because this is a new platform. So it's going to be different for different people. So it's all good. I just want to get it as close as possible for everybody. And just remember, when court's on, I don't normally speak over them. The volumes definitely sound more equal now. But is that better for you, Melissa? Can you hear me now? Because earlier you couldn't hear me at all. So is this better for you, my darling, as well? J-Mac says she wants to give me a thumb. J-Mac wants to thumb me. More than welcome to J-Mac next time I'm in Boston. This is much better. I don't have to keep turning it up and down. Okay, so I need to change it then for Sarah P because I like to annoy Sarah P. Happy days, you can hear me. Yeah, it is a process, and you know what, it's probably gonna be wrong another time. So if it's, you know me, people, if you can't hear or something goes wrong, just let me know and I'll always try and adjust stuff. So currently, right, so does this make a difference? Right, so if I boost this volume for my earpods, does this make a difference? Hang on, let me just do 24 there.
The state of Washington. So the league was like, okay, fine, you can kick the can for 6 years, but now we got to do something here
Gotcha.
because
Is
the
that
man who owned the
louder?
team
Yeah.
died, and his will says sell
Is
the
that-
team.
Right.
We got to sell the team. And probably what's happening is you got potential members of the Billionaire Boys Club constantly knocking on Roger Goodell's door saying,
Because that's a lot louder on my side. Because if it doesn't affect it, I'm going to take it back down because it's really loud on my side. I prefer to have it lower.
and I want to buy a team, and these damn values keep going up. I want to buy it before the value goes through the roof. So I feel like the NFL,
Okay.
has something beyond the sanctity of their policies and
Yeah,
procedures.
gotcha.
They presumably have.
Thank you, Mexi. So, but if I leave it like that, you're all going to be happy.
And that's one of the things I'm trying to chase down for the Sunday pregame show. They presumably have somebody in mind who's going to
That's
swoop
already
in and
on
buy
the
the
line.
team.
What I'm gathering is, Bad Dazza, if I turn my volume up on my end, it will go louder. So technically, if a court is low one day, we can boost it on my end. But for now, it's okay as it is what I go with. Jema says, I love you. I know you do. I love that. Sorry, I know you love that as well. I love that, and I love that you are so kind and try to fix it for your people and don't get angry and refuse to make an adjustment. Well, it depends who asks. If it was you or Sarah P or Jugs or Lady Di, then or Bex or something like that, I would be pissed. I would be like, don't fuck off. But when nice people like Melissa, Rhonda, obviously, you know, all the good people ask me, then I'll do it, you know, so. Right, so if that's okay, then we'll go with that. But if it fucks up again, just let me know, and we can change it again. So we'll leave it as that then. Thank you, J-Mac. J-Mac, you know what you're gonna do to make me love you. You know what you're gonna do. Take it back. Right, let me Right, here we go. No worries, Jugs. Oh, and KD as well. Okay, I take it back. I pay J-Mac to say that. Whatever, you bend over backwards for us. I know. I wish I could bend over more. Right, let's listen to this bitch.
Cruz, you ready for the jury?
Yes, ma'am.
All right, could you bring the jury in? Thank you.
Gotta love a flexible streamer. I know. I got my yoga top on for Tracy. So let's see how it is. If the court volume's too low, let me know, and I can boost the volume. So just remember that. So the jury coming in. So with that, strap her in, strap her on, whichever one you prefer, and we will go. And thank you, Christine Mitchell, for the super chat as well. Oh shit, they got up there now. Why they got up there? Oh, because the jury coming in. Okay. Oh.
Ask that if Mr. Cruz is going to navigate to any portion of the slideshow that has a sensitive image, it's just one slide, that he please let both the media and other people in the courtroom. And then one other thing, Your Honor.
Mr. Cruz, any problem with that?
No, ma'am.
All right, thank you. Go ahead.
I understand, and we will fully comply with the court's instruction regarding cell phones for any interns or anyone we have in the office. I will note for the record, not law enforcement, but Ms. Stephanie Stewart from the district attorney's office is a victim advocate that's here, and we will likely have one other person, our director of victim services, Ms. Ashley Duvall, who may need to use their cell phones in the court.
Okay. Thank you for letting me know. I don't have any problem with that. And actually, I meant to include your staff. I know that they get your witnesses and things of that nature. Mr. Cruz, same for you. If you have other people that you need to assist you in getting witnesses or anything like that, they certainly can have their cell phones. So, but thank you for clarifying. All right. Anything else?
No, Judge.
All right. Thank you. You may bring the jury in.
There you go. So we can all thank Melissa for this. Now, Josie, my hot mama Josie, how is this for you? Because I've got to keep Josie happy, otherwise a grumpy Josie's not a very good time for me. So, as much as I love to piss off Sarah P, I do not like to piss off Josie. So, I hope that works for her as well.
Y'all may be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. And can we, Your Honor, place State's Exhibit 97 on the screen?
Is that your computer?
I believe that may be the State's computer.
Oh, is that your laptop?
I'm lawyer left.
That's why it didn't work. All right, let's try it.
Mr. Cruz, have the computer set. You bet.
Typically, I just stick this in and it pops up.
Okay. I don't know, but you may have a setting set up where you need to drag the window over to Jason's screen.
I've never figured out how to use that. Sure. Oh, I'm lawyer, right? Okay. Oh, from the judge's perspective, that makes sense. That makes sense.
Well, I've got lawyer Wright pressed. Maybe a connection with the computer?
Let's see. Mr. Faust, I could get it under you really quick.
Did you use this before?
Is it to save the court's time and to be respectful of the jurors' time? Can I just have this? If the state is willing, can I just give it to them and they could?
That's up here.
That's not my background. No, sir. Can I just give the exhibits if they're willing? Do you mind? Click.
Not at all.
I don't have any problem if y'all can work it out technologically. It's absolutely fine with me. I only have a couple buttons to press, so I don't know.
Just leave your things set up so you're ready to go.
We'll start at test A.
Sorry, which slide?
Test A. Test A. This one. Which one? Oh, that is no big. This. Do lawyer Wright, Your Honor?
You're lawyer Wright. Got it on podium.
His is not going on.
We could. I was going to say, Your Honor, we could, if it's okay, we could do it during the break. I know the jurors. I need to be very respectful of the time. As under court instructed, I could just do it with the state if they'll play it for me. That's fine.
All right, well, did you all work that out? Are we?
Yes, I
what do
have
we-
no
okay.
problem with that, Judge.
All right, so got it on lawyer left. Mr. Elemental, you want me to put it on podium?
Please, Judge. And just one moment, Your Honor. I just want to make sure that we get to what it is that Mr. Cruz wants before I display it to the jury. So test A, is that correct, Mr. Cruz?
Yes, sir.
All right. It's up.
Engineer Grove, during your examination with the state, they asked you about the HVAC system and the impact it could have when it's on and the impact it could have when it's off. Do you know whether Ms. Baker's do you know if Ms. Baker had an HVAC system?
It appears from the drawings and the tax documents that she did.
Okay. Do you know if it was on or off?
So the night of the fire, I think it was 40 degrees Fahrenheit, the lowest point, and I think by like 8 a.m. it reached 60 or something like that. So one would think it was probably running, but I don't know.
Where exactly was the blanket placed on the bed?
I have no idea.
All right. Next slide, please. Do we know the size of the chenille blanket?
We don't.
Okay. Next slide, please. Do we know how the chenille blanket was placed on the stove?
We don't.
Okay. So these two photos we just looked at, these aren't specific to Ms. Baker's case, is that right?
Yeah, absolutely not. So when we conduct testing in the lab, we always say that we're running tests or experiments. We're not doing reconstructions or recreations. So no, these are specific to our tests. Now, what it shows is that a range of different materials on the high setting on the stove all ignite very readily.
Yes, sir. Next slide, please. I'm sorry, next slide. Okay. And you mentioned that you don't know the position, so we don't know if it was balled up on the stove, is that right?
We don't.
Okay. Next slide, please. Next slide. Okay. Now here I believe there's a test that was conducted in this, is it fair to call it a warehouse?
It's a lab. It's big though. It looks like a warehouse, but it's a lab.
Fair. And when this test was conducted, it was not conducted trying to replicate what would have taken place in Ms. Baker's home as far as space-wise.
Yeah, I would never use the word replicate. We ran tests.
What would be a better word for me to
Tests or experiments.
But this test wasn't, the conditions weren't set up similar to Ms. Baker's home to conduct this particular test. Is that correct?
No, but that's irrelevant. This fire is fuel limited. It's not ventilation limited. So, whether or not we conducted it in this room, in our lab, it's irrelevant.
Fair. Would it be relevant to determining the time that it took for the fire to go through the roof?
Can you be more specific?
Absolutely. And I may say the question wrong. Would the conditions be relevant when you're doing the fire test or the test to determine the time that it took the fire to go from a small fire to a fire through Ms. Baker's roof? Would the conditions be relevant?
Yeah, and if you'll allow me. So
absolutely.
If we were going to run a test on this, and there's reasons we didn't, but if we were going to run a test, we would want as best as possible to get the actual dimensions of the room of origin, the ancillary bathroom and closet, and that includes the footprint, the height. If we had the exact window, we've had cases where we've had fire in an apartment building, so we were able to get windows out of that particular apartment building and test them. So if we had the same window, then we can start to do some tests that are I'll say worthwhile. But because we didn't have the window and there are some other variables, we just relied on past data.
Okay, understood. Test 2 to 4 of the Kingston test involved gasoline use, correct?
Correct.
Ms. Baker's home, we agreed, did not involve any accelerant as far as gasoline.
That's my understanding. I don't think samples were ever taken.
Sure. Slide with the times on it, please.
There are lots of slides.
Each one, the first one, if we could start with that one.
Okay.
And I'd like you to look at your screen for a second. Okay. And I'll be over here and I'll let you. So these times these aren't specific to Ms. Baker's home and the fire in her home, is that right?
No, they're specific to the Kingston test.
So these are Kingston test times, not times relevant to Ms. Baker?
That's correct.
Okay, next slide, please. And these times here, these aren't relevant to Ms. Baker's home. These are relevant to the Kingston test.
I wouldn't say they're not relevant. They're not specific to Ms. Baker's home, so they
use that language.
Yeah.
Please forgive me. Next slide, please. And this time isn't specific to Ms. Baker's home, is that
correct?
Okay. Next slide, please. This time as well is not specific to Ms. Baker's home?
Correct.
Next slide, please. All right. I have no other questions for you. Thank you.
Any redirect, Mr. Yelman-Chile?
I think just one question, Judge. Are the type of fuel and ventilation factors that were present at 160 Fawn Drive the type that could lead to a longer period of time passing before flames come through a roof or observed and called in?
Yeah, I would say they are. It's certainly possible. We did not have a couch or some nice vertical fuels like hanging drapes or something like that to get a really intense fuel-limited fire going very quickly. Ventilation was a huge issue. The hollow core door was, I think it's a hollow core door. The door was closed. The window was believed to be in the shut position. So that's a big issue. When do we get air to support this fire? We don't know anything about an incubation period, if there was one. And certainly a cycling HVAC system can keep a fire alive that would otherwise go out due to lack of ventilation. So, yeah, I think the conditions could support a long duration fire.
Judge, I don't have any other questions.
Mr. Cruz, anything further, sir?
No, ma'am.
All right, thank you. May this witness be excused.
We'd ask that yes, Judge.
Any objection, Mr. Cruz?
No, ma'am.
You may step down and you are excused, sir.
At Exhibit 18.
All right, if you'll put that right there on the end of the desk. Thank you. Could I see counsel to the bench briefly, just for a minute? All right, thank you. All right, Mr. Yelmichli, Mr. Bolden, you may call your next witness.
Karen Williams.
You get Karen Williams, please.
Karen Williams.
Go ahead, Mr. Bolden.
Thank you, Your Honor. Ma'am, if I could get you to raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down, ma'am. Can you start off by stating your name and spelling it for our court reporter, please?
Karen Williams, KarenWilliams.
And Miss Williams, in what town do you currently live?
In Warner Robins, Georgia.
How far away is that?
About 2.5 hours away.
Did you come up to Athens yesterday?
Yes.
Now, Ms. Williams, I want to take you back to 2001. Were you living in Athens at that time?
Yes.
And do you remember the address where you were living?
East Campus, University Apartments, I believe.
Okay. Back then, ma'am, were you married?
Yes.
Who were you married to?
Trey Bryant.
Okay. And so was your name Karen Bryant?
Yes, sir.
Your husband at the time, Trey, what did he do for a living?
He worked for Schumann Wrecker Service, driving a tow truck.
Ms. Williams, I want to ask you to try and remember back to January of 2001. Back then, do you recall talking to the police about an incident that had occurred in Deer Park?
Somewhat.
Okay. And do you actually recall, let me ask you something that happened a little bit more recently. Do you remember speaking with me a couple weeks ago?
Yes.
When I drove down to your house?
Yes.
And after meeting with me, did I send you a copy of a police report as well as an audio recording?
Yes.
Okay. And did you have a chance to review those?
Yes.
Okay. Did reading that report and listening to that audio help refresh your recollection as to the specificity of what you discussed with the police that day?
Somewhat.
Okay. Well, what were you talking to the police about?
On that date, I guess suspicious activity that I believe that was going on early in the morning that just didn't look kind of out of the normal to me.
Okay. What, if anything, and I'm going to ask you to go into a little bit more detail, ma'am, what exactly, let me back up a little bit. Do you recall being with your husband, Trey, your husband at the time, Trey, in Deer Park on the morning of January the 19th, 2001?
Yes.
Okay. And why had you gone there?
I I believe we went to tow a car.
Okay. And what, if anything, did you see? I'm sorry, let me back up once again. Do you remember whether or not you assisted your husband at the time in towing that car?
I don't believe I got out of the tow truck.
Okay. And what, if anything, did you observe when you were sitting in the boat, in the tow truck?
Well, I remember seeing somebody walking past the wrecker, and then I also remember vaguely someone riding a bicycle, but I mostly recall somebody walking through near the wrecker or in front of it.
Okay. Do you recall any description of that individual?
Not at this day. Back then, yes, but to this day.
Okay. And again, having had a chance to listen to that audio that I sent you a few weeks ago, did that help refresh your recollection about the description that you had seen?
Somewhat, yes, sir.
What, if anything, do you remember as you sit here today?
Well, looking at the sketch and stuff, I vaguely remember doing that, but I know that whatever that I had said or done back then was what I remember.
Do you think it might help refresh your recollection again if you were able to listen to the audio one more time?
It could.
Your Honor, can Mr. Cruz and I approach?
You may. Bathroom break. All right, ladies and gentlemen, we're going to take another brief break, and it'll be certainly a bathroom break. There are snacks, of course, in the jury room. Don't discuss the case. We'll be with you in 10 minutes. Thank you. Yes.
Hello, Amy. I just saw you come in. Hello, my darling. Hello, Marky. How are you, sir? Hope you're all well.
Everyone may be seated.
Okay.
Good to go? Okay. For the record, Your Honor, I am going to play what's been marked at this point as State's Exhibit 98
All right.
for Ms. Williams. I don't know if it needs to go to lawyer left.
Wait. Okay.
I apologize.
Probably does.
This is Detective Fitzgerald. I'm at 665 East Campus Road, apartment number 21. The residence of Trey and Karen Bryant. And this is January 22nd at about 1:35 in the afternoon. Karen, what's your date of birth
5/1973.
and your social security number?
254 55 53 68.
And do you work anywhere?
No.
And we spoke earlier on the phone about why we needed to speak to you, and that was because you were riding with your husband last Friday. And can you just start and tell me what happened whenever you got, well, what were you doing, and then what happened afterwards?
We went to pick up a Dodge Stealth. I don't remember the address right off. We arrived there about 8:15.
Do you recall the street that you was on where you picked up the car?
I don't know the name of the street.
You don't know the name of the street. How did you get there?
My husband drive. He got directions from the dispatcher.
Okay. And you were riding with your husband?
Yeah, I was riding with him.
Was he the tow truck driver for?
Mr. Sheeman.
That's a 5.7. Okay. So you was riding with your husband, and do you know the name of the apartment complex y'all went into?
Deer Park.
Okay, but you don't know the name of the street.
This is just Deer Park off Cooper Road.
Okay, now once you turned off of Lexington Road, do you know what street you turned on to there?
Cooper Road.
Okay, but then off of Cooper Road, you don't know which one it was.
It was the first road, I believe, to the right.
Okay, first road to the right. So you went down there to pick up the car.
Yep.
And do you remember what time that you got down there to pick up the car?
About 8:15.
About 8:15. Okay, now once you got there, did you help your husband load up the car, or did you just stay in the truck?
No, I just stayed in the truck.
You got there at 8:15, you stayed in the truck. And what did you see after that?
While he was loading the car, I saw a black male walk from the road that connects right in front of it. He was probably in his late teens, early 20s. And he just walked past the wrecker and kind of looked at the wrecker and just kept walking.
So he come out the street that was just down below you.
Yeah, across
He come out that street and walked towards you and then past the wrecker.
and past the wrecker.
Did you see where he went to after that?
No. I just watched him until I could see him anymore in the mirror. Because I didn't know whether he was going to get the money or something.
What brought his attention to you?
Well, he was walking by himself, and it was about 8:20, somewhere like that in the morning, and it just looked odd in the neighborhood. I mean, he was black, and he was walking by himself, and he was dressed like he had on a bright orange jacket or sweatshirt. He looked wide awake. It didn't look like.
Did you throw a color pants he had on?
I believe they were real baggy blue jeans.
Were they blue, or?
No, just medium blue. I know he had a lot of hair on his head. He had long sideburns. And I believe he had some facial hair on the mouth.
Just like a little scraggly beard or a
Yeah.
full beard?
Like a goatee kind of.
Okay. You used to talk about the hair on his head. So that was kind of long?
Yeah. Bushy.
Wild looking? Or?
Yeah. Like an afro.
Was it like a real big afro?
Not real big.
In the 70s? Or?
Not real big. It was probably 2 or 3 inches off his head.
Was it?
He didn't wear a hat or anything.
Okay. Was it neatly kept, or was it just kind of like?
It looked like it was kind of neat.
Now, you said it was an orange jacket or a sweatshirt?
Yeah, it was bright orange.
Bright orange. Any writing on it or anything like that? Could you see his bare arms?
No. It was cold that day. It was just bright orange jacket. I couldn't tell what he had on underneath. It was cold that day.
Did couldn't see his arms.
He looked about 21, maybe 2 years younger.
How tall do you think he was?
Probably 5'6", 5'7".
How much do you think he weighed?
He was kind of, he wasn't thin and he had a full face. Probably around 220.
Was it kind of husky or?
Much, kind of big bone. Much
Was he kind of being that height and that weight? Was he kind of like lanky or?
in the face. I mean, I couldn't say what he was like under his jacket, but he was kind of heavy. Not real heavy, but he was moisturized. And he was much more stomach as far as I could see.
So he walked past the record.
Walked past the record, looked in the record, kind of just kept walking.
And you watched him out the rearview mirror. You couldn't see him anymore.
Out of the side. Out of the side mirror.
And did he stay on the street the whole time?
The whole time?
Once he got by the record?
Yeah, I seen him. He was walking on the right-hand side of the street.
Well, what about when you first saw him? Was he on the street then?
Yeah, he was on the right side of the street coming to the road. He stayed on the right side. He didn't get in the middle or anything. He just moved from the right to the right side of the road.
Did he put it behind any houses or anything?
But there's a curve and I could also see it just, I noticed him walking probably 50, 75 yards from the stop sign.
And how old again did you say you thought he was?
He's in his late teens, early 20s. He looked too old to be in high school. But not too much older than that.
Was he carrying anything?
No, he didn't have anything.
Did you see anybody else?
That's the only person I seen for morning.
And once your husband loaded up the car you were there to pick up, what did you think?
I'm trying to think whether we went out that road that we seen him walking down or went back out the road again. I think we came back out the road again.
You had to go down and turn around and went back out?
Yeah, I think we actually turned in that road and backed up and went back out the same way. Yeah, I didn't see him.
So when you went back out that way, you didn't see where he had gone to or where he was at that time?
I mean, he wasn't running, but he was walking at a moderate pace.
Wasn't jogging or anything like that?
No, he wasn't driving, but he was walking.
Is there anything else you remember?
The girl next door did well. He picked up his belt. She came home.
Did she say anything to you?
She had just pulled up.
What did she do when she pulled up?
She just went inside the house.
Anything else?
No.
Did you tell what kind of shoes that guy had on?
The pants were real kind of big at bottom.
You said they were kind of like a medium colored blue jeans?
Yeah, medium to dark. Not real dark, but about medium dark.
But the color you have on or darker than that?
It'll be a little bit darker than the blue jeans I have on. But I remember his about that color orange.
That's pretty bright.
Yeah, it was bright. It was bright orange. Yeah.
Didn't see his arms. His arms were covered. Anything else? 25.
You ready for the jury to come back in? All right, very good. Could you have the jury come in, please? You may proceed.
Excuse me. Thank you, Your Honor. Ms. Williams, having had the chance to listen to the audio that we just played, having had the opportunity to do that again, do you have a specific recollection about speaking to the police back on January the 22nd of 2001?
Vaguely.
Vaguely. Is there a particular reason why you may have a hard time recalling your time in Athens, ma'am? Just generally?
It was 25 years ago, and I witnessed some trauma on my own, so there's a lot of things that I don't recall back from 25, 30 years ago.
And would the passage of time and your own particular circumstances make it difficult for you to testify fully and accurately as to what you said back then?
No, not at all. If anything, I would have said or done back.
Well, and let me ask that question again. Would
Do you have an objection, Mr. Cruz?
Ms. Williams, my question is this. As you sit here today, is your ability to fully and accurately recall what you told the police back in January of 2001 affected by the passage of time and what happened then?
Yes.
In the recording that you just listened to, did you recognize your voice on that?
Yes.
And did you give the officer true and accurate information as it might relate to your Social Security number and address?
Of course, yes.
I do have a objection. Leading, Your Honor.
All right. Any response to the objection about leading, Mr. Bolden, before I make a ruling?
I mean, it's a yes-no question. It doesn't prompt her for the answer. I don't think by definition it is a leading question.
I'm going to overrule the objection. You may continue.
Ms. Williams, in that recording, did you give the officer true and accurate information relating to your husband's, at the time, Mr. Bryant's occupation?
Yes.
Ms. Williams, back on January the 22nd of 2001, would your statements to the officer have been fresh in your memory?
Yes.
And would the statements that you provided to the officer have been correct to your best of the best of your ability at that time?
Yes.
And, Your Honor, at this time, I'm going to move to allow States 98 to be played for the jury under OCGA 24-8-8035.
All right. Any objection from the defense?
I would just ask that it's moved into evidence, but otherwise, no.
All right. Thank you. I'll allow you to play it. Can I just see counsel to the bench real briefly?
This fucking judge. Want to see you call the toilet, break the jury. Fucking hell. Rhonda, if Rhonda's still here, Rhonda's getting a new knee in April. So, congratulations and good luck to Rhonda on getting her new knee in April.
Yes. Okay. All right. And so there's an agreement upon admission into evidence. Is that correct? All right. And we just have to see what number that is. I think it's number for the state 97? 98? Okay. So 98 is admitted without objection. .
And we spoke earlier on the phone about why we needed to speak to you, and that was because you were riding with your husband last Friday. And can you just start and tell me what happened whenever you got, or what were you doing, and then what happened afterwards?
We went to pick up a Dodge Stealth. I don't remember the address right off. We arrived there about 8:15.
Do you recall the street that you was on where you picked up the car?
I don't know the name of the street.
You don't know the name of the street. How did you get there?
My husband drive. He got directions from the dispatcher.
Okay. And you were riding with your husband?
Yeah, I was riding with him.
Was he the tow truck driver for
Mr. Sheeman.
the 512? Okay. So you was riding with your husband, and do you know the name of the apartment complex y'all went into?
Deer Park.
Okay, but you don't know the name of the street.
This is just Deer Park off Cooper Road.
Okay, now once you turned off of Lexington Road, do you know what street you turned on to there?
Cooper Road.
Okay, but then off of Cooper Road, you don't know which one it was.
It was the first road on the way to the light.
Okay, first road to the right. So you went down there to pick up a car.
Yep.
And do you remember what time that you got down there to pick up the car?
About 8:15.
About 8:15. Okay, now once you got there, did you help your husband load up the car, or did you just stay in the car?
No, I just stayed in the truck.
You got there at 8:15, you stayed in the truck. And what did you see after that?
While he was loading the car, I saw a black male walk from the road that connects right in front of it. He was probably in his late teens, early 20s. And he just walked past the wrecker and kind of looked at the wrecker and just kept walking.
So he come out the street that was just down below you.
Yeah, across
He come out that street and walked towards you and then past the wrecker.
and past the wrecker.
Did you see where he went to after that?
No. I just watched him until I could see him anymore in the mirror. Because I didn't know whether he was going to get the money or something.
Now what brought his attention to you?
Well, he was walking by himself, and it was about 8:20, somewhere like that in the morning, and it just looked odd in the neighborhood. I mean, he was black, and he was walking by himself, and he was dressed like, you know, a bright orange or a jacket or a sweatshirt. He looked wide awake. It just looked like.
Did you tell what color pants he had on?
I believe they were real baggy blue jeans.
Were they blue or?
No, just medium blue. I know he had a lot of hair on his head. He had long sideburns. And I believe he had some facial hair on the mouth.
Just like a little scraggly beard or a
Yeah.
full beard?
Like a goatee kind of.
Okay. You talk about the hair on his head. So that was kind of long?
Yeah. Bushy.
Wild looking? Or?
Yeah. Like an afro.
Was it real big afro?
Not real
like
big.
In the 70s? Or?
Not real big. It was probably 2 or 3 inches off his head.
Was it,
He didn't wear a hat or anything.
was it neatly kept, or was it just kind of like...
It looked like it was kind of neat.
Now, you said it was an orange jacket or a sweatshirt?
Yeah, it's bright orange.
Bright orange. Any writing on it or anything like that? Could you see his bare arms?
No. It was cold that morning. It was just a bright orange jacket. I couldn't tell what he had on underneath. It was cold that morning.
You couldn't see his arms?
He looked about 21, maybe 2 years younger.
How tall do you think he was?
Probably 5'6".
How much do you think he weighed?
kind of, he wasn't thin and he had a full face. Probably around 220.
Was it kind of husky or?
Much, kind of big bone.
Kind of being that height and that weight, was he kind of like lanky or?
In the face, I mean, I couldn't say what he was like under his jacket, but he was kind of heavy. Not real heavy, but he was moisturized, and he was not much stomach as far as I could see.
And he walked past the wrecker.
Walked past the wrecker, looked in the wrecker, kind of just kept walking.
And you watched him out the rearview mirror. You couldn't see him anymore.
Out of the side mirror.
And did he stay on the street the whole time?
The whole
As
time
he got by the wrecker?
Yeah, I seen him. He was walking on the right-hand side of the street.
And what about when you first saw him? Was he on the street then?
Yeah, he was on the right side of the street coming from the other road. He stayed on the right side. He didn't get the middle. He was just going to the right side of the road.
Did he stay embedded behind any houses or anything?
But there's a curb, and I could say it just, I noticed him walking only 50, 75 yards from the stop sign.
And how old again did you say he probably was?
He's in his late teens, early 20s. He looked too old to be in high school. But not too much older than that.
Was he carrying anything?
No, he didn't have anything.
Did you see anybody else?
That's the only person I've seen for 40.
And once your husband loaded up the car you were there to pick up, what did you think?
I'm trying to think whether we went out that road that we seen him walking down and went back out the way we came. I think we came back out the way we came.
You had to go down and turn around and
On the
go back out?
Yeah, I think we actually turned in that road and backed up and went back out the same way. Yeah, I didn't see him.
So when you went back out that way, you didn't see where he had gone to or where he was at that time?
I mean, he wasn't running, but he was walking at some moderate pace.
Wasn't jogging or anything like that?
No, he wasn't jogging, but he was walking.
Is there anything else you remember?
The girl next door did well. He picked up herself. She came home.
Did she say anything to you? Or?
She had just pulled up.
What did she do when she pulled up?
She just went inside the house.
Anything else?
No.
Can you tell what kind of shoes that guy had on?
The pants were real kind of big at the bottom. I couldn't see.
You said those were kind of like a medium colored blue jeans?
Yeah, medium to dark. Not real dark, but about medium dark.
About the color you have on or darker than that?
It'll be a little bit darker than the blue jeans I have on. But I remember his backpack color orange.
That's pretty bright.
Yeah, it was bright. It was bright orange. Yeah.
Didn't see his arms. His arms were covered. Anything else? I'm going to interview them at about 1:45.
Ms. Williams, Several days after making that statement, do you recall traveling to the Athens Clarke County Police Department to provide a description of the individual that you were referencing in that interview to a forensic sketch artist?
Yes.
You do? I'm sorry, I'm having a hard time.
Yes.
And when I, again, a few weeks ago, provided you with a copy of a police report and that audio that we just listened to, did I also provide you a copy of a police sketch?
Yes.
Did you have an opportunity to look at that?
Yes.
Can I approach your Honor?
May.
This has been marked as State's Exhibit 99. Do you recognize that, ma'am?
Yes.
Okay. What is State's Exhibit 99?
It's a sketch.
By the sketch, do you mean the sketch that you provided to
Yes.
the sketch artist a few days after that interview? we just
Correct.
listened to? State's 99, Your Honor?
Any objection?
No objections, Your Honor.
It is admitted.
And if I can. I'll publish that at this time, Your Honor, if I could use the Elmo. So again, Ms. Williams, this is State's 99 that's just been tendered into evidence. And again, just to be clear, is this the sketch that you, or the sketch based on your description to the sketch artist back on January 27th of 2001?
Yes.
Those are all the questions I have for you, ma'am. Mr. Cruz may have some questions.
Cross-examination, Mr. Cruz.
Good morning, Mr. Bryant.
Good
I'm sorry. Mr. Williams, please read me. Is it Mrs.?
Miss.
Miss Williams? Well, good morning, Miss Williams. My name is Ahmad Cruz. I represent Mr. Edrick Faust. Before we get started, I have water here. Do you need anything?
No, thank you.
Okay. Is it okay if I ask you a couple of questions?
Yes, sir.
Okay. Is it fair to say that you've had opportunity to hear your recording from 25 years ago twice today?
Yes.
Okay. And the state also played it for you before court as well. Is that correct?
Yes.
And to any of the questions that I ask, if you don't know the answer, you could just say, I don't know. Now, this interview with you was conducted on January 22nd, 2001, correct?
Yes.
And they were interviewing you about what you saw on Friday, January 19th, 2001. Is that correct?
Yes.
And we've established that you and your ex-husband, you all were in Deer Park picking up a car, correct? And the street that you all were on was Deer Parkway, correct?
I believe so, yes.
Court's indulgence. Your Honor, I would move pursuant to OCGA Section 24-2 -201B 1 and 2 to admit Defense Exhibit 19. Excuse me, for the Honorable Court to take. Forgive me. For the Honorable Court to take judicial notice of Defense Exhibit 18. It is 19?
Thank you.
May I approach, Your Honor, with the statute as well as the exhibit?
You may.
Just trying to tender it.
Correct. You don't have any?
Okay. Just.
Okay. I don't need the statute. I've got it right here.
Just to be clear, I don't know that's something that judicial notice could be taken of, but I don't have any objection to his exhibit being admitted.
Okay, so let me ask this question, Mr. Cruz. You're asking to tender D-19, but you're asking the court to take judicial notice of it.
I'm marking it as D-19, but I'm asking Honorable.
Okay, and can you give the court an explanation why judicial notice is necessary?
Absolutely. So the statute provides that a judicial, OCGA Section 24-2-201 B 1 and 2, which are relevant. The Honorable Court can choose any one. A judicially noticed fact shall be a fact which is not subject to reasonable dispute, in that it is either 1, generally known within the territorial jurisdiction of the Honorable Court. As the Honorable Court is aware, Your Honor is the most powerful in Clark County. This is your jurisdiction. Deer Park, the neighborhood, is in Clark County, and we've previously admitted D12, and testimony has established that D12 is off of Cooper Road, which is shown in D19. Both parties are undisputed. As Mr. Bowden just stated, he was unopposed to the Honorable Court, or he was unopposed to this photograph. So under 1, we would ask the Honorable Court to take judicial notice. Under B, it is capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Your Honor, you can find this overview as well on Google. So we would say that we meet 24-2-201 B 1 and 2. D provides a court shall take judicial notice if requested by a party and provided with the necessary information. So what we have here, we have the houses, we have the street here, Cooper Road, we have East Meadow Road, we have Deer Parkway, we have Deer Park Drive, and we have Fun Drive. So that's why we're asking for judicial notice, Your Honor.
Mr. Cruz, let me ask you this question. I will admit D19 without objection as a D19, but let me ask you about the issue of your requesting the court take judicial notice. What exactly are you asking the court to take judicial notice of?
Well, I would say this. If the Honorable Court is admitting the exhibit, judicial notice is not an issue.
All right. Then I will just admit the exhibit
Yes, ma'am.
as D19 without objection.
Yes, ma'am.
We
Thank
will
you, Your
not
Honor.
deal with judicial notice.
Yes, ma'am. Thank
Go
you.
ahead, sir.
And I believe the last question I asked you, Ms. Williams, is the street that you all were on was Deer Parkway. Is that correct? Yeah. Okay. And I'd like to show you what has been marked as Defense Exhibit 12 as well as Defense Exhibit 19, if that's okay. On Defense Exhibit 19, do you recognize where you were located on Deer Parkway at the time that you saw the gentleman of the sketch?
No, I wasn't much of a driver back then, so I really didn't pay too much attention to the street names. That was more of my husband.
That's fair.
So I was just,
But would you agree that Deer Parkway is on that map?
yes,
Okay.
yes,
Excellent. Your Honor, I would like to publish D19 to members of the jury.
Granted,
yes.
you want to put it on the overhead? Okay.
Ms. Williams, are you able to see Defense Exhibit 19?
Repeat that, please.
Yes, ma'am. Are you able to see Defense Exhibit 19?
Yes,
And would you agree that this street here that my finger is following, is Deer Parkway?
yes,
Do you recall the location from which street the gentleman was walking from?
no,
The black male that you saw walking, you would agree that he walked past the wrecker?
correct,
Okay, he was not running.
no,
And you watched him walk until you couldn't see him anymore. Is that correct?
correct.
And at no time did you see him running?
Not to my recollection, no.
Let's talk about what he was wearing, okay? The gentleman you saw was wearing a bright orange jacket or sweatshirt?
Correct.
Okay. And how long did you stay in Athens?
Do what, do?
How long did you stay in Athens?
I was born and raised here, so I've been in Athens since '73, and I left Athens 4 years ago.
Okay, excellent. So your whole life, pretty much.
Right.
Would you agree, in Bulldog country, if you're trying to be hidden, you don't wear orange?
Your Honor, I would object to the speculative nature of that question.
We're going to sustain that objection.
Sure. I'll rephrase the question. The gentleman was wearing a bright orange jacket or sweatshirt.
Correct.
Is it fair to say that the bright orange jacket was easily noticeable?
Yes.
Would you have any reason to disagree that you described the jacket as bright as one of the orange stickers that's attached to an electrical cord?
No, it's not like a bright reflective orange. It's like a dull, like really bright, like a running suit type reflective, just a kind of orange.
Are you certain about that?
I believe so. Yes.
And you stated that the person was wearing real baggy, medium colored blue jeans.
Correct.
And because of the jacket that the individual was wearing, you could not see the individual's bare arms. Is that correct?
Correct.
And you would agree while this gentleman walked past the wrecker, he was walking on the right side of the street?
From my recollection from today.
But it's fair to say 25 years ago, you got a good look at this gentleman, right?
25 years ago, yes.
You stated that the black man was around 5'6" or 5'7". Is that correct?
Correct.
You stated that he was not a thin guy. Is that correct?
Excuse me?
You stated that he was not a thin guy.
Correct.
You stated that he had a heavy looking face. Is that correct?
Oh, yes.
And he appeared to weigh around 220 pounds.
Yes.
And he was big boned.
Yes.
Do you recall being asked if he was carrying anything?
I don't recall to this date, but if it was in my statement, you know, reviewing my statements, everything accurate and correct.
Everything is accurate.
Yes.
So if it's not in your statement, that means that did not occur.
I wouldn't.
You wouldn't know?
No, correct.
He was also not wearing a hat, correct?
To the best of my knowledge, no.
So is it fair to say that his face was fully visible?
Correct.
When he walked past your vehicle, he made no effort to not be seen.
No.
He did not change directions when he saw you. Is that correct?
I don't believe so.
And you would agree he was walking at a regular pace?
Correct.
And he was walking on the roadway,
Correct.
which was open and visible.
Correct.
There was nothing, or is it fair to say that there was nothing about his appearance that would prevent recognition?
No. No.
Now, the information you gave in your statement, is that the same information you gave to the sketch artist?
Correct.
Okay. So I have a question for you, and I believe this has been published to the jury. Court's indulgence, Your Honor. All right, so I have a question for you. Do you see how my ears kind of poke out a little bit? At what point in your statement did you describe this individual's ears? Did you hear any description of his ears?
Can't recall.
Okay. In regards to his nose shape, do you recall hearing anything about this individual's nose shape?
I don't recall.
In regards to this individual's eye shape, do you recall saying anything about this individual's eye shape?
Are you saying?
Do you recall stating to law enforcement the person's eye shape?
Oh, yes, of course. All of that. All of that. Yeah, I thought you meant seeing or saying. Yes, I've described all that myself.
So in your statement, you described his eye shape. Mm-hmm. Okay. And, Your Honor, I would like to play State's Exhibit 97. And if you will, Ms. Williams, when we get to the...
99.
Oh, 90. Please forgive me. Ms. Williams, I am going to play what's previously been admitted as State's Exhibit 98. When we get to your description of this individual's ears, when we get to the description of this individual's nose, anyone you hear first. When we get to the description of this individual's lips, when we get to the description of this individual's eyebrows, you just give me a thumbs up, okay? And we'll stop the recording at that point. Is that fair?
Okay.
Okay. Court's indulgence.
So I imagine she never did. So we're going to have to listen to this again, I suppose.
You may.
They've been approached now. Who asked to be approached? I'm not sure. Please. Oh, they muted it, bastards. He said, I've got an objection, the state said. Please like the stream if you haven't done so yet. I would have really appreciate that. Thank you very much. The worry I have is, like yesterday, there were missing evidence yesterday. today, this eyewitness, poor thing, she's not going to remember anything. And it seems like they're just putting everything together here. I'm trying to look at the expressions of the judge, and the state don't want something in. This is their objection. But it was not on the record. Well, it was on the record, but not for us to hear. Just a reminder, this is where Bex lives. So this is basically how she is. I think she's related to the judge and everything. I think this is another example of a cold case that they just grabbed there and gone, right, we need to get this off the shelf. But I don't know, we'll see as it comes in. It's very annoying so far anyway, I know that much. Stop reminding people. Bex literally lives here. I think you live 30 minutes away? How to annoy Bex in a day. That's the game today. As a reminder as well, in case you missed it. It does explain everything about Bex. Just a reminder, there were 3 empty envelopes found yesterday. The envelopes were supposed to contain a pubic hair removed from the victim's buttocks, a hair removed from the victim's torso, and a hair from the left hand of the victim, all of which were missing. As also been said, the hair was for a Caucasian individual.
Actually, Mr. Cruz, Mr. Yamachill, I just thought of something, Mr. Bolden.
And the defendant is not Caucasian, obviously.
That's kind of what we discussed earlier. I don't know if you're playing.
So as a reminder, the envelopes are supposed to contain the pubic hair recovered from the victim's buttocks, a hair recovered from the victim's torso, a hair from the left hand of the victim. And it's supposed to be for a
just for
Caucasian
purposes
individual.
of the record, Ms. Williams, and out of respect, you get some personal information. Is it okay if I started after your personal information? Are you fine with that?
I didn't quite understand.
Sure. Just for respect out of your personal information and for yourself, we're going to start the recording after you give your personal information.
Okay, yes, sir.
Excellent. And again, Ms. Williams, when you hear the first description of anything as far as facial features, just give me the thumbs up and we'll stop the recording, okay?
No.
And we spoke earlier on the phone about why we needed to speak to you, and that was because you were riding with your husband last Friday. And can you just start and tell me what happened whenever you got, or what were you doing, and then what happened afterwards?
We went to pick up a Dodge Stealth. I don't remember the address right off. We arrived there about 8:15.
Do you recall the street that you was on where you picked up the car?
I don't know the name of the street.
I don't know the name of the street. How did you get there?
My husband driver got directions from the dispatcher.
Okay. And you were riding with your husband?
Yeah, I was riding with him.
Was he the tow truck driver for
Mr. Sheeman.
512? Okay. So you was riding with your husband, And do you know the name of the apartment complex y'all went into?
Deer Park.
Okay, but you don't know the name of the streets.
It's just Deer Park off Cooper Road.
Okay, now once you turned off of Lexington Road, do you know what street you turned on to there?
Cooper Road.
Okay, but then off of Cooper Road, you don't know which one it was.
It was the first road I believe to the right.
Okay, first road to the right. So you went down there to pick up a car.
Yep.
And do you remember what time that you got down there to pick up the car?
About 8:15.
About 8:15. Okay, now once you got there, did you help your husband load up the car, or did you just stay in the car?
No, I just stayed in the truck.
You got there at 8:15, you stayed in the truck. And what did you see after that?
While he was loading the car, I saw a black male walk from the road that connects right in front of it. He was probably in his late teens, early 20s. And he just walked past the wrecker and kind of looked at the wrecker and just kept walking.
So he come out the street that was just down below you.
Yeah, across
He come out that street and walked towards you and then past the wrecker.
and past the wrecker.
Did you see where he went to after that?
No. I just watched him until I could see him in the minute. Because I didn't know whether he was going to get the money or something.
What brought his attention to you?
Well, he was walking by himself, and it was about 8:20, somewhere like that in the morning, and it just looked odd in the neighborhood. I mean, he was black, and he was walking by himself, and he was dressed like, a bright orange jacket or sweatshirt. He looked wide awake. It just looked like.
Did you throw a color fancy hat on?
I believe they were real baggy blue jeans.
Let's stop it there for a second. I do have a question I want to go back to you on. Did you hear yourself say he has on a bright orange jacket?
I just heard orange jacket.
Okay, that's fair. Thank you.
I'm a little older. I still can't hear that well, but
That's fair.
Were they blue or?
No, just medium blue. I know he had a lot of hair on his head. He had long sideburns. And I believe he had some facial hair on the mouth.
Just like a little scraggly beard or a
Yeah.
full beard?
Like a goatee kind of.
Okay. You talk about the hair on his head. So that was kind of long,
Yeah. Bushy.
wild looking, or
Yeah. Like an afro.
was it real big afro?
Not real big.
In the 70s, or?
Not real big. It was probably 2 or 3 inches off his head.
Was it?
He didn't wear a hat or anything.
Okay. Was it neatly kept, or was it just kind of like?
It looked like it was kind of neat.
Now so it was an orange jacket or a sweatshirt?
Yeah, it was bright orange.
Bright orange. Any writing on it or anything like that? Could you see his bare arms?
No. It was cold that morning. It was just bright orange jacket. I couldn't tell what he had on underneath. It was cold that morning.
You couldn't see his arms.
He looked about 21. Maybe 2 years younger.
How tall do you think he was?
Probably 5'6".
How much do you think he weighed?
He was he wasn't thin, and he had a full face. Probably around 220.
Was it kind of husky, or?
Much, kind of big bone.
Kind of being that height and that weight, was he kind of like lanky, or?
in the face. I mean, I couldn't see what he was like under his jacket, but he was kind of heavy. Not real heavy, but he was forced right. I mean, it was my stomach as far as I could see.
And he walked past the record.
Walked past the record, looked in the record, kind of just kept walking.
And you watched him out the rearview mirror. You couldn't see him anymore.
Out of the side mirror.
And did he stay on the street the whole time?
The whole
As
time
he got by the record?
Yeah, I seen him. He was walking on the right-hand side of the street.
What about when you first saw him? Was he on the street then?
Yeah, he was on the right side of the street coming from the other road. He stayed on the right side. He didn't get the middle or anything. He just moved from the right to the right side of the road.
Did they put it behind any houses or anything?
But there's a curb, and I could see it. Just I noticed him walking only 50, 75 yards from the stop sign.
And how old again you said you thought he was?
He's in his late teens, early 20s. He looked too old to be in high school. But not too much older than that.
Was he carrying anything?
No, he didn't have anything.
Did you see anybody else?
That's the only person I seen this morning.
And once your husband loaded up the car you were there to pick up, what did you think?
I'm trying to think whether we went out that road that we seen him walking down and went back out the way we came. I think we came back out the way we came.
You had to go down and turn around and go back out?
Yeah, I think we actually turned in that road and backed up and went back out the same way. Yeah, I didn't see him.
So when you went back out that way, you didn't see where he had gone to or where he was at that time?
He wasn't running, but he was walking at a moderate pace.
Wasn't jogging or anything like that?
No, he wasn't jogging, but he was walking.
Is there anything else you can remember?
The girl next door did well. We picked up the cell. She came home.
Did she say anything to you?
She had just pulled up.
What did she do when she pulled up?
She just went inside the house.
Anything else?
You know,
Did you tell what kind of shoes that guy had on?
the pants were real kind of big at the bottom. I couldn't see.
You said those were kind of like a medium colored blue jeans?
Yeah, medium to dark. Not real dark, but about medium dark.
But the
I
color
remember
you
that.
have on or darker than that?
It'll be a little bit darker than the blue jeans I have on. But I remember his back was bright orange.
That's pretty bright.
Yeah, it was bright. It was bright orange. Yeah.
You couldn't see his arms. His arms were covered. Anything else? I'm the interview then at about 1:45.
Okay, Ms. Bryant, but you would agree that the recording is an accurate, I'm sorry, Ms. Williams, you would agree that the recording is an accurate description of what you gave to law enforcement?
Yes, yes.
All right, and we've discussed, I believe we've already agreed that that interview took place on January 22nd, 01. Is that correct?
Yes.
All right, now on court's indulgence. So we have January 19th, it's the day you see the person. Then we have January 22nd, is the day that officers interview you. We've agreed on that. All right. So we would agree that at this point, 3 days have passed since you've last seen this person.
Yes.
Okay. And it probably goes without saying, but this person didn't do anything to you that would make them memorable. Is that right?
No.
4 days after that, which will put us at 7 days, Friday, January 26, 2001, you meet with a sketch artist. Is that correct?
Yes.
Okay. So we could agree that a week has now passed since you've seen this person that's walking.
Correct.
Okay. So I ask you this. Do you believe that you told the sketch artist about this gentleman's forehead and how his forehead was?
At the time, yes. Yes, I believe everything that I said was accurate at that time.
If it was said, correct?
If it was said, yes.
And it may not have been said, is that right?
It's 25 years ago.
That's true. Eyebrows. 7 days, a week later, you... Of course, no. I am sorry. Eyebrows. Do you recall, and I emphasize language recall, Ms. Williams, do you recall giving a description of the individual's eyebrows?
I really don't recall the full description at this date and time.
Okay. And if you don't, you can just say, I don't recall, okay?
Yeah, I don't recall.
How about the bridge area of the nose, which is this area right here?
I don't recall.
Okay. How about the nostrils shapes? Do you recall that?
No, I don't recall.
Okay. Now, you said that the person that you saw had a goatee. Is that right?
A goatee?
Mm-hmm.
Yes.
Okay. Now, I don't have a goatee, right? Okay, you would agree. I'm going to show you what's been marked as State's Exhibit 99. Do you see a goatee?
Not really.
So that answer was a no. Is that correct? Was that a no?
Well, now my husband has a goatee, but it's a different kind of goatee, so I really can't answer that question, Corey.
That's fair. I have no more questions for you. Thank you. Publish. And you're going to publish State's Exhibit 99 to the jury.
You may. Any redirect, Mr. Bolden?
No, Your Honor. I would ask that the witness be excused.
Any objection from defense counsel?
I believe we have under subpoena. I would just ask that she stays on on-call status.
All right. You are free to go if you would just make sure that Mr. Cruz has your contact information and you are on call for this case, but you are free to go for today.
Okay,
Thank you. All right, ladies and gentlemen, it is 12:25. We're going to take a lunch break, and I'm going to explain a couple of things. I do know there is a juror who needs to go to the airport on Friday afternoon. Is that right? Who's the person that needs to go to the airport? Or somebody's leaving to go out of town. Maybe that's it. Okay, there was a car motion. Got it. Okay, we're going to obviously work around that. And so I have ordered lunch for all of you, and I'm going to do that tomorrow and Friday. We're going to take a lunch break, but it's going to be shortened in duration. We want to get in as much of this case as we can before we break for the weekend. We're going to honor whatever plans that juror has. And I think there was another conflict with the juror for that afternoon, Dr. Waller. Okay, so we're certainly going to honor those commitments. So in the interest of time, I've ordered lunch for all of you. So we're going to bring it to you in the jury room. Enjoy your lunch. Please don't discuss the case. If anybody needs to get to their car for any reason, if you'll knock on the door, we'll have a deputy escort you. But other than that, if you'll just stay in the jury room, and we're going to bring you lunch. So go into the jury room if you would. Enjoy your lunch. We're going to be at recess until 10 after 1, so about 45 minutes. Thank you. What's that? We'll have everybody go into the jury room. We'll talk about it. Thank you.
seems is paused. Right, I don't think they come back, no. Okay, so they're coming back in about 15 minutes, I believe. So until then, let's wait here. Right. What's on the menu? You know, I'm having a egg mayonnaise sandwich. We have some really good organic eggs, so I'll be. Oh shit! I'll be doing that for my lunch. But right, before we do anything, let me make it that bigger. Let me get over here. I just got to do one thing here. Sorry. Once I do this, I just got to set something up, and that's why we'll entertain now. Then what I'll do is I'll go and see if there is anything being posted about this on Twitter, because there's a few interested people covering this case now. Originally, I don't think anyone covered it. Now, all of a sudden, I think a lot more people are covering it because I think people are seeing it as interesting. So, we'll do so now. Right. Let me switch. Here. Then I will have. Okay, how do I do this? No, I can't do it that way. Right, I'm going to change this over to here. So let me have a look on Twitter to see what's going on over there. Right, I need to make sure that I got this right then. Okay. Kat Not Williams is also streaming it. She's a few hours behind streaming it. Bad Dazza, what a lad. Bad Dazza shared my stream. What a lad, Bad Dazza. What a great guy Bad Dazza is. If you don't follow Bad Dazza, give him a follow. There he is. Darren Dazza 483. See, give him a follow. What a lad. So, we were supposed to start at 10 a.m. this morning. I had that as well, but... yeah, it's not much on there. So, we'll bring this back. Put this in here again. Right, because Bex is confusing me on everything, let me have a look here. Oh shit, you can't see it. Shit, no wonder, I'm covering the screen. Sorry. Anyway, follow Bad Dazza. Okay. So, trial of man accused of killing UGA law student. There might be some facts and stuff here, so let me make it bigger. I know, I'm not going to say it. Right, 23. Baker's found dead inside their off-campus home in Athens. There are no handprints. Okay. Defense attorney began the rebuttal opening statement shortly before 1 p.m. saying there are no handprints belonging to Mr. Faust. There are no fingerprints. and the state will present to you belonging to Mr. Faust. There is nothing inside the house that the state will be able to present to you to connect Mr. Faust with Ms. Baker's house. He was then found in contempt of and fined $1,000 relating to statements he made to the jury. Okay, well that doesn't really help us. Let me copy and paste this. Thank God, Lady Di's leaving us. Woo! Good. You're supposed to say lurk, Lady Di. Oh, you did as well. You did do it. Yeah, fair play to you. Okay. I'm trying to see exactly. Home tomato soup, nice. I like that. Right, so this is some of the information. So let's go through some of this information, because I'll be honest with you, I'm only been half listening, and now I'm a little bit more engrossed in it. He was Edrick Faust was arrested in 2023 in connection with the death of Tara Baker. Shut Fox 5. No pronouns here. Frigging pronouns. We don't do it. Baker, who was 23 years old, was found dead on January 19, 2001. One day before her 24th birthday. Shit. Baker was last seen by a friend. Okay, we know that bit. Questioning the evidence, Faust attorney suggested as stated. So nothing there again. Sometimes you get I want to see. Sometimes you get a brief summary. Okay. So on April 30th, 2024, the DNA matched. It took DNA, so it was in April 30th, 2024, it matched Edrick Faust. Okay. The defense countered aggressively, telling the jury there is no direct evidence placing Faust at the crime scene. Defense attorneys stressed the absence of fingerprints, eyewitnesses, or contemporaneous links between Faust and the victim. They highlighted that hair found in Baker's hands was Caucasian, so that's one of the missing. That's one of the missing hairs. If you remember, when that witness had to open those envelopes and there were 3 missing hairs, that's one of them. It's saying that the one in the hand was from a Caucasian, not American, African American, and warned jurors against allowing moral judgments against Faust's lifestyle or choices to influence their decisions. Defense counsel also revived scrutiny of Chris Melton. Chris Melton is or was her alleged boyfriend. Whether they were still together or not, I don't know. Baker's boyfriend, Chris Melton, at the time, noting his initial status as a prime suspect, alleged inconsistent statements and visible injuries to his hands, documented shortly after the murders. So he had a lot of injuries to his hands, her boyfriend did. The defense framed the state's case as an attempt to retrofit, I don't know what that means, a suspect to a cold case using DNA alone, urging jurors to focus on reasonable doubt rather than the emotional weight of the crime. Well, from experience, if there's DNA, people will believe DNA, so more likely than not. So that's an uphill battle for the defense. A heated moment unfolded in court when defense attorney Ahmad Cruz was held in contempt and fined $1,000 after prosecution objected twice to comments made during opening statements. Cruz said the comments were not intended to circumvent the statute, rather than to show Chris Melton's consciousness consciousness of guilt. In his conflicting statements, Judge Bitchlot ruled the remarks violated Georgia's RAPE Shield law, known as Rule 412, which limits references to an alleged victim's sexual history without prior court approval. The judge went on to explain that if the defense believes such evidence is relevant, they must file a formal notice and receive court approval before referencing it in front of the jury. So that's why he was found in contempt of court. Let's find out more about this, because this guy, Dave said, was one of the best defense attorneys in Atlanta. The law office of Amadar Cruz. Okay, so he's got his own law. So Beck says, I believe in the DNA. I think they were fooling around. Don't think he ended it. There you go. That's also a way of yeah, that's a good way of looking at that. Excellence in criminal defense. There he is. Attorney profile. So meet attorney Ahmad R. Cruz, a lawyer who works for and with you. What's this about?
I grew up between Atlanta, Georgia, and Albany, Georgia. I was raised by a village, which made me the person I am today. The way I decided to become a lawyer, I would see people get arrested, or I would hear about people getting arrested, and the first thing they would say is, call the lawyer. So I thought lawyers protected people from police, and that's where the initial thought of becoming a lawyer kicked in. And then as I grew up and I learned more about it, I realized that lawyers really help people. And the quality of lawyer that an individual has, they can determine whether innocent person is found guilty, or vice versa, whether a guilty person walks free.
I own and operate an income tax preparation and financial counseling business, and have done for well over 22 years. At the time, I was being basically harassed by the Georgia Department of Revenue. They sent an undercover into my business with fraudulent information for me to prepare a return. And because I did the due diligence on the return and got the individual a refund, I was being accused of fraud. Not only were my ethics being questioned, but I'm a licensed and ordained minister. This affected not only my personal life, but it affected both of my professional lives. I needed my name back. And when I explained that to Ahmad, he was instrumental in making that happen. Ahmad Cruz has got to be one of the South's last gentlemen. Not only did he call to check up on me, but just his interaction with me all throughout the case, ensuring that I understood things, making sure that I was comfortable, putting me at ease at every single opportunity. If someone else found themselves in the same situation, not only would I recommend Ahmad Cruz, I would ensure that I introduce them to Ahmad. I owe him my life.
When individuals are typically charged with crimes, they believe that their life is over, but that is not the case. In the United States of America, we have what's called the presumption of innocence. Until an individual is convicted of a crime or enters into a plea of guilty, they are presumed innocent. One thing we make sure of is that if we're given the opportunity to work on your case, we're going to do everything we can to ensure that this matter is behind you successfully, and you can continue your life, you can continue your course of earning your livelihood, and you can properly restore your reputation in your community. When you hire the law office of Ahmad R. Cruz, my staff and I, we're going to do anything and everything legally and ethically possible to ensure that your matter has the best possible result.
Okay, so there you go. Let's read a little bit about him, because we've got a couple more minutes. When you work with me, let me make it bigger. That's what she said. Right. Oh, I keep gotta stop saying that. Right. Okay. Okay, I don't need... Oh, no, this is not gonna work. when you work with me, you not only work with a knowledgeable attorney, but also an honest advisor, confidant, counsellor, and friend. What sets me apart from other other criminal defense attorneys is that I am completely dedicated to my clients' causes. I represent them the same way I would want to be represented. My law firm believes in doing more than what we are paid to do. We will do everything legally and ethically possible to resolve. Well, he has been in contempt of court, remember, to resolve our clients' matters in their favour as best we can. Further, perhaps what additionally elevates my criminal law firm is the fact that we do not practice in any other areas. We are solely dedicated to criminal defence. Specialising in criminal defence law and representing clients the way I want to be represented is important for several reasons. As firstly, I'm completely dedicated to the specific laws that pertain to my client's criminal charges. Secondly, when one represents clients the way they would want to be represented, they don't mind answering their phone calls and talking with them on nights and weekends. I'm available for direct access for all my clients throughout their cases. And I don't mind going the extra mile. I bet he's got a second phone, though. I bet he's got a second phone. And he will shut it off at some points. I am available for direct access to all my clients throughout their cases. And I don't mind... I don't mind going the extra mile in the investigations, even if that means dedicating my nights and weekends to their defence. If I were charged with a crime, I'd be frightened. If I were facing prison time, I'd be frightened. True story, both of them. So I work as hard as I can to ensure that I'm doing all that is necessary to achieve a successful outcome for my clients. So yeah, I mean, I'd be shit scared. You know, I think we all would be, to be fair. So, it's good. My litigation techniques and successful cases. To prepare for every one of my cases, I read the specific relevant laws, thoroughly investigate all the facts of my clients' situations, start preparing for trial as soon as I receive discovery, talk to the prosecutors early and often, and prepare strong motions to attack the state's case and evidence in as many ways as the law allows. With me, you can trust that I will try my best and tackle every angle of your case, unless you got this bitch of a judge, of course, who will deny everything. One of my most memorable cases is when I represented a prominent young lady who had an extremely complicated and difficult case. She had previously worked with 2 attorneys before she hired my firm. The first attorney withdrew from her case due to the complexity of the matter, and the second attorney took the young lady's matter to trial, which almost resulted in a conviction. The jury voted her guilty 11-1. The single one juror prevented this young lady from going to prison for a very long time. After these results of her trial, her friend referred her to my firm. From there, after an in-depth research of her circumstance, I was able to successfully obtain a dismissal of her case due to a technicality. Oh my god, so she literally... What? She got found, so... She had 11 jurors voted guilty and 1 not guilty, so it was a mistrial, and... Wow, and then he found a loophole, basically, on a technicality to get her off. Another case I'm proud of is defending a young man arrested for trafficking several pounds of drugs he picked up from the Hartsfield-Jackson Airport. The state had a confidential informant who set our clients up via text message, and police conducted a traffic stop on our client's car and discovered the drugs in his vehicle. He was facing a significant amount of prison time, among other penalties. However, my firm was able to attack the state's case and the confidential witness despite the evidence against my client. As a result of our efforts, English is my second language, The state offered our client a heavily reduced sentence of just 3 years probation, 3 years of probation, and a restriction of his criminal record, and he completed probation. Okay, we don't need to go into why criminal law, but okay, so that's a little bit about the defense attorney. Well, one of them. Has he got any more? Alfreda, Cobb County, Fulton County, Marietta, Kennesaw, Roswell, Sandy Springs. Don't know any of them. Results. So there's a few dismissed. Surprisingly, he wasn't able to dismiss this case, considering the fact that literally there's evidence missing from this trial. So I would have thought that he'd be able to get some of that thrown out, but obviously not. Anyway, we have got a little. She said to come back at 10 past 1, I believe. So, am I wrong? No, I'm right. So they've had a good lunch. They've had a fairly decent length lunch. We just got to wait for her to come back in. I'm not sure. Wait. Oh, no one does play. I didn't press play. Press play again. That would have been embarrassing, waiting for the stream to come back, and I had not pressed play. I do think it's now shaping. The trial is shaping a little bit. It's getting a little bit more interesting now than what it was. If you have not watched opening statements, I encourage you to do so. Maybe tomorrow lunchtime or something, we might replay them at like 1.5 speed, because I think it's imperative for you to watch them to understand this trial and understand everything. I said at the time, and I stand by it, I believe that the prosecution did more to try and protect her boyfriend at the time, or ex-boyfriend, depending on how we look at it. And the defense obviously went after him. And there were allegedly, and I missed this is why I need to watch it again, pictures of her ex's hands after the murder. So hang on, let me see if I can do this. Let's see if I can do it. Do it real good. Da, 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 da. So I'm trying to find something. I am.
Truly here, because
okay, hang on. I'm trying to find. This is the defense up here. Okay, now I'm with you. So this is it. This was the hands of Chris. I thought they were her hands. This is Chris's, the boyfriend's hands after. I'm not sure how long before or after. Let's listen to it. Maybe he will tell us.
Mr. Melton's left hand. Death. These are Chris Melton's hands after Miss Baker's death. So Miss Baker was killed on January 19th, 2001.
Okay.
These photos were taken on January 21st.
2 days later. So there you go. So 2 days later, that was the state of the boyfriend's hands. I mean, that does not look good. Let me do a screenshot of that. That is not good, people. Ba ba da ba 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 da ba da ba. You can do me real good. Right, hang on. Let me save it. Downloads. Okay, hang on. Save that. I could take this down. Well, let me get this. Hang on, people. Some people would say I'm slow. I'm not. I'm just... So the knuckles have it. I mean, come on. Look at the state of that. Scratches. What the fuck? I know you can't see too well. Oh, hang on, let me zoom it in. Look at the state of that. Are they going to say that he was going through bramble or something? Or, oh, it's because he uses his hands for work. Bullshit. I mean, I would be very suspicious of that. So, what? I am like, what? Did he do a Colin Albert and fall on ice and catch himself on both sets of knuckles? It's both. Well, it's left is showing, and there's probably one for the right as well. So I will say this then. We'll watch that tomorrow. He had an alibi with his parents, which, well, guilty. Mark says guilty. I don't disagree with you. But unfortunately, he's not standing trial. That's the problem. So he can't be guilty. Right, court's back. Sarah P says, my husband uses his hands all over me all the time. And they have never looked nothing like that. Unless he's been in a fight. Yes, I agree. They are fighting hands. There's some scratches, I would say. Potentially here as well. And here, you can see them. So yeah, his alibi is his parents, which I don't know. I'm not going to obviously condemn him, but I just think that there's more evidence against him there than this defendant. So far, anyway, I know the DNA, but he could have slept.
Y'all may be seated.
I don't know.
Back on the record. Statement calls next witness.
Josh Golden.
Could you get Josh Golden, please?
Okay, well, I'm going to go and get my sandwich now. Once you watch this, but remind me tomorrow, everybody, to show the opening statements again. And I will. If you don't, then...
Sir, if you could raise your right hand, please. You swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can have a seat, sir. Sir, if you could state your name and spell it for our court reporter, please.
It's Joshua Golden, Joshua-Golden.
Mr. Golden, I want to call your attention back to 2000, 2001. Where were you living at that time, sir?
I lived in Deer Park in Athens.
Okay, and do you remember the exact address you were living at?
Yeah, it was 240.
240, would it be 240 Deer Parkway?
Correct.
Okay. Your Honor, can I get the Elma turn?
Yes.
There we go. All right, so... Mr. Golden, this has previously been admitted as State's Exhibit 37. Do you recognize State's Exhibit 37?
Yeah, that looks like the neighborhood when I was there.
Okay. Do you see 240 Deer Parkway in that picture?
I believe this one down here in the bottom.
Okay, I think you can actually touch the screen and circle the address that you're referring to.
I think there was another house next to us that went straight up that road, but I believe that one's the one that's 240.
Okay, and I'm going to ask you to wheel back over and speak into the microphone. I'm not going to, I think your eyes are kind of like mine. I'm not going to ask you to look at the screen anymore. Mr. Golden, do you remember January the 19th of 2001?
Yes.
Do you remember that as the day that there was an arson and murder located in Deer Park?
Yes.
On that day, did you have an opportunity to call the police to make a report to them?
I think it was that day, if I remember correctly.
And I guess what was it that made you aware of the potential to call the police?
Yeah, so that night, my roommate's car had been repossessed. We didn't have auto pay back then, so went out in the morning and he thought his car had been stolen, came in, said, I think my car has been stolen. We did call and try to make a report, and they said it had been repoed that night. So we went and picked it up that day.
Okay. And do you remember what kind of car you drove at the time?
Yeah, I had a white Dodge Stealth.
Okay. And what did your roommate drive?
It was an older blue Honda, and I think it was a Civic.
And so was his Civic in the driveway the night before on the 18th?
Yeah, because I always parked in the parking pad to the right, and he always pulled right into the front, right by the front door where we lived.
And when you woke up the next morning, was his car gone?
Right.
Mr. Golden, those are actually all the questions I have for you, sir. Mr. Cruz may have some questions.
Cross-examination, Mr. Cruz.
Good afternoon, Mr. Golden. My name is Ahmad Cruz, and I have the privilege and honor of representing Mr. Edrick Faust. Is it okay if I ask you a couple of questions? Sure. I'd like to show you what's been marked as Defense Exhibit 13. Do you see your house on that exhibit?
I think it would be this one right here.
Okay. And I am going to give you a marker, and I am going to allow you to mark your home on this physical exhibit. Is that okay?
Okay.
Your Honor, I don't know that that's appropriate.
I agree with that.
I'd like to show you what's been marked as Defense Exhibit 14. Can you see Defense Exhibit 14 clearly?
Yes.
Okay. And would you agree that in the top right, that is the Deer Park community where my finger is located?
As far as I can tell, yes.
And I can show you different angles. Course indulgence.
I mean, yeah, that looks like the Deer Park. You talking back here in this area here?
Can you show me where on this you're stating was the Deer Park area?
That looks like Deer Park there.
Okay, excellent. And what is this right here? Is this the Walmart on Lexington Road?
I would imagine, yeah.
Okay, thank you. And I'd also like to show you what's been marked. That's Defense Exhibit 15. And you'd agree that this area right here is a different angle of the Deer Park?
Correct.
And this area here would be the Walmart parking lot? Okay. Do you remember foot traffic in Deer Park, walking through Deer Park to go to that Walmart?
I don't remember there being much. I mean, I don't remember.
Okay, that's fair. Those are all my questions for you. Thank you so much.
Okay.
Any redirect?
No, Your Honor, I'd ask that Mr. Golden be excused.
Any objection from Mr. Cruz?
No, ma'am.
You are free to go, sir. You may call your next witness.
Tiffany Schroeder.
Could you get Tiffany Schroeder?
Ma'am, if you could raise your right hand, please. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. And just, I had a hard time hearing you, and if I'm having a hard time, some of our jurors might as well. So if you could just speak loudly into that microphone.
Okay.
Can you state your name and spell it for our court reporter, please?
Tiffany Schroeder, Tiffany, last name Schroeder.
Ms. Schroeder, back in January of 2001, were you living in Athens?
Yes,
And what were you doing in Athens at the time?
I was a student.
Where in Athens did you live?
I lived in Deer Park,
Remember the address?
415.
I'm going to show you, this has already been put into evidence as State's Exhibit 37. Do you recognize that as kind of an overhead view of the Deer Park subdivision?
Yes.
And can you point out, so the screen that's down there to your right, you can actually touch it and make a circle. And I'm going to ask you to put a circle over what house was 415 Deer Park Drive. Okay, so is that where you were living in January of 2001?
Yes.
Do you recall on January the 19th of 2001 there being an incident to include a fire or an arson and a murder in the neighborhood?
Yes.
And the day of that incident, do you recall talking to law enforcement about part of your day?
Yes.
What, if anything, do you remember about the early morning hours of January the 19th, 2001?
I was leaving for class in the morning between 8:30, and saw a young gentleman walking down our street right near our driveway.
When you say walking down our street, which direction was he coming from? And again, I think you could just kind of draw a line on the screen. So that'd be heading down towards the stop sign here. Is that, am I getting that right?
Yes.
What were you doing at the time that you encountered this individual?
Walking to my car, putting my stuff in the car to leave.
Okay. And as you were leaving the driveway, did you describe the encounter that you had with this individual?
Yep. I was just walking towards my car, opening the door, and he was walking in my direction towards my driveway. Saw each other. I continued to get into my car and then proceeded to wait for him to pass my driveway so that I could back out.
Okay. About how long did this encounter last?
Probably 20 to 30 seconds.
Can you describe, if you can recall here today, can you describe in general what this individual looked like?
Yes. Younger African American man wearing jeans, either a red or orange hoodie, medium complexion, clean.
Do you remember anything else about his description here today?
His hair was of shorter to medium length.
Okay. About how long did you have a chance to view him? Did I ask that already? I'm sorry.
You asked about the encounter, but in terms of viewing him, it was probably close to 20 seconds.
At the time, was there anything unusual about that encounter?
I would just say the time of day to see somebody walking through the neighborhood, considering the earlier hours and the weather. Don't usually see people walking at that time when I'm leaving for class.
Were you aware of individuals using Deer Park as a cut through to the Walmart?
Yes.
Was it after you learned of the arson and murder at 160 Fawn Drive that you had an occasion to speak with officers about that individual who you encountered?
Yes, it was later that day, towards the evening.
And at some point later, did you agree to meet with a forensic sketch artist and provide a description of the individual that you had encountered to that person?
Yes.
Let's see, what number are we on?
99.
If I can approach the witness, Your Honor.
May.
Schroeder, I'm going to show you what I marked as State's Exhibit 100. Do you recognize this?
Yes.
What is State's 100?
That is the sketch that I did with the forensic artist.
And, I moved to tender State's 100, Your Honor.
Any objection?
No, ma'am.
It is admitted.
If I can publish that to the jury.
May.
And, Your Honor, would it be possible to clear the screen? Ms. Schroeder, again, State's 100. Is this the sketch that you, I guess, describe, or the sketch that was rendered based on your description to the sketch artist?
Yes.
And at the time, did you believe that that sketch represented the individual that you had encountered on your driveway at 415 Deer Parkway to the best of your ability?
Yes.
And as you sit here today, do you have any thoughts about how accurate that description would have been?
It would be just as accurate.
Today?
Yes.
Ms. Schroeder, those are all the questions that I have, ma'am. Mr. Cruz may have some questions. Thank you.
Cross-examination.
Yes, ma'am. Good afternoon, Ms. Schroeder.
Afternoon.
My name is Ahmad Cruz. I represent Mr. Edrick Faust. Is it okay if I ask you a couple of questions?
Yes.
Before testifying today, did you meet with the state?
I met with the DA assistant over the phone in regards to being here.
Did you hear your audio recording from 20 years ago?
No.
So as you sit here today, you're not sure if that sketch is accurate, or are you sure, regardless?
I'm sure that that is the sketch that I did
Okay.
at the station, yes.
Okay. And are you sure that that sketch matches the description that you gave law enforcement?
Yes.
Court's indulgence. Do you deny today telling law enforcement that the individual you saw walking was nondescript? Do you deny that statement?
I don't deny that statement in the context that the person I saw seemed average looking.
And when you say average looking, what do you mean by that?
I mean, no specific physical features that stood out wildly, like colored hair or unusual clothing or anything like that.
Sure. So nondescript didn't mean his physical features. Nondescript meant no colored hair, no wild clothing, things of that nature.
Correct.
Okay. I'd like to ask you a couple of questions about that, okay?
Sure.
And may I approach?
Sure. Okay. Okay.
Based on that photo, can you tell the jury how you describe that individual's facial hair?
How I described the facial hair?
Correct. And you can just go off the photo. If that photo is correct, how would you describe the facial hair? Is it a full beard? Is it
Little to none.
okay, little to none. How would you describe that individual's nose?
I guess wide.
How would you describe that individual's eyes?
Dark eyes, wider set.
How would you describe that individual's lips?
Full.
And that individual's face. How would you describe the facial shape?
The facial shape, I would say squared oval.
All right, I just want to make sure I have this correct. So the description that we have, wider set eyes, dark eyes, wide nose, full lipped, square oval facial shape. Forehead. How did you describe the forehead?
Average size and width.
The shape of his eyes. How would you describe the shape of his eyes?
Almond.
And do you see this cheekbone structure on that, the individual in the sketch?
Yes.
Okay, how would you describe the cheekbone structure?
I would describe it on the higher side of cheekbones.
And would this have been the description you gave to law enforcement on the date that they came to speak with you?
It would have been similar, yes.
Your Honor, I would move to introduce the defense exhibit. And I am going to give Your Honor particular timestamps. Court's indulgence. Just to be clear, you do recall meeting with law enforcement on January 19, 2001, is that right?
Female law enforcement at the time of the sketch?
Not at the time of the sketch, on January 19th, the day that you actually saw the person. Do you recall meeting with law enforcement on that day?
Meeting with law enforcement? Yes.
And giving a statement to law enforcement on that day?
Yes.
I think I said this wrong. I think I said the day you saw the sketch. The day you saw the person. The same day you saw the person. Do you remember meeting with law enforcement on that day?
Yes.
Okay, thank you.
Mm-hmm.
All right, Sharon, let the record reflect that I am going to start this video at minute mark 12 minutes and 5 seconds.
I object to something being played that hasn't been tendered into evidence.
I mean, I agree with that.
Oh, please forgive me, Your Honor. Okay. Please forgive me. Ms. Riker, have you had opportunity to hear your interview?
The interview that day?
Correct.
I have not heard it, nor did I know it was a recorded interview.
Sure, that's fair. That is fair. You would recognize the interview if you heard it, though, right? You would recognize your voice, your name, where you stayed?
Maybe.
Your Honor, I would like to play the recording for the witness outside the presence of the jury, if I may. For foundation purposes, Your Honor.
All right, can I see counsel at the bench, please?
You don't remember exactly what you said in the interview, is that correct?
To some degree, I remember.
Okay.
What I remember is being asked as I came home and the GBI was canvassing the neighborhood.
Okay.
And they asked me questions in my car.
Sure, that's fair. Do you remember everything that you stated in that interview?
For the most part, yes.
You do?
Mm-hmm.
Okay. And your statements were that he had wider set eyes, dark eyes, wide nose, full lips, squared oval facial.
I object, Your Honor. That's a mischaracterization of what her testimony just was.
I'm going to sustain that objection. I will allow you to rephrase your question.
Sure.
I think that's correct.
Sure.
But you may rephrase.
Sure. Is it fair to say that you stated that the individual had wide set eyes?
I don't think I was asked those specific questions at that time.
Okay. So on January 19th, that is not the description you gave?
Not to that level of detail, no.
Okay. I'd like to go through the items we discussed today. If you think that wasn't something you said on the 19th, just let me know, okay? Is that fair?
Sure.
Okay. We've agreed that wider set eyes, you didn't give that level of detail on the 19th. Do we agree there?
I don't remember which of those details they may have asked me about at that time or not.
Sure. Would hearing your recording refresh your recollection?
I don't know.
Okay. Would hearing it let you know if you would know if it would refresh your recollection?
I'm not sure.
Okay. If I play it for you, will it refresh your recollection?
Possibly.
Your Honor, I would ask to refresh this witness's recollection outside the presence of the jury.
All right. Any objection to the statement? All right. Ladies and gentlemen, I'll have you go into the jury room. Don't discuss the case. We'll be with you shortly. Y'all may be seated. Go ahead, Mr. Cruz.
Thank you. And I want to make sure I address you appropriately. Is Miss your last name?
Schroeder.
Ms. Schroeder, yes, ma'am. And for purposes of the record, this is a CD that contains multiple interviews provided in the state's discovery. Ms. Schroeder's timestamp on this CD is 12 minutes and 5 seconds. Until 15 minutes and 38 seconds. Ms. Schroeder, if you would, please.
Again, Mr. Cruz, if you would. Yeah, Mr. Cruz, let me ask you this question. Are you able to play it on your computer for the witness?
Absolutely.
Okay, so you can bring your computer over to the witness table and play it that way. It's not anything that's going to be transcribed. This is for witness recollection, so you can do that.
All right, Ms. Wright, I'm going to play this for you.
Somebody robbed the place at 5 o'clock. Because they never let him say it.
that?
It's very muffly from here. Yeah, it's not very clear.
Judge, can we just have the laptop closer to the witness, I think is what the court was suggesting. Well, that,
I think, Mr. Cruz, you can play it for the witness at the witness stand. It doesn't need to be transcribed, and it's to refresh her recollection, so you can play it for her at the witness stand. Thank you.
I left at 8:15 to go to class.
Okay. Now you said you saw somebody outside or just walking through. Can you just kind of explain what you saw through this?
Yeah, I was walking to my car and I saw African American gentleman walking down my road towards my house. In fact, he actually had to stop walking so that I could pull out of my driveway.
Okay. Now you live right here.
Mm-hmm.
And was he on the road?
No, he was coming down this way.
Okay.
Like from the entrance to the neighborhood.
Okay.
Towards this way.
So he was down that far end road down there.
So and technically he was walking down Deer Park Drive.
Okay.
Basically. And I don't know, he was just kind of, he's kind of nondescript. He wasn't tall, wasn't short, wasn't, large guy or small guy. The only thing I remember, he was wearing like an orange colored shirt, orange or red, something bright.
Do you know if he was wearing a hat or anything?
No, he wasn't wearing a hat.
Now, do you remember what kind of pants he was wearing by any chance?
I don't remember what color. They were just like kind of baggy, not like fitted. I want to say jeans, but I could be wrong.
Okay. That's fine.
They definitely were. I don't think they were a dark color. They were either like a khaki or denim type.
Lighter color, not so dark. Okay. Is there any reason in particular that you remember? You see folks walking a good bit of time. Is there any reason that it stuck out this morning, or is it just because we're asking, or is there?
It kind of stuck out because I was surprised that somebody would be kind of just strolling through that early in the morning. I mean, I've seen people walking through the neighborhood before,
right,
but not at that particular time of day.
Many folks walk or jog or anything out here. Is it usually pretty?
Yeah, the students that live here usually.
In the morning, or is it usually in the evening?
More so in the evening. I've seen people in the morning, but today was kind of weird because it was kind of rainy, so it wouldn't have been a day for them to do that, really. In my mind, I assumed that maybe he was cutting through to go to Walmart. That's
pretty normal.
Yeah, I mean, I didn't know what he was doing, but I was like, oh, well, maybe he's just cutting through.
He might have been. We don't know.
Right.
Was anybody else home this morning, or would have been here, a roommate, or anybody else?
When I left, you were here. I was here until 9 a.m. When I was doctor's appointment, I was back at 11 a.m.
Did you see anything coming in or out, or?
No, sir. I didn't see anything unusual. I was here until 2:30.
What's your last name?
Yes.
Did that refresh your recollection of your statements from January 19, 2001?
Yes.
All right, you can bring the jury back in.
So, Ms. Riker, you've had opportunity to hear your statement. Is that correct?
Yes.
Okay. And that statement refreshed your recollection. Is that correct?
Yes.
Okay. And is it true on January 19, 2001, you did not hear yourself in that statement give a physical, facial description of the individual that you saw walking? Is that fair to say?
That's fair.
Now, you mentioned that you gave a sketch to a sketch artist, right?
Yes.
And you mentioned when you were speaking with the state that you saw this individual for about 20 seconds. Is that right?
Yes, 20 to 30 seconds, yes.
Okay. You were on your way to class. Is that fair to say?
Yes.
Okay. And I'm assuming it's maybe more than 10 people in your class. You probably saw more than 10 people that day?
No.
No? Okay. But you met with a sketch artist on Friday, January 26th. Would you agree with that statement?
I don't know if it was that date specifically.
Sure. Would seeing the sketch artist's notes refresh your recollection?
Possibly.
And I still have free reign, Your Honor?
Yes.
I'm seeing the second paragraph, but I don't see my name there.
So that doesn't refresh your recollection?
No.
But you do recall on some date meeting with a sketch artist?
Yes.
Okay, you don't know at this time what date that is.
It was around that time. I don't remember the specific date.
That is fair. Now let's talk about what you did discuss on the 19th, if that's okay. In your statement on January 19th, you stated that you saw an African-American male walking down the street. Is that correct?
Yes.
Okay. He was walking in the direction from the entrance towards your home.
Correct.
While walking, the male actually stopped so you could pull your car out the driveway.
He had to stop walking one way or the other because he saw that I was backing out.
Just to make sure we're clear on that we're on the same page. While walking, the gentleman had to stop so you could pull out of the driveway.
Yes, but I don't remember whether he stopped and then I stopped so that he could keep walking, or if he just stopped.
Your Honor, I would move to introduce Defense Exhibit 20 into evidence, minute mark 1309 through minute mark 1313.
I object on, this is not an inconsistent statement, Your Honor.
Well,
I have case law for the Honorable Court if you would like it.
well, at this point, first I'd like counsel to explain what he is asking to tender, and then we'll go from there.
I am asking to tender Ms. Schroeder's January 19th, 2001 interview, recorded interview, minute mark 1319 and 1313 for impeachment purposes. Ms. Schroeder.
All right. Okay, hang on just a moment. Based on that request, Mr. Bolden, do you have an objection?
I do object.
Okay.
Because I do not believe that Ms. Schroeder has testified to anything inconsistent with what her statement was that the court just heard. So.
All right. Mr. Cruz, do you care to respond to that response?
I do.
Go ahead.
My question is an exact quote. I asked while walking, and I'll say the quote part. Did the male, and this is the quote part, stop walking so that she could pull out of her driveway? If the Honorable Court would allow me to play the audio, I do not want to put evidence on the record. That is not a yes or no. I didn't receive a yes or no to that. I received the answer that was different from the question I asked. To be respectful to the witness, what I understand the appropriate procedure, if it differs from what's in the evidence, at that time I would just move to tender the evidence.
Okay, I agree with the state on their recognition of what the law requires to admit evidence that the proponent believes is an inconsistent statement, but I will allow you, of course, to continue cross-examining this witness.
Yes, ma'am, but not to impeach, Your Honor?
I
just want to make sure I'm clear.
I'm sustaining the objection
Understood.
that Mr. Bolden made to the introduction of that particular exhibit.
Understood. So I just want, and you could, if possible, you could just give me a yes or no. In your January 19th statement, did you tell law enforcement that the male had to stop walking so you could pull, and I'll say the quote, so that I could pull out of my driveway?
Yes, I said he had to stop. Yes, I did say that.
You don't recall that individual wearing a hat, do you?
I do not recall a hat, no.
So it's fair to say that his face was fully visible?
Yes,
Okay. And when he stopped for your vehicle, he made no effort not to be seen. Is that correct?
he made no effort not to be seen.
He did not change directions when he saw you?
Not to my knowledge, no.
And he was walking at a regular pace. Is that fair to say?
Yes, that's fair.
He was walking on the roadway, which was open and visible?
Yes,
And you would agree, and I just want to make sure we're clear. Now, this individual was wearing a bright shirt. Is that right?
yes, either orange or red, yes.
But it was a shirt. Is that correct?
Hoodie, shirt, sweatshirt.
We have to be specific. Was it a hoodie or a shirt, or you don't know?
If you're asking me, I would say it was a hoodie.
Your Honor, I would move to introduce Defense Exhibit 20, minute mark 1355 through 1402.
On what grounds, Mr. Cruz?
Prior inconsistent statement.
All right, Mr. Bolden, or Mr. Almanchili, any objection?
Again, Your Honor, I don't know that there's been anything inconsistent today. You said that-
If you'll speak into that microphone, Mr. Bolden.
Sorry, Your Honor. I don't know that the proper foundation has been laid once again, so I would object.
I'm going to sustain that objection. The proper foundation needs to be laid.
Judge, I have a motion outside the presence of the jury.
All right. Ladies and gentlemen, if you'll go into the jury room, and please don't talk about the case. Thank you.
This is now getting ridiculous. This is now getting ridiculous. Just play the fucking thing. I'm getting really pissed off for this. Why are you hiding stuff? The foundation is laid. What the fuck else are you supposed to do?
Sir, you all may be seated. Yes, sir.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We can't argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia. He doesn't stand a chance in this courtroom, Your Honor. The witness made a prior statement. We played the recording for the court. The witness made a prior statement. He was wearing like an orange-colored shirt, orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. Faust. The person that they brought, the first witness in for, said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you. Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I don't necessarily think I have to make a response.
All right. Thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. You know, it is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, you know, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say, for the record, in this particular moment, that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of the question allowed this witness, at least in my impression, to sort of pick, was it sort of a shirt or was it a hoodie? And the testimony, as I heard it, was that she elected to sort of describe it as a hoodie. If you would like to make an argument that that in and of itself is what the law says is an inconsistent statement under the evidence code, then I will hear it. But if not, I'm going to sustain the objection and ask you to move on, sir. You may be heard, yes. And then I'll talk about the mistrial in just a moment, but go ahead.
If the court has the statute, just send me a little time. Pull on the statute now, if that's okay. But if you have it readily available.
Well, I mean, Mr. Cruz, I'm not going to advise you on the law. And I think you need to be here prepared to argue it.
No, I just said if you had a copy of the statute, I was just trying to save them before some time, but I'll pull it up here.
The judge has been very petty. It was inconsistent what she said. She said it was a hoodie. He's saying, well, is it not a shirt? It's very important in the defense case. So she knows exactly what's happening. She knows that it's impeachment, and she's just trying to be really awkward about it all. Hello, Robin G, by the way. Hello, Jay McGee. McGee.
The statute is OCGA 24-6-613. Prior statement of witness is the title of that section. Under subsection A, the law provides, in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I have. They heard the entire statement. Subsection B provides, except as provided in Code Section 24-806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did. I said, Your Honor, this is a quote. I read the statement as a quote. She said it was a hoodie. I confronted her with the statement, gave her opportunity. She still chose to say this was a hoodie. Second, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement. The state will have opportunity to examine her on the prior inconsistent statement.
Mr. Cruz, what is the statement you're saying is inconsistent with this witness's testimony?
Sure.
I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked, the individual that she saw walking, did she state he was wearing like an orange-colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. And you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say, a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange-colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right. And, Mr. Cruz, I want to comment on your motion for mistrial.
Sure.
I'm going to deny that motion. The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option. And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion. All right. Can you bring the jury in, please? Thank you. You all may be seated. You may continue, Mr. Cruz.
Thank you, Your Honor. On January 19, 2001, you told law enforcement in your statement he was wearing like an orange-colored shirt, orange or red, something bright. Is that correct?
Yes, that's what I said. But I describe shirt as all-encompassing. I haven't had a chance to say that, but had the officer asked me, was it a T-shirt or a sweatshirt, I probably would have been more specific. But to me, a shirt, is a hoodie, sweatshirt, any of the above.
And that's your memory 25 years?
Yeah.
You stated that his pants were baggy fitted, lighter color khaki or denim jeans. Is that correct?
That is what I said in the recording, yes.
And this individual had about an inch of hair on his head.
To my best of recollection, that is how I described it, yes.
When you were asked by law enforcement what this individual looked like, your response was, I don't know. He was just kind of, he wasn't, well, he's kind of nondescript. Is that correct?
That is what the recording said, yes.
You stated that, let me put it this way. Would you agree that you did not tell law enforcement whether or not he had facial hair?
I was not asked that question.
You would agree that you did not tell law enforcement the shape of his eyes?
I was not asked that question.
You would agree that you don't remember telling law enforcement the distance between his eyes?
I was not asked that question.
You would agree that you do not remember his lip or nose shape?
I was not asked that question on January 19th, no.
Okay. And you would agree that you did not tell law enforcement his facial cheekbone structure?
I don't believe I was asked those details on January 19th.
Yes, ma'am. People walking through Deer Park to go to Walmart was pretty normal. Is that correct?
Yes, that's correct.
And you told law enforcement the person that you saw, you assumed he was walking, going to Walmart. Is that correct?
That was the thought I had, yes.
Is it fair to say that the gentleman may have been going to Walmart?
Sure.
Your Honor, I would still move to tender Defense Exhibit 20 into evidence as a prior inconsistent statement.
All right, I'm going to, is there any further discussion about that?
No, Your Honor.
Okay, I'm going to I'm going to sustain the objection. I'm not going to allow you to admit that particular exhibit.
Yes, ma'am.
Anything further, sir?
No, ma'am.
All right. Any redirect of this witness, Mr. Bolden?
Briefly. Ms. Schroeder, do you remember what the weather was like that day?
Yes.
What was it?
It was kind of foggy, misty, a lot like it was this morning.
Another thing, so you just mentioned on cross-examination about questions that you weren't asked on the 19th as it relates to specific facial characteristics.
Correct. Yep.
Were you asked those kind of questions when you met with the sketch artist?
Yes.
That's all I have.
Any further cross-examination, Mr. Cruz?
Question don't.
Are you looking for this? Mm-hmm. That is an accurate depiction of how I described the person I saw to the sketch artist.
So this is accurate.
To my knowledge, yes.
Anything further, Mr. Bolden, of this witness?
No, Your Honor.
May she be excused.
I'd ask that she be excused.
Mr. Cruz, any objection?
Did you receive a subpoena from our office?
Yes.
Okay. I'd ask that she be held on that subpoena, Your Honor. Just on call. On call.
All right. You are still under subpoena from the defense. You are free to go.
Okay.
You may call your next witness.
Call Matt Owens.
Could you get Matt Owens, please?
Do you swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? You can have a seat, please. And sir, if you could state and spell your name for our court reporter.
Matthew Owens, Mattheowens.
And sir, back in 2000, 2001, where were you living at the time?
147 Vaughn Drive.
Okay. Your Honor, if we could have the Elmo.
All right. Takes a minute.
All right. Mr. Owens, this has been admitted into evidence as State's Exhibit 37. Do you recognize that to be an overhead view of Deer Park subdivision?
I do.
Okay. And you can actually touch the screen down there to your right. If you can, do you recognize what 147, where it is?
I believe it would have been here.
Your Honor, I think you might have to turn the
I think it is on.
Sorry.
It is on.
Oh, I'm sorry. Oh, is it a dot? I can't see that far. Okay. Gotcha. Could you make a circle just because I really can't see that? Okay. Thank you, sir. Back in 2000-2001, who were you living at 147 Fawn Drive with?
We had several roommates. Jay Anderson was one of the roommates. Reynolds McLean. I'm trying to recall who, people were moving in and out at that time. Gabe Norris, and I can't recall the fourth.
Do you recall the day when the house across the street, 160 Fawn Drive, was set on fire and there was a body discovered?
I do.
Was there anything about that morning that struck you as odd, sir?
When I left for work that morning, I stepped into the driveway to get into the car and could smell smoke. It smelled like a house fire.
You recall what time that was?
It was about 8:40 to 8:45.
And was there, you recall what the weather was like that day?
It was overcast, sort of foggy, misty, kind of like today.
And so that was on your way to work, is that what I understood?
Yes, sir.
Back on the day of, on January the 19th, 2001, did you talk to law enforcement?
I did in the afternoon when I got home from work.
And did you describe what you had smelled on your way to work that morning?
I did.
You mention anything else of significance at that time?
No.
Okay. A couple of years ago, did you have a chance to talk to law enforcement again about the case?
Yes, GBI came to visit me at my home.
And at that time, did you have additional information to share with them about the morning of the 19th?
We spoke that occasion, and what I relayed to them, aside from what I noticed when I was leaving, was that earlier that morning when I was getting ready for work, we'd seen someone walking down the street and on Fawn Drive coming towards our house.
And who was it that alerted you to that?
One of my roommates, I believe it was Reynolds.
And at the time, when you spoke to law enforcement back in 2024, when the GBI talked to you, were you able to recall a description of that individual at that time?
Yes, the description of the individual was, probably.
Yes.
I just want to make sure I'm clear. Is hearsay if he's asking him to give a description that somebody else gave him?
Mr. Bolton, do you want to clarify your question?
I think I was asking him to describe the description that he gave to law enforcement.
Okay. Any objection to that, Mr. Cruz?
That's the question, no.
All right. Go ahead, sir.
Okay.
You can continue, Mr. Owens.
The individual was, probably early 20s, black male, maybe 5'10" to 6 foot, average height, average build.
You recall anything about the individual's clothing or providing that description to law enforcement at the time?
At the time, I stated that they were wearing, I believe I told them it was a white T-shirt and jeans.
Here today, do you believe that's still the case, or are you sure?
Today, I would have difficulty to say with certainty after 25 years that that's what the person was wearing, but the person's physical description I'm certain of.
Mr. Owens, those are all the questions I have for you, sir. I am sure Mr. Cruz will have some. Thank you.
Thank you.
Cross-examination, Mr. Cruz.
Thank you so much for your time today. I don't have any questions for you, Mr. Owens.
May this witness be excused.
I'd ask that he be excused, Your Honor.
Any objection from the defense?
No, ma'am.
You are free to go, sir.
Thank you.
You may call your next witness.
Judge, can we have a brief recess?
Yes. 10 minutes?
Perfect.
All right. We're going to take one more restroom break. 10 minutes. If you'll go into the jury room, please don't discuss the case. We'll see you all shortly. Thank you.
I can never get the hang of this. I'll get the hang of this stream eventually. Oh, man. I think yesterday was a slow day, but today, I think we're all in it a bit more today with this trial. The judge, he saw him, he doesn't remember anything, so he's just like lit. But you know what they're like, they're just going to pound them with witnesses. It's also interesting that what I found interesting there, actually, Mark, you said he doesn't remember anything about Orange, and that's why the prosecution asked, so you're not really sure of the clothing because you want to make sure that was in there, because obviously everyone else is saying that he had a orange shirt, but this guy's saying he had a white shirt, so it's inconsistent, so I agree with you, Robin. Those the weather forgets the whole person lived with. What did Robin say? How do you not remember who lived with you when something tragic happened? Not sure. I mean, he did say that there was a lot of coming and goings in the house. So I think it was like a lodgings thing it was. So I just suspect that they had lots of people renting at that time. I don't know. The brain is a weird thing. Also, you talk about a man. Us men don't remember lots of stuff. We remember some things, but not the everything thing. Or no orange hoodie. Yeah, well, maybe a shirt, a hoodie. Who knows? It's I just don't know. I mean, outside of the DNA, which even with the DNA, I question even that. I think you can question everything in this trial and how anything was taken, because when you come to trial and you submit 3 envelopes and the 3 envelopes are missing of evidence, 3 crucial pieces of evidence as well, one of which would have placed a white person at the scene of the crime with it being in her hand, and it's gone missing. I don't know. That to me is a little bit. I would be hammering that home, and how I am trying to refrain from giving too much opinion, in the sense of we still need to find out how or what the DNA means. I don't know how legit that DNA is. So let's see how they implement that. So I don't know. Robert, you said, I remember what I was doing 30+ years ago when a neighbour died and guy was on his fire escape trying to get out of the house because the body's blocking the door from open. I'd say everyone's different, Robin. I'm not saying that you wouldn't remember that. I'd be honest with you, I don't remember everything. I remember I've had people die around me and I don't remember exactly who was around me. Everyone's different, people. I try not to judge others when it's 25+ years ago. And as I say, women seem to remember details much more than men. I would say that. We look at funny things, if that makes sense. We are here for your opinion. I know, but I'm trying to refrain it a little bit in the sense of I want to hear the DNA stuff. At the minute, it's bullshit, is the way I'm seeing it. I'm not... I'm also afraid I'm missing something. I don't know. Again, maybe because I did miss a few witnesses, and I'm always worried that I missed something. So I just don't see it at the minute. When you consider on the openings, the hands of the boyfriend, that's a lot. Do you know what I mean? That's a lot to take in. It looks like he's been in some sort of fight or some sort of grappling or something, and that was taken 2 days after. I just don't know. I just don't know. You know, there's a lot of question marks here, I believe. Oh, I was wondering, why am I missing chats? I've got it on top chat. Okay. Are you sure it's missing though? Who can ever tell if it was there in the first place? True story. True story. I mean, we don't know what's happened to it. This is another one where it's like, where's the evidence? Does it even exist? Was it made up? The guy said he sealed it. It came back sealed, but there's nothing in there. Where's it gone? You tested it, so and I think the testing was done in 2024. So how or what was it made up? Was it missing? A lot of people have got a lot of things to answer for. I don't know. I also, when it comes to the DNA element of it, I know that some of you know a lot more than me about the DNA, and some of you already expressed your opinions that the method and what it stands for is bullshit. So there's that as well. So how accurate is it? Because I remember, do you remember years ago, I've been talking, well, not even years ago, a few years ago onwards, if anyone says anything about DNA, then it's guilty. Do you know what I mean? You know? So I think times are moving a little bit now where just because you have a DNA, it doesn't necessarily mean that you've killed somebody. It can get there in other forms. We got touch DNA. There's many things that can put DNA. Now, I'm not saying you should just discard it, but there are now more opinions where before, if you bring DNA to a trial, then yeah, normally it's guilty, because how many people have been convicted based on DNA, based on things like touch DNA and stuff like that? I can't remember the names of one night stands in the morning, let alone 25. I think it's more of I generally do think it's more of a man thing, though. I think women are more caring, not caring, that's the wrong word, but women have better memories, I think, than what men do. I think we concentrate on things that might not be as important, the detail. So I generally do think it's a gender thing, personally, because I got a memory like a sieve as well, no matter what's happened. But women tend to remember the final details. I mein, have you gone in a fight with a woman? She remembers everything from fucking, 20, 30 years ago. Jeepers. I don't remember what we argued about yesterday. So we are emotionally detailed. True story. And I believe that. I do believe that. Right. I hopefully there's no more breaks, because it's those people get fair trials. Though I don't know. I would disagree with you, Bex. Not on everything, you're right, but there are a few trials, I imagine, 10, 15 years ago that may have been touch DNA, and they pinned it on somebody potentially. And we all know how touch DNA works. You can transfer and stuff like that. But back then, we didn't know about that back then. So I presume there's a lot more people in prison right now that are in prison because of DNA, but actually might not have done it. I remember the first time he told me to fuck off. Fuck off, Bex. I know. I know. I don't remember half the things. My sister remembers stuff. And my mother remembers like some funerals and all that. I don't remember nothing. Okay. When the fuck is Chris going to testify? Is he going to be called? Listen. We all said during the current retrial that they had to call Proctor, yeah? We all said the same. They have to call Proctor. They never did. So, is this going to be the same thing? Are they not going to call anybody? I agree with you, Bex. It's fine. Now, Bex, you can fuck off now, Bex. It's fine. We got the point, Bex, yeah? I agree it doesn't feel like a fair trial. How can 3 pieces of key evidence go missing and it's a fair trial? Do you know what? That's a good point. Lady Di says he didn't remember telling Lovely thank you for yesterday, and I was just trying to give him 5 coffees. Oh, did you? He didn't come up.
Going back?
Let me check.
All right, you may bring the jury back. Thank you.
Maybe, do you know what? I played about with my settings. Hang on, it should come up. I think it's because I got the thing covered. I think it is. If I put this here, maybe because I moved it, it should come up above there. Yeah, no, my point was, Lady Di, that they may not. I don't know. We'll see. Because it should have come up on screen. I should have got a bing bing on it. Hang on, I will check now for you, Lady Di. I got it open here, so let me just check. View page. Doesn't seem like you have, no.
No, I may be seated. Mr. Yalman-Shelley, Mr. Bolton,
No.
you may call your next witness.
No, you did not, Lady Di.
Call it Jennifer Corsi.
Could you get Jennifer Corsi, please?
She's out of breath. She's out of breath because she's just had a quickie with the state attorney here, this guy here. He just going, thank you, Judge. You're just making my job a lot easier, Judge. From blowing the state... There you go. Marky's got it. Marky's got it. Just making sure that you got the right one.
Thank you, Your Honor. Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay. You can have a seat. Good afternoon.
Good afternoon.
Ma'am, if you could start by stating your name and spelling it for our court reporter, please.
Sure. My name is Jennifer Corsi. Last name is spelled Coursey.
And Ms. Corsi, how are you employed, ma'am?
I am currently employed with the United States Army Criminal Investigation Laboratory in Forest Park, Georgia.
And can you tell us a little bit about your responsibilities at the U.S. Army's Criminal Investigation Laboratory?
Sure. I serve as the laboratory director for that laboratory, and basically I have complete oversight over all of the forensics that we conduct at that laboratory, and we do forensic analysis for the military agencies across all of the Department of War, so worldwide.
How long have you been at the U.S. Army's Criminal Investigation Laboratory?
I've been there since June of 2004, so a little over 21 years.
And in those 21 years, can you speak a little bit about the different responsibilities you've had as you've kind of worked your way up to the title of Executive Assistant Director?
Sure. Basically, I began my employment at the U.S. Army Crime Lab in June of 2004. At that time, I was a DNA examiner, forensic biologist, which means I performed DNA analysis and serology on cases that were submitted to the laboratory. I was in that position from 2004 until 2010. In 2010, I was promoted to a supervisor, so I supervised a team from anywhere from 8 to 12 or 13 DNA examiners, which meant that I managed their day-to-day activities, assigned cases, and things of that nature. In 2014, I was promoted to the DNA division chief, which meant I was over the entire DNA division, which I think at that time was around 30 DNA examiners and technicians as well. And then I was in that position for about 10 years. And then in June of 2024, I was promoted to an assistant director. And then just this year, I was promoted to laboratory director.
Thank you, ma'am. Before your career at the U.S. Army's Criminal Investigation Laboratory, did you have an opportunity to work at the Georgia Bureau of Investigation's Division of Forensic Science?
I did.
Is that commonly known as the Crime Lab?
Yes, the GBI Crime Lab.
How long were you at the GBI Crime Lab?
I began my employment there in August of 1997 and then left in May of 2004, so it was close to 7 years.
And can you speak a little bit to, in general, what your I don't want to focus necessarily on your current position, but when you were at the Crime Lab, GBI Crime Lab, what were your typical duties and responsibilities?
So when I was at the GBI crime lab, I was a forensic biologist, and that means that I did forensic serology and DNA analysis on cases submitted to the laboratory. I would do the analysis, and then I would write a report of my findings and then testify in court as needed.
Can you speak a little to your educational background?
Sure. I graduated in June of 1996 with a bachelor's degree in biology, and then additional training was received on the job, specific training for DNA testing and serology testing.
Can you describe any training that you've had that allows you to perform those duties that you just described as a forensic biologist?
Sure. You are required to be a forensic biologist and to conduct DNA testing. You're required to have a science degree, which I had a biology degree. Addition to that, you must have specific coursework, which I also had, which was my molecular biology, genetics, and statistics. Addition to that was a rigorous training program that had to be at least 6 months long, where it is basically you do a lot of reading, you do practice samples, you have lectures, you do demonstrations, you also have practical exercises, written exams, and then oral exams as well. And the training is usually concluded with a mock trial to prepare you for court testimony as required.
Okay. Do you belong to any professional organizations?
Yes, I do. I'm currently a member of the Southern Association of Forensic Scientists. I'm a member of the American Society of Crime Lab Directors, and I'm also I'm a part of the Council of Federal Forensic Laboratory Directors.
Have you previously testified as an expert in the areas of DNA analysis, forensic serology, and forensic biology?
Yes, I have. I've testified close to 100 times in state and military courts.
Your Honor, at this time I would move to tender Ms. Coursey as an expert in the fields of forensic biology, serology, and DNA analysis.
No objection? Is that right? All right, thank you. This witness is deemed an expert in the areas of forensic biology, serology, and, I'm sorry, you said DNA? I was writing it. And DNA analysis. You may continue.
Ms. Coursey, if you could please speak generally to the steps in testing exhibits for biological material.
Generally, it starts with a visual exam. So we open the item of evidence after we've conducted an inventory where we're making sure that we're taking proper notes and accounting for the evidence appropriately. We open it up, we do a visual examination, we look for any staining that may stand out to us, whether it might be blood, so that would be a reddish-brown stain, sometimes yellowish staining for semen or other body fluids. So we just do a visual exam. Once we do that, if we identify stains, we then circle those, and again, we're taking good notes of that. And then we do what we refer to as presumptive testing. So presumptive testing is basically a test that you conduct on a stain that is just that. If the test is positive, it means that further testing is necessary to confirm the presence of that particular body fluid. If it's negative, though, it's negative. There's no further testing necessary. It's considered negative for that body fluid. And that's generally how you conduct, whether it's on a swab or whether it's on an item of clothing or anything of that nature.
And after a body fluid has been determined, what happens next?
Most often, there's an interest in who that body fluid belongs to, and so that the next step would be DNA analysis.
Ms. Coursey, I'm going to ask you to help the jury understand what is DNA.
So DNA is basically the blueprint for your body. It dictates everything from eye color, hair color, your height. You get half the DNA from your mom and half the DNA from your dad, and it changes. It stays the same throughout your life. It never changes, and all cells of your body have the same DNA. So that means we could take one sample of DNA from one type of cell in your body, so maybe like a blood cell, and compare it to a semen cell or some other type of cell in your body. Very, very much of our DNA from person to person is very similar. But there's a very small percentage, maybe less than 1%, that varies greatly across individuals, and that's the part that we hone in. That's the part that we look at for forensic analysis. And no two people have the same DNA except for identical twins.
When you were at the GBI crime lab, what type of DNA testing did the lab perform?
We performed short tandem repeat testing.
Okay. And can you kind of explain in a little bit more detail exactly what short tandem repeat testing is?
Sure. So if you think of the English language has an alphabet of 26 letters, your DNA is made up of an alphabet of only 4. And so short tandem repeats means there's specific known sequences on your DNA that repeats in everybody. And the number of times that it repeats in each of us is very different. And so that's the type of testing that we use to kind of determine, if one individual has donated a sample or not, and the difference between individuals.
What are the general steps for conducting DNA testing?
So DNA testing, first you have to get to the DNA. So basically you take a sampling of, let's just say, for example, I've identified a blood stain on an item. I take a small sample of that blood and I place it into a tube, and we have to get to the DNA. The DNA lives inside of cells, so we have to break open those cells, which is called extraction. So we get the DNA, we kind of rinse away all the other portions of the cell, and then we have that just pure DNA. The next step is to quantify the DNA. So we really need to know how much DNA is there. There's a specific amount required, or a minimum amount required, to perform the remaining steps of DNA analysis. During that step, we find out how much there are. The next step is called amplification, and basically that is just making lots and lots of copies of those areas of interest that I spoke of earlier that kind of vary across individuals. At that step also, there's a sort of a fluorescent label that is applied to the DNA, and that's for the next step of DNA typing. That way an instrument that these DNA fragments pass through can be detected by the instrument and recorded, so that the output is a DNA profile that we can use for comparisons between samples and individuals.
And why is DNA useful for forensic comparisons?
Really, it's useful because, basically, like I said, no two people have the same DNA except for identical twins, and we focus on that area of DNA that varies so greatly across individuals.
And can you talk a little bit about proficiency testing?
Yes, proficiency testing for a DNA examiner is required. We're required to do 2 a year, and that just allows us to maintain our competence. It makes sure that our skills are sharp and that we're conducting the analysis according to policies and procedures, and that we get the correct outcome. So proficiency tests are generated by an external company, and they know the results. It's submitted to the laboratory, and we do not know the results. We just perform the testing on it just like we would a normal case, and then we get our answers, our conclusions, and those are sent back to the agency that we purchased the proficiency test from, and then we get a report back from them to say whether we got the consensus result or not.
Can you speak a little bit to some quality control measures that are used in the U.S. Army's Criminal Investigation Lab and from your time back at the GBI Crime Lab?
Sure. They're pretty much very simple or similar, because the DNA testing across all laboratories have certain requirements. And so we start with validated procedures that are validated, they're shown to be reliable and reproducible. And then we have, approved policies by our laboratory. After that, it's more about we use personal protective equipment, right? We use gloves, masks, things of that nature, laboratory coats. We clean our areas. We don't want contamination. We make sure that our areas are very clean in between samples. We work samples at a different time or space, again, just to prevent for any cross-contamination. In addition to that, all reagents that we use, all the chemicals that we use for our testing are tested prior to being utilized on evidence. So we know that they're working properly before we use them on evidence. There are positive and negative controls. Those are, a positive control is a sample that goes through the entire process with the evidence sample. We know the outcome of it. We know what the DNA profile is for that positive control. So it tests at the end of the testing when we're looking at the DNA profiles, we should know what that profile is and that the system, everything worked properly. There's negative controls as well. We don't want a DNA profile in a negative control. It is a blank, essentially, and it shows that nothing was introduced into the process that shouldn't have been. We also have reagent blank controls that are also for the same thing. It shows that there's no contamination to the reagents that we're using for our testing as well. Additionally, at the end of our testing, when we have compiled all of our results and we've generated a report, we have another qualified examiner review that case technically to make sure, again, all policies are followed, procedures are followed, all the proper documentation is present. They also do an independent analysis of the data. So there is data generated, and they do an independent analysis on it, and then they compare what they got as the answer to what I got as the answer and make sure they match. And once all of that is done, they kind of check off the case. That is called a technical review. Then there's one more review that is conducted before the case or before the report is released to the customer, and that's an administrative review. And that's basically typos, formatting, things of that nature, make sure there's no misspellings. And then after that, the case is released.
Ms. Corsi, I want to call your attention back to January of 2001. I think we've established that at that time you were at the GBI crime lab. One thing I don't think I've established is, was your name different at that time?
Yes, my name at that time was Jennifer Fincher. That was a first marriage name.
And I only asked that because there's some reports with
Understand.
that and that last name on it. Back in 2001, did you have the opportunity to conduct both serology and DNA typing tests on some evidence in connection with a case involving a victim by the name of Tara Baker?
Yes, I did.
Okay. I want to first start with
You may.
first start. I'm going to hand you. Well, I'm marking this case. That's opposite. All right.
That's what I have. Ms. Satterfield, is that what you have? Thank you.
It's all right. Now I'm going to hand you what's been marked as State's Exhibit 101. What is that, man?
This is a final report issued based on my testing of the sexual assault evidence collection kit of Tara Baker. I recognize it for the unique DOFS case number at the top as well as my signature at the bottom.
And basically, Ms. Corsi, if you could kind of summarize what this report summarizes, what this report reflects as it relates to your work in the early days of this case.
Yeah, this report basically states that I conducted.
Yes, sir. All right. Any response to the objection, Pearson?
I'll rephrase your.
All right. I'll sustain it and allow you to phrase if you choose to.
Ms. Corsi, is State's Exhibit 101 a fair and accurate summary of your semen identification based on the case that we're here about today?
Yes, it captures my findings and conclusions.
I would move to tender States 101.
Any objection, Mr. Cruz? All right. Any response to the objection? All right, I'm going to admit it over objection.
Again, Ms. Corsi, if you could kind of summarize what this report indicates that the work that you performed.
Sure. I conducted testing for seminal fluid and semen on items from a sexual assault kit identified as coming from Tara Baker. That testing included visualization of or looking for the presence of sperm on a microscope slide or a smear, they call it, made from of the vaginal area of Miss Baker. I also tested swabs from the oral and rectal areas. The testing of all of that were negative for seminal fluid or semen.
And let's talk a little bit about what testing was available, chemical testing was available for the detection of seminal fluid back in 2001. Back then, ma'am, what test was the lab using for to detect for the presence of seminal fluid?
Sure. So it's kind of it's a little bit different depending on what item I'm testing. So basically for smears, we're looking microscopically for the presence of a sperm cell. So in order to do that, you stain the slide, and you do that by using two different colors, red and green. It's called red and green dye. That's what we used. The red stains a sperm head the color pink or red, and then the green would stain it like a dark green color. So that allowed us to visualize the sperm microscopically. So that was done with the vaginal smears. I did not identify any sperm on that slide. Then I would conduct testing on swabs. I did oral swabs and rectal swabs. So basically that I took a small sample from a small cutting from each swab, and then I tested it. If you remember earlier, we talked about presumptive testing. I did an AP exam, which is acid phosphatase, which is a chemical that is found in high concentrations in seminal fluid. So I conducted testing using that reagent on those swabs, and they were all negative. So that concluded my testing for those items.
And if you know, Ms. Corsi, is the acid phosphatase test still the, I guess, preferred test or presumptive test for seminal fluid used today here in 2020?
Yes, that reagent is still currently used today for this same type of testing.
Are you also familiar with something called the quantifiler trio test?
I am.
And can you just briefly describe what that is?
So the quantifiler trio is a kit that is commercially available, and it does, I'll go back again when I was talking about the steps of DNA analysis, the quant step of DNA. So how much DNA is there? So back when I did this testing in 2001, we didn't have that technology available, but now it is available, and basically it allows you to quantify the amount of DNA, but it also gives you some indication of if there's male DNA present. And this could be in the absence of a body fluid. So if there's an item of evidence that doesn't have seminal fluid on it or any body fluid, you can still take that forward to this type of testing, and it will quantify the DNA for you, but also give you an indication of if there's male DNA present in that sample.
And do you know when the quantifiler trio came to be used? Let's talk specifically about the U.S. Army Criminal Investigation Lab, since that's where you've been for the last 21 years.
Right. We went online with quantifiler trio in 2016.
Ms. Corsi, were you also asked to conduct serology testing on fingernails from the sexual assault kit of Ms. Baker?
Yes, I was.
approach the witness again, Your Honor?
You may.
Ms. Corsi, I'm handing you States Exhibits 102 and 103. Recognize this, ma'am?
Yes, I recognize these as official reports I generated at the time of testing of the fingernails from the sexual assault evidence collection kit of Tara Baker. Identify it based on the unique DOFS case number at the top as well as my signature at the bottom. One report contains the serology testing or the blood testing, and the other report is in regards to the DNA testing on the fingernails.
I'd move to tender States 102 and 103.
Any objection, Mr. Cruz? All right, thank you. Any response to the objection? Okay, I'm going to overrule the objection and admit 102 and 103 over objection.
Ms. Corsi, let's start with 102. I believe that is the blood examination. Is that correct?
Yes, sir.
What does this report summarize, ma'am?
This report entails the testing that I conducted on the fingernails for the presence of blood. Again, I performed chemical testing on the fingernails. It's presumptive testing, and it did indicate the presence of blood. Oftentimes, when there is an abundance of abundance of blood or reddish brown staining on an item, we would go further to confirm the presence of blood. But in this situation on the fingernails, it was a small amount of blood, and so my report says in there that in order to preserve that sample for DNA testing, no further analysis was done at that time, and then the samples were submitted for DNA analysis.
That's 102.
Yes.
Move to States 103. What does that report summarize, ma'am?
This report summarizes the DNA testing conducted on the blood that was indicated on the fingernails. That DNA was found to be match Tara Baker or her identical twin.
Can I approach again, Your Honor?
You may.
Ms. Corsi, were you also, as part of your responsibilities associated with this case, asked to, I guess, check, for lack of a better term, certain physical evidence outside of the sexual assault kit for the presence of blood?
Yes, I was.
And States 104, do you recognize that, ma'am?
Yes, this was a report I generated at the time of testing regarding multiple items of evidence to include stove knobs, 3 different knives. Yes, and it also has the unique DOFS case number at the top and my signature at the bottom.
And do you, I guess, if you recall, what were the results of those particular tests?
So my results were, there was one knife that I indicated the presence of blood on. That was item 15. The additional two knives, items 29 and 30, did not reveal the presence of blood, nor did the stove knobs, item 14, I apologize, 14. All of those were negative for blood.
And is States 104 a fair and accurate summary of the report that you generated in connection with that, that testing? Excuse me.
Yes, sir, it is.
Move to tender States 104.
Any objection? It is, I'm going to admit it over objection.
You mentioned just a minute ago that the one item that you tested that was positive for the presence of blood was item 15, which was a knife. Did I hear that correctly?
Yes, sir.
Can I approach the witness?
You may.
Yes, this is the item 15 that I referred to earlier containing the knife. I recognize it with the DOFS unique case number associated with this case.
And I'm gonna just go over a couple of things on this box. And I'm going to do it on the Elmo. So you mentioned some unique identifying information. I'm going to zoom in here. What are we looking at here, Ms. Corsi?
In our laboratory, we have a laboratory information management system that kind of keeps track of all the evidence and information and data that is associated with a case. When items come into the laboratory, they're given a unique case number and item number. A barcode label is generated at that time and affixed to the item for tracking throughout the laboratory, and that's the label here that you see that has the unique case number 2001-1002454. In addition to the SUBM number 15, which I've been referring to as item 15.
Then I also want to point out one other thing on this box. Did you recognize anything here to include your initials at the time?
Yes, I do. I do recognize my initials at the time, as well as other initials and dates on the evidence. We are required once we, if we breach a package, we have to reseal it and date and initial our seal at the time. And so that's what my initials signify here, that I had opened that package at one time.
So to follow up, having chemical examination having indicated the presence of blood on the knife, would that have, I guess, moved it forward for potential DNA testing?
Yes. Actually, for that knife, I may have misspoke if I said indicates the presence of blood. That terminology means I did not do the confirmatory testing, when in this case I actually did on this item. So it did confirm the presence of blood. But yes, a portion of that sample did go forward for DNA testing as well.
So, what is States 105?
This is my final official report generated at the time of my testing regarding the DNA analysis conducted on the blood found on the knife, item 15.
Okay. And is that a fair and accurate summary of the DNA analysis or DNA typing that you did in connection with the knife, item 15, which is also States 94? Yes, 94.
Yes, it is.
Move to tender States 105.
Any objection, Mr. Cruz?
Yes, ma'am. You're saying.
I'm going to admit it over objection.
Ms. Corsi, what did your results reveal as to, if anything, as to item 15?
Yeah, my DNA analysis conducted revealed that the DNA from the blood obtained from the knife matched Ms. Tara Baker or her identical twin.
Did it indicate whether or not there were any other DNA profiles present on the knife?
Yes, there was only one DNA profile present. There was no indication of an additional contributor to that sample.
Last one, I believe. I can approach one last time.
Yes, sir.
Of course, this is case 106. Now, in this case, were you also asked to examine toenails taken from Ms. Baker's body during her autopsy?
Yes, I was.
And does States 106 summarize your testing as it relates to that particular piece of evidence?
Yes, it does.
And is that a fair and accurate copy of the report that you generated in connection with the blood examination related to Ms. Baker's toenails?
Yes, it is.
Move to tender States 106.
Any objection?
Yes, ma'am. You're saying.
I'm going to admit it over objection.
Ms. Corsi, was there any blood on Ms. Baker's toenails?
No, I did not reveal any blood on the toenails.
We talked, the very first report that we talked about was the semen identification report. And you mentioned again that there, I can't find it, that it was negative for the presence of seminal fluid and that it did not reveal spermatozoa or partially intact spermatozoa. Is that correct?
That is correct.
And at the time, what would have been the protocol for that kit or those swabs to proceed with any sort of DNA testing?
They would not have. Once we test for semen, if that was not identified, we would not do further testing on it.
Here, 25 years later, based on your training and experience, has testing improved in sensitivity in that time period?
Yes, over time, there's been a lot of advances in technology, which allows for additional testing conducted, to identify, not necessarily body fluids per se, but also body fluids, but DNA in a more sensitive manner as well.
If I can have just a moment, Your Honor. Corsi, as it relates to, I'm going to jump around a little bit, the DNA typing of Miss Baker's fingernails. I think you previously indicated that the DNA from those fingernails matched Miss Baker or her identical twin. Is that correct?
That is correct.
And was there any other DNA profile obtained from those fingernails?
No, sir, I did not identify any other contributors to that DNA profile. It was a single source.
Ms. Corsi, I don't have any further questions for you. Mr. Cruz may have some.
Cross-examination.
Yes, ma'am.
Okay, here we go.
Good morning. Well, good afternoon, Ms. Corsi. How are you?
I'm good. How are you?
I am doing well. Give me 1 second. I have a couple of questions for you. Is that okay? All right, thank you.
Oh, I couldn't do that. I can't bend the laptop like that. That to be, oh, that goes right through me. What he did just there. Oh. Okay. I'm not sure if anyone's got any opinion so far, but I think it's important to listen to both sides. And then he did object to every item to go in, but he was overruled. So we'll see what happens here.
And is it Dr. Corsi?
No.
Just Miss Corsi? Okay, excellent. My name is Amai Cruz. I have the privilege and honor of representing Mr. Edrick Faust. Is it okay if I ask you a couple of questions?
Sure.
Okay. I'd like to talk to you about State's Exhibit 101, State's Exhibit 102, State's Exhibit 103, and State's Exhibit 106. And I am going to hand these to you. Okay.
Thank you.
And I want to discuss specifically with you item 2,
Okay.
which is the Tara Baker sexual assault kit. Is that correct?
Yes.
Okay. And is the proper way to address it is item 2? Am I saying that correctly?
Yes.
Okay. Anytime you received item 2, was there a particular method that you had to undertake as far as notating when you had it or notating when you gave it to someone else?
Well, anytime I conduct analysis on it, I would have notes of anything I've done in my case notes, and then if I breached the box or the container that the item was in, again, I would seal it, or I'd have to break a seal and then reseal it when I was done with my initials and date on it. Additionally, the barcodes that I identified earlier on the screen, we scan those barcodes when we transfer evidence from either to ourselves or a storage area or to another person.
Sure. So would it be fair to call that scanning is for chain of custody purposes?
Yes.
Okay. And is this something, this isn't something you're typing in, this is something that's computer generated?
I believe the scanning, this was a little while ago, but I do recall that there being a scanning. There could have been a mechanism if a scanner was broken or not working that we may have had to do a manual transfer by signing, actual paper documentation, but I don't recall specifically. But that would probably be a backup plan if the scanner didn't work or failed in some way.
Yes, ma'am. 1 second. Can you, or do you recall all the items that are that you first received, item 2I and item 2J?
So my notes indicate that I performed analysis on those items on January 22nd, 2001. As far as the notes that I have with me today, I do not have exactly when I received it first. This document states that it was on your laptop, identifies it as being resubmitted on February 15th, 2024.
How about the first time you obtained it? And I'll let you know this. I'm not trying to put you in the hot seat. You're not in the hot seat. Which date from either record did you first receive it?
Oh, my apologies. I didn't see this down here.
No, you're fine. And you can scroll to 2I and 2J if you need to.
So for item 2I, it appears that my first possession was January, oh, I'm sorry. Sorry.
No, you're fine.
January 22nd, 2001.
Okay. In 2I, is it fair to state that 2I is a oral swabbing?
That is what it was labeled inside of the kit on the container.
Okay. And is 2I A or B?
2I. So I do not have it in my notes as that. I have oral swabs A and B, but because I don't have that I and in the J, I'm not sure which correlates to which on this chain of custody.
That's fair. You answered my next question, but you have it as oral swabs A and B.
Yes.
Okay. So, to your knowledge, you tested oral swabbings. Is that right?
Yes, I had two separate containers. I don't recall if it was a box or not. Two containers that were labeled oral swabs.
Okay. And would you happen to recognize these?
I should recognize them with my initials and case numbers on them.
On this here?
I should be able to see my case number and initials on there. Yes, I recognize these as the envelopes that I tested with my date and initials, marking the date that I tested them, opened them for testing.
Okay, your initials are on those packages?
Yes.
So as of January 22nd, 2001, you had oral swabbings. Is that fair to say?
Yes.
Okay. After January 22nd, 2001, did you see those swabbings again?
No, I don't believe I did. I mean, it is possible that they were, one moment, please.
Take your time.
I have a lot of notes. So I imagine I saw them again, but did not conduct further testing on them, because when I did further testing on the toenails that were in this kit, they would have been in there, but I did not make record of that because I went in just for the toenails.
And what date was that?
I conducted the testing on the toenails on March 5th, 2001.
Okay, so you still would, because it was in one whole package, you would have had those swabs?
Yes.
Okay, excellent. This is a really important question, and this is my last question for you, and I'd like you to, let the jury know. Can you tell us what presumptive testing is?
Presumptive testing?
Yes, ma'am. Can you let the jury know what a presumptive test is?
Presumptive testing, I believe as I mentioned earlier, is a test that presumptively that's the wrong term. It's a first test that we use to kind of determine if any additional testing is needed. So if a presumptive test is positive, further testing is needed to confirm that particular body fluid. If it is negative, then at least at that time we stopped analysis.
My follow-up question to that, so if after a presumptive test, or let's say this, what does it mean when a presumptive test comes back positive? Can you let the jury know what that would mean?
Yeah, when a presumptive test is positive, it means that it indicates the presence of that particular body fluid, but it does not confirm it. So again, additional testing would be needed to say for certain that that body fluid is indeed blood or semen or whatever you're testing for.
Okay, and if you don't confirm the presumptive test, what does that tell us?
It basically means there's an indication of that body fluid, and generally that sample would go forward for DNA testing to determine who the sample came from.
Would it be fair to say that, I believe you said, let me not get it wrong. What's the type of testing needed after presumptive testing? Is it just confirmatory testing?
Yeah, we refer to it as confirmatory testing.
Okay. If confirmatory testing is not done, is it fair to say that we don't know whether or not that substance is present, whatever it may be?
I wouldn't go that far necessarily, because when you conduct DNA testing, especially at that time, and considering the technology that was available, we retrieved a DNA profile from something, and what was tested for was blood. So to me, at that time with the technology available, I would be very comfortable to say that the DNA profile came from blood.
And please forgive me. Please forgive me. So I'm not speaking of DNA testing.
Sure.
I'm not speaking of DNA testing at all. And please forgive me for not making that clear. I'm just speaking on, I would like for you to explain to the jury, and not in regards to DNA testing, just the principles of presumptive testing versus confirmatory testing, and what it means if you have a presumptive positive versus a confirmatory positive, or if you don't confirm at all. That's what I'm trying to get at. Does that make sense?
Yes, sir.
Okay, thank you.
So when you perform only a presumptive test, and that is the standalone test, and no further testing is done, you cannot say that 100% this is that body fluid. If you do add the confirmatory test and do both in conjunction, and they're both positive, then you can confirm the presence of that body fluid. Additionally, though, in combination with DNA testing and a presumptive test for body fluid, that can also be confirmatory, as well as the DNA has to come from something.
So outside of DNA testing, if we have a test that's deemed a presumptive test, we would need to do confirmatory testing to ensure that it's properly identified.
That's correct.
All right. Thank you so much for your service to this great country. I really appreciate your time.
Thank you.
Any redirect, Mr. Bolden? Go ahead.
Follow up a little bit on some of the last questions. Did I hear correctly that presumptive testing, along with other environmental factors surrounding the test itself, may be helpful? Is that what I heard you say? Or something to that effect? I'm not trying to put words. Let me back this up. Is presumptive testing, in your opinion, helpful?
I do believe presumptive testing is helpful because there's a lot of, when you open an item of evidence, let's just say that you're looking for blood to see if blood is present. There can be all kind of staining on an item. If, for example, let's just say we have a pair of khaki pants. You open up the pants, and again, you talk about visual analysis. So that's the first thing I would do when I open it up. And any stains would catch my eye. If you see stains that are reddish brown, those catch your eye, so you circle them and you do this presumptive testing. Well, many things can look like blood. Sometimes chocolate looks like blood. Sometimes, Georgia red clay looks like blood. There are many things that can look like blood. But doing that presumptive testing can initially go, okay, we can put that one aside because it's negative. I don't need to do anything further with that. Let me focus on any other stains that I see. And those stains that are presumptive, then you have to make a decision based on the case and the situation if you're going to go further to confirm it, or if it goes to DNA analysis or it stops.
Any requests, Mr. Cruz?
Have you heard of Lugol's iodine test?
I have heard of it. I have never used it.
Okay. Do you know what it is?
I am not confident to speak to that at this moment. I have never used that test, but I know I have read about it.
Let me ask you this. Do you know if it was in existence in 2001?
I do not know if it was in I do not know, because as part of my reading and training, we read about historical things, and I apologize, I've never been trained on that, nor have I ever used that technique, but I have heard of it. I just don't recall.
Absolutely, that is fair. The computer that I gave you.
Yes.
Do you recognize that document? The chain of custody report?
I do recognize it as a chain of custody that was generated at the GBI, but I have not seen this in probably 20-something years. It's not a part of my notes today that I have.
Sure. Can you take a moment and just refresh yourself with that document?
Just cough and say you're ready.
And just in regards to your, and just to save time, just in regards to your portion of that report, chain of custody report, in regards to items 2I and 2J, and the, I think the first page.
Yes.
Okay. You do recognize that in regards to those specific items and the first page?
This first page, that's what you're...
Correct.
Yes.
Okay. Is it fair to say that that chain of custody report, at least with your notations on it, would have been made at or near the time that you received or relinquished possession of those items?
Yes, that's correct.
Would it be fair to say that the chain of custody report in regards to yourself was made by you and you had personal knowledge of whether or not you had those items or relinquished those items at that time?
Yes, I should have knowledge of whether I have an item in my possession or it's somewhere else.
And is that chain of custody report kept in the course of regular conducted business of the GBI?
Yes.
And was it the regular practice of the GBI when officers received items or relinquished items to make a notation on the chain of custody report?
Yes, it should be noted on the chain of custody. And any time the evidence was received or transferred from a location to a location or a person to a location.
Okay. And is that a fair and accurate report? Does it appear to be altered in any way?
Again, I have not seen it in a really long time, but it appears to be what I recall as a complete chain of custody. There are items on here that I never had possession of,
course.
so I can't speak to that.
But to your items, does that appear to be altered in any way that you had possession or relinquished possession at the times notated on that report?
To the best of my recollection, it appears to be consistent.
Your Honor, I am going to mark this USB as Defense Exhibit 21. It will contain a redacted version of the chain of custody report, only including items 2I and 2J, and Ms. Corsi's possession and relinquishing of items 2I and 2J. Does that make sense, Your Honor?
Would you rephrase that?
Sure. So I'm moving to introduce Defense Exhibit D21.
Got that.
Yes, ma'am. And what it would consist of is a redacted copy of the, and I can make it easier for you. It'll include Ms. Corsi's portion of possessing items 2I and 2J, which Ms. Corsi has identified as oral swabs A and oral swabs B, as well as the first page identifying items 2I and 2J as oral swabs A and oral swab B.
All right, thank you. Mr. Bolden, any objection to the request for admission?
Your Honor, we don't actually have the document yet. So, like, I'm not exactly sure exactly what Mr. Cruz is intending to tender. So if he needs some time to produce it, because I just don't understand exactly what it is. I think I do, but I haven't seen it. So at this time, I would object. Once that document is produced, I'm happy to take a look.
Sure. May I produce it to the State, Your Honor? Is that fine?
Yes, and I will hold off ruling on that particular request until that process is done. You may continue your cross-examination.
Yes, ma'am. May I ask this? Can it be conditionally admitted based on me? Because the reason I ask that, the witness will be gone. So I just want to make sure that it can be conditionally admitted on the basis of
I don't think conditionally admitted is actually an appropriate way to handle it.
That's fair.
I have certainly heard the testimony. We can have it played back if we need to do that. I'll let you ask any other questions you need to.
Yes, ma'am.
To make sure you've asked everything you need to. I'll let the State do the same thing. And then I'll hear from both sides after the document that you're talking about is produced to the State.
Yes, ma'am. Ms. Corsi, you received a subpoena from our office?
I don't believe I did.
Thank you so much. I don't have any other questions for you. May I approach you?
Yes.
Okay, excellent.
And any redirect from the State? All right. May this witness be excused.
Thank you.
All right. Mr. Cruz, the State is asking for this witness to be excused. Any objection?
No objection.
All right. You are free to go. You may call your next witness.
Am I the only one that's confused right now? Rhonda, KD's on Facebook. I'll send you KD's page on Messenger now for you, Rhonda, so you can contact KD if that's okay. That you can message her then. I am more confused now. I don't really understand what just happened in full. So I don't know.
Yes. All right. Ladies and gentlemen, we're going to take a 5-minute recess. Don't talk about the case. We'll see you in a minute. Thank you.
Here we go again. Rhonda says no. No what? You don't want Rhonda, you don't want KD's Facebook. Alright, I speak up in the chat. I don't really know. I'm very confused. So, chain custody looks okay, but does that mean that there's going to be future witnesses? Are they trying to say that some things weren't logged and that's why they weren't checked? Or, yeah, I'm just a little bit sus with everything. Why did they not check all DNA? Presumptive DNA. There must be another witness for DNA. Because that's not very good. So sorry, I'm with you now, Rhonda. Okay, let me go and find KD on Facebook for you. And I'll link Facebook to you, Rhonda. So you've got that. I trust you, Rhonda. I wouldn't trust Dave or Badazza, but you know. So I just posted you the direct link to her. That should take you straight to Katie's page. So you can add her as a friend and message her. Stays hiding the ball, it seems to go for you. It is a bit annoying because, and I know, I'm being dramatic now, but every time there's an objection from the defense, it's as in, you know, overruled. Every time there's a objection from the state, it's like, okay, yeah, we agree with you. There's a lot of this. I'm trying to be objective, you know, but it's hard to be objective sometimes. Right, state hasn't proven one thing. I mean, there has to be a DNA expert because that is what? There has to be somebody else coming in later that tested it somehow, some way, because that told us nothing. I don't know, I posted in your Facebook. I had to prove one thing. I was only I'm thinking in 2001 it was only the victim's DNA. Then they investigated the case and retested the DNA and found male DNA, but I don't know. But also there's something wrong with the chain of custody allegedly. So there could be something wrong with the chain of custody. I'm presuming. Because, you know, yeah, I fake book. Was it a proper investigation though? Who collected the so-called DNA and did they use red solo cups? To be quite honest with you, Crystal, I would say this was probably worse than that. It's showcasing that there's literally 3 key pieces of evidence allegedly missing. The hair, 3 pieces of hair found on the victim's body is gone. I really don't understand it. Oh. So, and also all these interruptions, the jury. Bard is in the Facebook group. He is, yes. This must be frustrating for the jury as well because it's very confusing. And imagine, like, at least we can chat. Imagine being a juror right now where you're on your own, not able to discuss this case with anybody. You must be thinking, what a shit show this is. No, lovely. We have a alternate corner group. Alternate corner group. Are you in that? Lovely. We have that, the alternate corner group. No, I was just passing on KD's Facebook page to Rhonda so they can talk about cookies. And the group that KD's talked about is the alternate corner group on Facebook. And if you're not in there, then get in there. Right, so yeah, I don't know. I think at least we can Google stuff, and we got people in the chat that slightly understand some of this stuff. But if you're a juror, you'd be very, very confused right now. Bex, you know what I think about you, Bex. Exclamation mark Bex. Only dogs are in there, probably. You're not in it, though, Lady Di. Oh, man. So I was a bit disinterested in this trial. But now I'm not. Now I'm seeing a lot of things that are wrong. So... It's very... I'm a little bit confused. And I am confused as well. And no one told me about it. Oh, hang on. It's I blame Sarah P. Lovely. Hang on, let me go and get you the link for it. It's Sarah P's fault. Don't you worry. Actually, Sarah P's got it. I don't have the link. So when Sarah P's here asking for the link, I don't know what the link is. She posts it every. Oh, to be fair, you're not here in the mornings, are you? Lovely. She posts it every morning in here. But I don't remember what it is. I'm interested because of this cunt of a judge. I know. Don't know. They don't really have anything to discuss. Well, no, but like you would want to talk about the shit show this is. Well, you don't want to talk about the boyfriend's hands. Facebook group, please, Sarah. Facebook group, please, my darling. I don't know what it is. Sarah P is the link woman. We call her lazy, but she actually has all the links. So Sarah P will sort you out. You might want to discuss this with your fellow jurors to be like, what the hell's going on? It must be embarrassing to be in there as well. Do you know what I mean? Sitting there having to listen to all this and listen to the squabbling and the judge and stuff. Thank you, Sarah. Nothing, Lady Di, nothing pretty much. There might be some stuff on it tonight. Kat Williams is covering it. I know she's put some stuff up last night and she probably will tonight. Watch Kat. She's got some, I'm sure she'll have some good summaries on it. She pays attention a lot more than I do. My mind wanders everywhere. If I'm a juror, I want to hear from the boyfriend. I want to hear from his buddy. Well, yeah, I mean, definitely the boyfriend. And I'm sure they will. But who's going to call that? I mean, the state have to call him. They made such a big deal at the start, and I'm presuming they're going to have to call his parents if they're still alive to give him his alibi again. Yeah, exactly, lovely, exactly. And did you see the link that lovely Sarah P posted as well, lovely, just for you? So yeah, it's I have a lot of questions. Let's just put it that way. I have questions. Excuse me, Judge, I have questions. First question, why are you such a bitch? Why are you just like Lady Di? Yes, I agree. I would want to talk about those things. And also, like, I'm just very confused of who have they got on their witness list as well, because they need to, if the parents are alive, they have to bring the parents. If he is around, which he still is, they have to bring the boyfriend. Just remember, though, you know, these kind of things are, like we've always said, these witnesses are shit sandwiches. You start off fairly strong, you put all this shit stuff in the middle to hide it, and you finish off with his strongest witnesses. So just remember that. We won't see the best witnesses until the end. So just remember that. Right, they're back. Right, you better join the group, lovely. Oh, excuse me. I'm getting tired. Dave Badaza, do not fight over this judge. Kat Williams is Kat, not Williams. I like Kat. So I don't mind promoting Kat. I don't like promoting other streamers, but I don't mind promoting Kat because she's always been good to us in here. And I can't say that about many streamers, so that's why I never discuss any of the streamers. Obviously, Sean. Especially potentially criminal, and Kat. Why? Why is she smiling?
Thank you. Please be seated. We are back on the record. Mr. Bolden, you may call your next witness.
Call Ashley Hall.
Could you get Ashley Hall, please?
No, there's nothing. It's 2001, lovely. So there won't be CCTV and stuff. So I presume it wasn't a thing back then. Even if it was, they would never have restored it back then. You know, so. Behave, Baldaza and Dave.
If you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And I just need to make sure that you're speaking loudly enough into that microphone so that we can hear you, okay?
Okay, is that better?
Yes. Ma'am, could you state and spell your name for the record, please?
Yes, it's Ashley Hall, ASHLEY HALL.
And where do you live, ma'am?
In Dicula.
I'm going to ask you about your relationship with the deceased in this case, Tara Baker. How did you meet Tara?
We were in the same sorority at Georgia College in Milledgeville, and then we ended up living together in the sorority house for a couple years. We both came to Georgia and ended up living together here as well.
Can you describe in general terms your friendship with Tara?
We were extremely close. Pretty much once we met, that was kind of came a little bit inseparable. And then when we both came here for I was doing my graduate studies and she was in law school, we were living together. Of course, you just didn't have as much time together, but we were still very close.
What kind of friend was she?
Wonderful friend, sweet person, always nice to everybody, always up for anything, very Southern Belle, very someone that was very into her family. Like, I felt like her siblings were my siblings by the time I knew everything about them, all about her mother, how wonderful she was. She knew my family pretty much about the same. She very black and white. She knew right and wrong. There was no gray with Tara. Like, it was, this is what you're supposed to do. This is how you treat people. Fantastic person overall. And I know people say that about a lot of people, but she really was just pure of heart, just a great person.
I want to take you back to August of 2000.
Okay.
And did you and Tara and Valerie Lowe all move in together?
Correct.
And how did the three of you come to decide to live as roommates?
Well, I met Valerie through the equestrian team at UGA. We both rode on the team. And then Tara came in '99 to work for the law firm. And unfortunately, I'd already signed a lease, so we couldn't live together that year. So we made a point. We made sure we were together the next year. And she got along with Valerie fine. And we were just very similar personality types, how we were raised, just both. Yeah, it turned out to be a great roommate situation. So.
Where did y'all move into in August of 2000?
Fawn Drive.
In that time, starting in August of 2000, did all of you have boyfriends?
We did, yes. I was dating my now husband, Chris Hall. Valerie was with Jeff Hall, and then Tara was Chris Melton. We thought it was funny because we had two Chris's and two Halls in that whole set. So
let's talk a little bit about Tara and Chris.
Okay.
You recall how they met?
At Georgia College, mutual friends. He actually was a cheerleader at Georgia College, and my brother was a cheerleader. And kind of just small school, you meet through that way. So
over the course of your friendship with Tara at Georgia College, up through and including moving into 160 Fawn Drive with her, did you have an opportunity to see her relationship with Chris?
yes, we
attended sorority functions all together. We went camping together. We went on trips together. Just hung out together. So definitely immersed in their relationship.
In that, again, that fall semester, so starting in August of 2000,
I just wanted to show you this quickly before we get back to the trial. So that's the sketch, and then this is him in 2001. So just so you can compare them. That's him, that's the sketch, and that's him. Might be just me, but it looks very similar, do you know what I mean? Sketch is pretty accurate, I would say. Face is a little bit different. So I don't know. It does. The hair, they've got the hair on point. The hair's the same. But you know, I would say that's quite accurate personally. That could be any man. Yeah, it could. It could. But I look, I'm trying to keep it a buck, people. I'd say that looks very much like him. Do you know what I mean? I would say that looks quite like him, personally. I don't think it's a stretch to say that looks like him. Now, obviously, it could be, as you say, it could be anybody, but that anybody sitting in, like if I was a juror, I would look at that picture and go, okay, yeah, it looks like him. Now, does that mean that he killed her? No. It just means the sketch is, you got to remember, he lived just down the street. So he could be walking down the street. It's very plausible that he was walking down the street. So him being seen walking down the street is very plausible. I just think that the hair, the lips, I don't know. When you got a sketch artist, it's obviously impossible to get it perfect, but I can see why they pinpoint that. So, when I look at that, I would have said, yeah, that's very like it. So, I could see that personally. And as I say, I don't think it's out of the realm because he lived there. So, would he go past that house every day? Yeah. Why wouldn't he? He lives right across the road. So, I mean, as I say, people, the sketch is not going to be perfect, is it? So, the eyes are, like you talk about 20-second sketch. I think that looks like him. But does that mean he's a killer? No. So, all I'm saying is that, will the jury think that could be him? Yes. Some of them will think that. Some of them might say no. I personally think he looks just like him. Does that make him the killer? No. So, that's what I'm saying.
Where was Chris living at that time?
He was living Jamestown Apartments, I believe it was, with Chase Guerin.
Is that here in Athens?
That's in Athens, yes, I'm sorry.
Do you remember where in Athens that is?
The Jamestown, right off of Millage, I believe.
Can you describe for the jury kind of what, at least inside y'all's house at 160 Fawn Drive, what that fall semester was like?
Well, I was starting my graduate studies. Tara was starting her law studies. Valerie was finishing her undergrad, and she was starting her grad studies the next semester, but it was busy. I mean, we were kind of passing each other, or we're just studying at all times. And then we had our boyfriends on weekends. We either would do something with the boyfriends, or we'd do stuff together too. But it was just that time of your life where you weren't getting any sleep and you were studying and, you know, just living your life. So,
do you recall during that fall semester
Oh, am I muted, am I? I was just going to say, to me, that looks a very good drawing. I think the hair is very similar, the ears are very similar. I think one of the main features that's not there is just the jaw line's a little bit different, but we have to remember that this is a sketch. This is not a picture. This is based on somebody saw him for like 20 to 30 seconds. So I think that I think this is quite a good sketch in my personal opinion. It can be passed as him. But again, like I said, it's never going to be perfect. Sketches are never perfect. They're just a guideline. You've never seen a sketch that's perfect. And in my opinion, this sketch is, you can attribute towards him. But again, like we've also discussed, does that mean that he is the killer? This is not necessarily the sketch of a killer. This is a sketch of a person that walked past the house at a certain time. And just remember, he lived opposite her. So, is it plausible that he would have walked past our house? Yes. Does that mean he's the killer? No. Is this sketch got attributes that can be attributed to him? In my opinion, yes. So, I think it's pretty close. You're never going to get a snapshot, but I just think there's some key features here, like the hair, the lips, big lips. The nose is quite similar. The jawline's not, but again, before everyone gets the knickers in a twist, this sketch isn't a sketch of the killer, potentially. It's a sketch of a man that walked past the house of where the killing happened. That does not mean he's the killer, just to be fair. So yeah. I think the nose looks very similar, Rhonda, personally. So, but again, I think, maybe I'm just giving it a bit more leeway. I've seen sketches where it looks nothing like them. I look at this sketch and think this could possibly be him. Yes. I think this is a very good sketch. So yeah. Right. Let's get back in here. Let's get back in this one. What's leader? I think you all look relatable. But right, my point is this, right? Okay, I won't discuss anymore. Right, let's get back to it. Let's get back to this witness.
Occasions where Tara would spend the night over at Chris's
Yes.
apartment. Do you also remember occasions when Chris would spend the night at 160 Pond Drive?
Not as much. It was mainly over there, so.
Moving forward a little bit to the start of the spring semester, did you notice any change in Tara as it related to her relationship with her studies?
She was really buckled down. She was stressed with school. This UJ Law School, it was a tough department. I think Chris ended up moving back with his parents more, so they just couldn't see each other as much. And so mainly really buckling down with school.
You mentioned Chris had moved back in with his parents. Do you know why?
He was helping his father. He was a plumber, and he just started working more full-time. So was starting his career and trying to go off on his own a little bit. He just was busy, and it just made more sense for him to work from there versus driving an hour to his work sites.
Where did Chris live at the end?
Loganville?
Do you recall a time when Chris gave Tara a Christmas present that year?
Okay.
Do you remember that?
I know he gave her maybe a piece of furniture or something, or...
And without going into anything that Tara may have told you, did you get an impression as to her reaction to that gift? Does that question make sense?
Oh, I mean, anything he would give her, she was over the moon about. I mean, she just liked anyone to think of her. So usually if you just give her, I mean, you could have given her, like, I would draw a little picture sometimes when I was bored at work, and she would hang them on her wall, you know? I mean, like, that's just, she just liked anyone to think of her. So anything he gave her would have been wonderful to her, so.
Turning to Thursday, January the 18th. Were you at the house at 160 Palm Drive that afternoon?
Yes.
Were you heading out of town that weekend?
I was. My class for Friday was canceled, so my boyfriend was going to Georgia State and ended up going to see him.
Do you recall being at home with Tara that afternoon?
Yes, we had a long conversation because with her birthday coming up, I actually had a horse show that weekend, so I couldn't go to her party. And so we were talking about what we were going to do to celebrate later for her birthday. And then we're just catching up on everything for the week, since it was rare for us just to have time to sit and talk.
So you mentioned a birthday. Do you remember what she was going to do?
I think go to a couple different places downtown Athens with her law friends and some people she used to work with.
Did she seem excited?
Oh, she was thrilled, yeah. I hated I was missing it. That was going to be, she was very excited.
Do you recall Tara talking to anyone on the phone that afternoon?
I think she and Chris talked on the phone, but they talked about every day.
If you know, was Chris planning on coming in town that weekend?
I don't remember if he could make the party, but I know he was coming in town and they were doing something for the birthday.
Objection, Your Honor. Hearsay.
All right, any response to the objection?
I didn't ask to elicit any statements by anyone. I just asked if she knew.
It's implicit hearsay.
I'm going to sustain the objection.
Did Tara appear excited about the weekend plans?
Yes, she was extremely excited about the weekend plans. And she was excited about seeing Chris.
Let's talk a little bit about Tara's morning routine. What do you recall about that?
She was pretty much a creature of habit. Shower in the morning, she'll go eat breakfast. She would always have 2 bags of cheese grits, because I like cheese grits too, and that was a bonding moment. Eat her grits and then go finish getting ready. She had really thick hair, so it took her forever to blow dry her hair, so usually she'll sit on the floor and flip her head over and blow dry her hair.
You went through that all really quick.
Sorry.
Really fast.
I'm sorry, yeah.
And so I'm going to ask you to kind of break that down
Okay.
one at a time. How would Tara start her day?
Shower.
And what would she then do next?
She would go make her breakfast.
And where would she go to make the breakfast?
Well, she'll go to the kitchen to make the breakfast, and then she'll probably sit on the sofa and eat it.
And at that time, after eating her breakfast, is that when she would go back?
Go back in her room and finish getting ready, yes.
You indicated that part of that included blow drying her.
Yes, she had a lot of really thick hair, and so she would have to usually sit on the floor because she would get tired of standing up. And we've lived together since my freshman year, so it was kind of a joke, her sitting down on the floor, flipping her head over, doing her hair all the time. So.
What time would she start her day?
Depending on the class, if she had an early class, she'd like a 9:30, probably 6:30, 7:30. She'd like to get everything ready and then study for whatever classes she had that day.
So that would kind of start that routine?
Yes.
Depending on what time the first class was?
Yes.
In kind of the last months of her life. Had you noticed anything significant about Tara's relationship with Chris?
No, I mean, I think she was frustrated they couldn't see each other as much. Of course, with her schedule and his schedule now working full time, like every girl, she wanted her boyfriend to give her a little bit more attention. But I mean, I think I had the exact same complaint about my boyfriend at the time. So it was normal conversations you have with your friend about their relationship. Nothing off or nothing that would have caused me to be alarmed in any way.
You feel like your relationship with Tara that you just described over the course of this afternoon, you would have recognized if there were...
Oh, yes. Yeah, like I said, Tara's very black and white. Like, we're not ones to share, like, maybe the little minute intimate, but we definitely knew what was going on in each other's lives. I mean, that was, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
Ashley, or Ms. Hall, I'm sorry.
Yes, sir.
I believe I have a motion, Your Honor.
All right. I'm going to send the jury out. If you'll have a moment in the jury room and don't discuss the case. Thank you.
Bye, Rhonda. See you later, Rhonda. Oh, here we go. She's already pissed.
Y'all may be seated. You have a motion, Mr. Cruz?
Yes, ma'am, and I'd just like to put the basis on the record. As the Honorable Court is aware, Mr. Faust has a restriction on his line of questioning that he could ask witnesses in regards to statements that Ms. Baker may have made to said witnesses. During the state's examination of Mrs. P.V. Hall, there's been intimations of, well, and I'll say what the exact statement was, that if something was going on, she would have told me. Well, we have evidence to the contrary, but as of right now, we can't confront that statement because of the Honorable Court's ruling. So before I move further with our motion, I would ask, would the Honorable Court reconsider its ruling in regards to our residual hearsay motion with the statements that we have that Ms. Baker shared through Ms. Ashley Peavy?
All right, thank you. Mr. Bolden, Mr. Yelman, shall you care to respond to the motion?
It's asking the court to reconsider its ruling on our 607 before we move forward with any other motion. Our residual hearsay motion. I mean 807, excuse me.
Your Honor, to the extent that the state has asked Ms. Hall to testify about anything that Tara may have said, I understood the court's admonition the first time and have intentionally stayed away from that. I don't think that I have failed to, or I've elicited any testimony that would, violate the rule that requires notification. So I don't know exactly what Mr. Cruz is asking.
All right, thank you. So first of all, your request for a reconsideration of a prior ruling is not properly brought in this manner. That's not an objection. And I think you're misinterpreting my prior order. And so I think it would be imperative, Mr. Cruz, to go back and review what my orders were about. If you want to file a motion to reconsider, you certainly may do that, and I will consider whether it is timely and whether I should take it up. But I think your interpretation of the court's order is not accurate.
It is accurate, Your Honor. The order that you gave...
I'm not going to argue with you, Mr. Cruz. I have made my ruling.
Well, sure. Well,
do you have any other objection before I bring the jury back?
I moved for a mistrial. And the grounds we're moving for a mistrial on, Ms. Peavy Hall was able to testify that Tara would tell me if there was anything going on with her and Chris Melton. We've submitted to the court and filed a residual hearsay notice to address those statements that were made. The Honorable Court advised us that we could not mention anything that Tara Baker told Ms. Peavy Hall in opening, and we cannot ask any questions related to that. Evidence has come into this case contrary to our 807 notice, residual hearsay notice, and we ask the Honorable Court to reconsider its restriction on the defense that is not on the state and allow us to ask questions in regards to that. The door has been open, Your Honor. We're just asking for fairness at this point.
Okay, Mr. Cruz, once again, you are misinterpreting this court's order.
I am not, Your Honor.
Mr. Cruz, I'm not going to argue with you.
Yes, ma'am.
I'm just going to tell you what the court's position is. You are misinterpreting this court's order. It would be helpful for you to go back and look at the order and to review the law.
It's not written.
Mr. Cruz, I'm talking now.
Yes, ma'am.
It would be very helpful for you to go back and look at the court's order and to review the law that the court used in coming to that decision. This is not grounds for a mistrial. I'm going to deny your motion for a mistrial. If you want to file a motion to reconsider and it is filed properly, I will consider whether it is appropriate for the court to hear it at this point. We will, of course, do it outside the presence of the jury if the court decides to hear it. But until that motion is filed, I'm not going to consider a motion for reconsideration in this forum. But I do think it is imperative for you, Mr. Cruz, based on your arguments, to go back and look at the court's order and the law and to interpret it properly. And that is going to be my final answer. Would you please bring the jury back? Thank you.
Can we ask her about it? That's what the court hasn't ruled on, Your Honor.
Mr. Cruz, it would be imperative for you to begin your cross-examination. If there's an objection, I'll rule on it.
Yes, ma'am.
Ms. Hall, talk a little bit about 160 itself, the house. Did y'all use the back door very often?
No, I think when we first moved, we might have looked out there, and that was about it. I mean, there's no reason to go in the backyard.
The window by the kitchen table, was that ever opened?
No, but I remember that it wasn't on the track correctly, so we could never really lock it. So I think we moved a chair back there, so thinking if someone walked in, we would hear it. But I think we did report that it was off track.
Did the three of you share keys with your boyfriend?
No.
Why not?
Like I said, we were very black and white on that. It was our house, and no boy should be there if we're not there with them. We were in law school, or grad school and law school, and just were busy, and we don't need just a random person being there, and we were very respectful of each other's place.
How did you learn of Tara's death?
When we left, my boyfriend's in Atlanta, we first went to Winder, and then I went home, but my cell phone, like back there, we did not charge them, and mine was dead, because we just didn't use cell phones like that back then. And by the time I got home, my parents met me at the door and said there was a fire. My immediate thought was Tara left a candle burning. She loved candles, and but then we had to load up in the car and go to Athens, and I think just you didn't believe it, because at that time we didn't know exactly what happened. We just knew there was a fire. So of course got to Athens and find out what happened, and I don't know. Some of it's kind of blocked out. I feel like your body shuts down when you get some type of that kind of trauma. But
Bear with me just.
no, you're fine. No, I'm here to answer whatever you need, both sides. But.
Ms. Hall, thank you so much. I don't have any further questions for you.
Thank you.
Cross-examination, Mr. Cruz.
Ms. Hall, I think the most important thing, and I think everybody in this courtroom would agree, I am tremendously sorry for your loss.
Thank you.
I'm going to ask you some questions. Some of the questions may be a bit difficult. Some of the questions may be a bit uncomfortable, okay? but I want to let you know I am tremendously sorry for your loss. I would like to start with talking about Miss Baker's life and how you knew Miss Baker, okay?
Okay.
I think we'd agree that Miss Baker was in law school, and she wanted to become a judge.
Eventually, yes. She wanted to do real estate law.
Is it fair to say that Miss Baker was known to have a keen sense of justice?
Yes,
Okay, and she would listen, hear things out before she would make a decision on something.
I agree, yes.
And would you agree, as you sit here today, you just simply want answers on what happened to Miss Baker?
Well, and we want someone prosecuted in
Correct.
crimes, yes.
But the right person. Is that
The
correct?
right person, definitely.
Yes, ma'am. So you knew Miss Baker in undergrad, is that correct?
That's correct.
And you didn't just know her in undergrad, you two went to college together.
We did.
And you two were roommates in college as well, is that right?
Yes, correct.
And not only in undergrad, which was in Milledgeville, but you also were roommates here at 160 Fun Drive.
Correct.
You would have no reason to disagree that if Miss Baker was here, she would say you were her best friend.
I would hope so, yes.
Ms. Hall, about a year and a half ago, do you recall being visited by law enforcement to discuss Miss Baker?
I do, yes.
And as a part of that discussion, they asked you about Miss Baker's relationship with Chris Melton. Is that
Yes.
correct? And you didn't know Chris Melton just through Miss Baker. You knew Chris Melton because he went to undergrad with you two
I
as
did,
well.
yes. I knew him before they ever dated.
And I believe Miss Baker and Chris met at Georgia College.
Yes.
Is it fair to describe Miss Baker as, and if I say anything wrong, correct me, okay?
Oh, yeah.
Goal-driven and ambitious.
Very much.
And is it fair to say that you told law enforcement that Chris was very aloof and the fun guy to date in college, but not long-term?
If that's what it says, then that's what I said. But yes, they had a lot of fun together, and I feel like they just didn't have a lot of time for each other at that time. So it was a possibility that, like relationships do, sometimes they end, but that's not to me. That's up to her. So I have no idea if they would have broken up or stayed together, and we never will. So.
Yes, ma'am. That's fair. And you may have answered this. I just want to make sure it's clear for the court reporter. You described Chris as very aloof and the fun guy to date in college, but not long term.
Well, that was my opinion. That might not have been her opinion.
Yes, ma'am. And Tara and Chris were a match you never thought would happen.
Well, because she was very serious, and he was fun, and what they got together, and it worked. So that's all that mattered. There's a lot of people, I'm sure, that, in your past, that they didn't look like they would work, and they were fantastic together.
And when you and Ms. Baker were staying at the Deer Park apartment, she was dating Chris. Is that right?
Correct.
Okay. And Chris would come over to the apartment a lot.
He would come some, but they mainly went over to his.
Sure. And I want to make sure that I use the right term. Do you recall telling law enforcement that Chris came over to the apartment a lot?
I don't recall, but if I said it, then that's what I said, yes.
So,
No,
I
that's
just want to make sure I'm clear from the record. Do you not recall?
Yes, okay, I recall I said that. I said it a lot. Like I said, I talked to many reporters and many people, so.
And Chris would sleep over as well, is that correct?
Some, yes.
Based on your personal knowledge, you don't know whether Chris had been provided a key to Deer Park or not. Is that correct? Excuse me, the Deer Park house or not?
Personally, no, but she would have, one, told us if she gave him a key, and two, none of us would have ever given someone else a key that was not on the lease.
Sure. And thank you for that. And just to make sure it's clear for the record, to your personal knowledge, you don't know.
Of course, no one knows.
Yes, ma'am.
So.
As Tara's best friend and that's her roommate. Would it be fair to say that you had an opportunity to observe her relationship with Chris Melton?
Yes.
Is it fair to, well, let me rephrase that. When law enforcement met with you, you told law enforcement, I think once she started law school, I think they started dividing a little. Do you recall making that statement?
I'm sure I made the statement. The only thing I would mean by that statement is that he was starting his full-time job, plumbing, and she was trying to study. So they just didn't have the time together. And as I said before, that was just frustrating whenever you don't have the time with the person that you're with.
Yes, ma'am. And you also told law enforcement, and I quote, I mean, there were cracks already that, it was just he was wanting more time, and she's like, hey, I'm in law school. Do you recall making that statement to law enforcement?
I'm sure I did if you said I did, but she was in law school. She was busy.
Yes, ma'am.
That's a fact.
Would you agree that you told law enforcement when asked about Ms. Baker's relationship with Chris Melton before her death, you stated, I think just the normal, you could almost see it was the normal, you could almost see the ending of a relationship, if that makes sense.
Well, that was my opinion, but does not mean that's what was happening.
Sure, but that was based on your...
No, it's just, as I said before, they just couldn't spend time together. And so it just looked like they're both busy. It did not mean one thing or the other. She was frustrated at the time. Again, does not mean that their relationship was ending. He was one of the nicest people ever. It was always sweet to her, never showed any anger toward her.
And you told law enforcement about the frustration around them not seeing each other, is that correct?
Yes, that's correct.
And is it true that you told law enforcement when you were asked, like they're starting to grow apart or he's getting on her nerves? Do you recall being asked that question?
I don't recall it, but if I said it, that's...
Would hearing...
But also you have to remember we were asked so many questions by so many times that it was getting on my nerves at that point. So sometimes I might have been a little abrupt.
Yes, ma'am. I know you mentioned that you don't recall it. Would hearing your interview refresh your recollection in regards to that particular question and what your answer may have been?
If it makes... Is there a reason for me to hear it?
Ma'am?
Is there a reason for me to hear it?
Sure, we could talk about it outside the presence of the jury, but at this time, the Honorable Court has only given me permission to ask questions.
Okay.
So would hearing your interview refresh your recollection into the question that was asked and your answer to that?
What exactly was the question, and maybe I can just answer it for you how you need it answered.
Yes, ma'am. You were asked by Agent Bigham, like they're starting to grow apart, or he's getting on her nerves? And your response was, I think it was just getting frustrated. Because, and I think they both were because she had to study so much. Do you recall making that statement?
Well, I'm sure I've made it many times, but yes, she did have to study a lot. And when he had time, a lot of times she didn't, and when she had time, he had to work. It was what happens when people start their real lives. You have priorities, and you just don't have the time to spend together. But that doesn't mean that he hurt her or did anything to her.
Yes, ma'am. Is that a yes or a no to my question?
Do I remember making that? Yes, okay, I remember that statement.
Thank you. Do you remember telling Elizabeth Bingham, and I think that was, once she started dating Chris Milton, and I think that they were kind of on the outs before everything happened?
Well, they just didn't have, not on the outs, they just didn't have the time together.
Do you recall making that statement?
I'm sure I made the statement. I'm just saying that they did not spend as much time together as they had previously.
Yes, ma'am. But you do recall making...
Yes, I recall making that statement.
Your Honor, may we approach?
Okay.
one other time. We are almost done for today, but if you'll go into the jury room, please don't discuss the case. Thank you.
Oh, so quick break for some reason. We'll see what this is about. Just don't ask for another mistrial, dude. Just don't ask for another mistrial. Fuck.
Y'all may be seated. Thank you. All right, go ahead, Mr. Cruz. And I have your motions that we were talking about. In general, I have all three of them that are pending. So I'm pulling up the one related to this witness. Go ahead.
As the number court is aware, on January 20th, 2026, Mr. Faust filed a notice of intention to introduce residual hearsay testimony pursuant to OCGA section 248-807 in regards to Ms. Ashley Peavy. In court's indulgence, Your Honor, my computer just froze on me. I have a hard copy, actually. From Miss Tara Baker that were made to Miss Ashley Peavy. The first statement that we asked for admission of is Miss Peavy stated in her interview with law enforcement that Miss Baker confided in her that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating. She didn't feel appreciated. The second statement from Mrs. Peavy Hall, please forgive me. Ms. Baker expressed frustration to Mrs. Peavy Hall, advising that Chris Melton wanted more time with her, but Ms. Baker was unable to give it. The third statement that we asked that the Honorable Court admit through Mrs. Ashley Peavy Hall is that Ms. Baker, the third statement, we asked the court not to consider that statement. We're asking about the first two. And the reason we bring this motion up, Your Honor, is because during direct examination, the state elicited testimony from Mrs. Peavy Hall where she stated that if there was something, and I'm paraphrasing, but if there was an issue in the relationship, Tara would have said something to her about it. I believe it was two other times, because the state didn't exactly ask these questions, it was the answers that was given back to them. There were two prior occasions I just didn't say anything to, but once we hit the third occasion, I asked the Honorable Court, could it consider or consider making a ruling on our motion or reconsider its ruling on our motion.
I didn't make a ruling on this motion. It's pending.
Well, the pending ruling was not to make any statements in opening about it. It was restriction on defense counsel not to ask any questions related to our 807 motion.
We had a hearing. That's right.
Well, until Chris Melton testified. And after Chris Melton testified, the Honorable Court said it would reconsider our motion at that time, which I respect the Honorable Court. I respect the Honorable Court's order. But once testimony has come in from the witness that we have a residual hearsay motion pending on that's contrary to what we know the evidence would show, We're saying in essence that this has now become competent and relevant evidence that we could use to impeach the prior statement given on direct of Mrs. P.V. Hall.
Steve, care to respond?
Yes, Your Honor, and I'll just cite, there's basically in all of the notes on decisions here, there's a very good first sentence to all of them. The residual exception to hearsay is to be used very rarely and only in exceptional circumstances. That holding is in Brooks v. State, 365, Georgia App 711. And frankly, Judge, I haven't had a chance to read all of these cases. These are just the notes on decisions. Thrift v. State, 310, Georgia 499. Miller v. State, 303, Georgia 1. Those are in order. I'm sorry, I should have done this to begin with. 2022 Court of Appeals case, a 2020 Georgia Supreme Court case, and a 2018 Georgia Supreme Court case. These are certainly not exceptional circumstances, Your Honor. What they are is a couple of statements cherry-picked about minor regular relationship complaints that parties would have in an effort by Mr. Cruz to cast a certain light on the relationship between Ms. Baker and Mr. Melton. This witness, and I would just state, the court heard the objection from defense counsel to statements similar to the statements he's attempting to admit, and it sustained that objection and directed the state to move away. Defense counsel is not seeking to admit the third notice statement. And if we look at the first two notice statements, I don't believe there's a way to interpret those as being necessary in creating some kind of exceptional circumstance. The witness has acknowledged that there were challenges in the relationship that were created by a lack of time, and has not denied. She may not be familiar with each statement that Mr. Cruz has read to her that are purportedly quotes from the interview that she had with the GBI in 2024, but she has acknowledged that they had her perception of things may have been that they were drifting away, but she didn't have the ability to get inside of Ms. Baker's head, and her overall view of their relationship was nothing that caused her concern. I failed to see, residual hearsay is an extraordinary exception. If we think about all of the exceptions to the hearsay rules, there are well over a dozen. And so when you're going into this catch-all category, especially in a circumstance where you are picking random statements that Ms. P.V. Hall has referenced in talking to law enforcement, and the only one that's close in time to the crime, the defense is not seeking to admit anymore. I'm not sure that there's been a date provided as far as when these statements were allegedly made by Ms. Baker to Ms. P.V. Hall. So that in and of itself, I think it's a failure to show how they would be extraordinary. This would qualify as an extraordinary circumstance. We don't even know the temporal relationship to these statements. You go inside any serious long-term relationship or any marriage, and if we're going to pick out times where one party or the other made some kind of statement about being frustrated by the conduct of the other party, that certainly wouldn't be an extraordinary circumstance. And that's exactly what Mr. Cruz is describing here, Your Honors. I don't think the court should let it in under 807. The only other cases that I've seen, Judge, and I can look back and find them again, but when we looked at it when the notice was filed, most of the statements that I saw had things to do with statements directly related to the crime, either made by the decedent or made by some witness who was unavailable, not through any kind of wrongdoing of the party who is trying to admit that residual exception. And so I'm unaware of any case where a criminal defendant who is on trial for the murder of the declarant has been allowed under the residual hearsay exception to admit statements from them. I don't think Mr. Cruz is citing any case. There may be one out there. I'm not saying that, and that's not even really the determinative factor for the court. But I've not seen any cases where it was admitted in any circumstance that would be anywhere close to this.
All right, thank you.
May I respond, Your Honor?
Okay.
In regards to the exceptional circumstance, Ms. Baker is not here to speak for herself. As the state has clearly said multiple times, my client is the individual charged with Ms. Baker's death. So I have the burden of not only getting justice for my client, but also Ms. Baker. We're presenting the evidence that the state had and did not use. The exceptional circumstance is the state had all this evidence of Chris Melton's guilt for 24 years and ignored him. Even today, when I've given them, I've given you your own evidence, they still continue with the prosecution of Mr. Faust. Our position, on the court knows this, is that Chris Melton did this. We're presenting the evidence to establish that Chris Melton committed this crime, and a part of that evidence is Ms. Baker herself saying, hey, these are the issues, or these are my feelings about my relationship with Chris Melton.
Okay, thank you, Mr. Cruz. All right, so I'm going to move backwards from 3, 2, and 1. First of all, number 3 has been withdrawn by defense counsel, and I've noted that in the motion, and I will order it withdrawn, and that will not be allowed. Number 2 is, has already been testified to by this witness, and so I'm going to deny your motion on number 2. This witness did articulate what you are seeking basically to introduce in number 2 of this motion, and because of that, your motion does not meet the standard for the court to grant you the ability to have any of those statements introduced under 807. With regard to number 1, I think what is important for me to tell you is that the state's comments that your request, Ms. Tara Baker confided to Ms. Ashley Peavy that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating, she didn't feel appreciated, is very vague and general in nature. I will let you at this moment, in support of your motion, voir dire question this witness about that moment that you seek to introduce. It's outside the presence of the jury. The court cannot make any determination about your request because of the vagueness of that particular statement. I don't even know what the statement is that you're seeking to introduce. The way that you have written it in the motion, and you may have just done it to put the court and the state on notice, and that's fine, is a general sense of what you're insinuating.
Sure.
But I know you're asking to introduce a specific statement.
Yes, ma'am.
I'm going to ask you to, if you choose to,
Yes, ma'am.
question this witness outside the presence of the jury about what it is you want this court to admit, the specific statement, but it also needs to have the specific supporting testimony, the foundation that Mr. Yalamachill was referring to.
Yes, ma'am.
Because it is not proper under 807 for the court to admit statements that are not particularized, that are not associated with something very specific. Just sort of a general request is not appropriate under 807. And so in the context that perhaps you were just giving the court notice of what you wanted, I'll let you voir dire or question this witness if you choose to, and then I'll let you cross-examine, sort of, or redirect, or whatever you want to call it also, and I'll make a decision.
Sure. Thank you.
And that's with regard to number 1 in your motion.
Thank you, Your Honor. Mrs. Peavy Hall, Agent Bigham asked you, what was she telling you about their relationship? And she is Ms. Baker. Do you recall that question?
Okay.
Do you recall that question?
Yes.
Okay. And your response was, your response to her question of what was Ms. Baker telling you was Some of it's just guy stuff of not being considerate. You know, the girl's doing so much and feel like the guy's not reciprocating. Is that correct?
Yes.
Okay, and that's what Ms. Baker told you. Is that correct?
Yes, correct.
No other questions in regards to number 1, Your Honor.
All right. Mr. Yelman-Chile, do you want to ask any other questions?
I don't have any questions.
All right, thank you. All right, Mr. Cruz, you haven't laid the foundation. I mean, I don't know when these statements happened. I don't know what circumstances the conversation you're asking to introduce happened between the victim in this case and this witness. It's a general conversation. You haven't laid the foundation. I'm going to deny your motion.
Yes, ma'am.
You may bring the jury out.
She could also have said, can you please lay foundation? Because some judges don't like to lay foundation. Just get straight to what do you want to get out of this. Next, I need to get rid of Bex, Lady Di, Katie, James, Hippie Chick. Oh shit, I'm unmuted. Fuck. Scrap all that.
Your bill leading up, ma'am, thank you. Your opinion of Ms. Baker's relationship with Chris Melton was that Chris Melton was not treating Tara well leading up to the time of her death. Is that correct?
My opinion was she was frustrated, but that does not mean that he wasn't treating her well.
Do you recall telling law enforcement he liked to flirt with other girls and everything else too?
Well, not everything else too. That probably was a little bit extra, but he was very friendly, but so was Tara. They were both very happy, friendly people and talked to everybody.
My specific question is, did you tell law enforcement that he liked to flirt with other girls and everything else too?
Yes to your question.
And sometimes you would hear Ms. Baker express frustration about her relationship with Chris Melton. Is that correct?
I'm going to object to hearsay, Your Honor.
All right, here to respond to the hearsay objection.
I do. I'm not asking for a statement. I'm just asking for the witness's perception based on information given to her.
All right, I'll allow it. Go ahead.
Is that correct?
It's correct. We usually talked about being frustrated with our boyfriends, yes.
Okay. And not only would you hear Ms. Baker talk about it, you told law enforcement that you witnessed it for yourself. Is that fair?
I'm sure I did.
Now, we've agreed, or I believe we've agreed, on a couple of things regarding your knowledge of Ms. Baker's and Chris Melton's relationship. But based on your friendship with Ms. Baker and you being Ms. Baker's best friend, and I think we all would agree, I think both sides are on the same page that you were the person that she considered her best friend. Is it fair to say that Ms. Baker was not the type of person to speak ill of Chris to others to avoid making him look bad?
To a point, yes, probably. But she would still, if something really bothered her, she would have said something.
Just to make sure I'm clear for the record, in regards to my question, and if you can, just yes or no, but you can always explain. Is it fair to say that you describe Ms. Baker as the type of person that would not speak ill of Chris to others to avoid making him look bad?
Yes. She would also do it for me too, probably. But
now, again, I want to go back to Ms. Baker as the person, because I think that's the most important thing, tied with the most important thing in this trial. You would agree that Ms. Baker was not a pushover.
no, she was not.
She was very assertive.
She was quite assertive.
But she would speak her mind. If something was wrong.
Well, yes, but yes, she was not pushy. She was not loud.
And even as best friends, you two would get into disagreements.
Of course.
So it is fair to say that she's assertive, not timid. Is that correct?
She had things she was timid in.
Okay. But just speaking her mind.
She would have to be very, either something upset her to where she had to speak her mind, but she wouldn't just say something to somebody to say it. Like, she was not one to insult somebody, even if she had a different opinion.
That's fair. Do you recall law enforcement asking you about racial biases of Ms. Baker?
Yes.
Okay. And is it fair to say that you advised law enforcement that she did not have any racial biases?
I did.
But you did say if you did her wrong, she might not ever forgive you.
I did, yes.
Were you aware of the incident the week before her death between her and Chris Melton?
This was 25 years ago. You have to do a little bit more than that. So.
Sure. As you sit here today, are you aware of a disagreement Ms. Baker and Ms. Melton got into, Mr. Melton, the week before her death?
I know she was frustrated with him, but we did not discuss exact details.
Okay, just to make sure it's clear for the record. Are you aware?
I am not aware of the exact confrontation that they had.
Yes, ma'am. Now, with these lines of questioning, I'm going to ask you some very personal questions, but I am not going to mention the topics. I'm not going to dig too deep, okay? So I'm going to speak in general terms. Is that fair?
Yes, sir.
Okay. During your interview with police, and again, I won't mention the topics, but do you recall being asked some questions about your knowledge of Ms. Baker's innermost private life?
Yes.
Would you agree that you told law enforcement, or let me change that. Would you agree with the statement, people do things without telling people, it doesn't matter how close you are?
I agree with that.
You would also agree with the statement that there are certain things, if they occurred, Ms. Baker would not advertise to anybody.
That's.
Can we approach?
You may.
Your Honor, I would ask if there's objection. The state just makes the objection, Your Honor.
Well, y'all been coming to the bench this entire time. So why don't y'all come up here and I'll make a determination of whether we do it here or I send the jury out. Yes, sir. Hold on.
Okay, she has to switch the mic off. I just want all witnesses to be truthful, whether it's the defense witnesses, prosecution witnesses, anybody. Just don't add extras in, just be truthful.
It's 5 of 5, and I am going to take up another thing outside your presence. I'm not going to make you go back in and come back out again. I'm going to send you home for the evening. It's 5 of 5. I am going to ask you, of course, to recognize the rules we've talked about ever since you've been coming to this court. Don't discuss the case with anyone. Don't do any independent research. We have been related you to the. We're going to start. We will get started. Thank you. Just like a deputy that's going to escort you to the elevator, going to take you down the elevator, and escort you all to the parking deck. When you come here tomorrow morning, we're going to start right at 9 o'clock. Again, just like you did today. Come straight here, go straight.
To be fair, he is allowed to lead, James. He is crossing, so he's allowed to lead on it. Right. I just hope everyone's just fair on it. I can say, I don't care what witness you are, just be truthful. That's all. Right. Let's wait to see where else is it coming back. Right, here we go. Lisa Lawrence.
I want to sort of go back for a moment with regard to the motion of residual hearsay that the defense filed and that we've kind of heard argument on today, even though it was pending. The motion with regard to this witness is denied. Number 3 that the defense asked for was withdrawn. I've already made my comment about number 2. The second prong of the motion. But with regard to number 1, the first prong of the motion, I did deny it, but I want to elaborate for the parties why I denied the motion. The law requires, and I'm making a finding the defense did not provide this, the law requires, of course, that there be a sufficient foundation laid to provide that exceptional guarantee of what the law mandates, exceptional guarantee of trustworthiness. There was no statement under a belief of impending death or any statement against interest, which the statute, of course, refers to. That really isn't what this statement was about, but that wasn't present here. I did make it clear to defense counsel that the court needed a foundation about timing, about context, and things of that nature in order to assess the appropriateness of the motion that was not provided. And so those are the reasons that this court did not grant your motion that you filed with regard to this witness to introduce residual hearsay. I'm making a further finding that it did not violate 403. There was no showing that the testimony was relevant, as the witness in this particular motion did not deny the statement she made to law enforcement. And even if it was relevant, there was not a sufficient showing that the probative value was substantially outweighed by the danger of unfair prejudice. And that is my finding on that motion. All right, let's talk about your objection to Mr. Cruz's question. Go ahead, and then, Mr. Cruz, you may respond.
Well, Your Honor, it is an objection to any questions, which was the line of questioning that Mr. Cruz seemed to be headed down, that could touch on acts or inferences to be made to the jury by his questions that would violate the court's previous order regarding 412. Mr. Cruz is asking questions about the most intimate details of Ms. Baker's life. He is asking Ms. P.B. Hall questions about there may have been things that Ms. Baker has done that she wouldn't tell anyone about. And the state's fear is that Mr. Cruz is going to continue down a line of questioning that would result in trying to, which is barred by 412, it's cross-examination, but direct examination, cross-examination, or any evidence of any kind is barred that may touch in any way on any type of past sexual conduct of the victim. And I believe that that is what this line of questioning is. So it is a motion in limine asking Mr. Cruz not to continue down that line of questioning, which is barred by 412.
All right, thank you. Mr. Cruz.
I truly don't know what to say, Your Honor. We have a right to cross-examination. The state clearly just...
I can hear him.
Sure.
You hear him?
I just told me I need to use this when I speak. But I truly don't know what to say. The state just stated that I guess they believe, not that I've done anything, but they believe my questioning is leading to 412, which led them to request a bench conference that I wasn't, that I wanted to continue my cross-examination. They could have made their objection on the record. This isn't an objection. This is the state saying, hey, Judge, please curtail his cross-examination. We just don't like where it's going. The court has made it very clear what I can't. I'll say this. The court has given me 2 examples of what is off limits with 4012, and I understand the statute as well. This is, again, in essence, the state just saying, Judge, we don't like this line of questioning. We don't like where it's going. It violates 412, so put a restriction on them. And he even just asked for it. He said, Judge, this is a motion in limine asking you to put a restriction on Mr. Faust regarding his line of questioning. Your Honor, I am exhausted. I used to love coming to court every single day. This was my childhood dream. I am starting to just, me and Mr. Faust, it's a war of attrition. We're just dragging through this case. We're just dragging through this case. I would ask, Your Honor, that you rely on the law, the 412 statute. I'll prepare a brief if you want me to. Our office will put it together regarding 412 and what the cases say about Rule 412. I would ask that you deny the state's motion, and if we put anything in place, that the state, if they have a valid objection, make an objection. If I violate the court's order, the court can hold me in contempt if I violate the court's order. I understand what the court's order is. The only thing we're trying to do, Your Honor, I'm trying to get justice for my client. I'm trying to get the truth for the family. We're just trying to litigate a case. I would just ask that the Honorable Court allows us to litigate this case pursuant to the rules of evidence and not the preferences of Mr. Yalamachili and the state.
Thank you, Mr. Bruce. So I want to ask you if I can get an understanding of your line of questioning that you're asking to be admissible. Where were you going with those questions?
Your Honor, these are exact quotations of statements that she's made made to law enforcement. If the Honorable Court wants to know exactly where I'm going with that, I could do it outside the presence of I would ask to do it outside the presence of the witness.
All right, fair enough. Could I have you, well, actually, I don't think we need this witness now at all, unless there's something else we need to discuss with this witness.
That's correct, Judge.
All right. I'm going to ask that you return tomorrow per your subpoena, and you're free to go for now. Thank you.
She's got to go straight home, put Law and Crime on, and watch the stream to see what's been missed.
Go ahead, sir.
Yes, ma'am. The sole purpose of this line of questioning, Your Honor, is summed up in one sentence that we were going to use in closing, that Tara did not share intimate details of her private life. So what the state just did, stopping the cross-examination, was to prevent us from saying one sentence in closing. And that sole sentence, Tara does not share intimate details of her private life. I would ask that a restriction is put on the state. They are more focused on convicting Mr. Faust than finding out the truth and letting the evidence stay where it needs to stay. The evidence speaks for itself. Mr. Yalamachili doesn't have to speak for the evidence. I don't have to speak for the evidence. The witnesses can come in and present the evidence. I have a double burden on me now, right? I have to make sure this family finds out what happened, what evidence we have, but I also got to defend Mr. Faust, knowing that anytime he gets any traction, the state jumps up. Judge, stop him from doing this. Judge, hold him in contempt. Judge, we object to this. Your Honor, I just ask that we have opportunity to present this case. I respect the court, but it is hard to drag on every day knowing Mr. Yalamachili at any given time, just any given time, is going to jump up and make some type of objection, run up to the judge and say, Judge, he's doing this, stop him. We just want to present our case.
Okay. All right. So first of all, I think that both counsel have jumped up and, in your words, made objections throughout the case from beginning to end, and that is fine. That is what lawyers do. I don't think one side is doing it more than the other. And so I think that the record needs to be accurately reflected. So let me say that first. The second thing I do want to ask you, Mr. Cruz,
yes,
is, are you asking permission? I mean, I realize that you didn't intend to ask permission, but I'm asking you now, sort of in the context of what we're talking about. Are you asking permission to ask that witness, is it true that Ms. Baker did not share all the intimate details of her life with you? Is that what you're asking?
What I'm asking is the Honorable Court to protect Mr. Foster's right to cross-examination.
Mr. Cruz, I certainly will do that, but we are really getting into the weeds with regard to this motion. It's very necessary. So that's my question, is that are you asking to be able to ask that question?
Let me ask this question. Is the Honorable Court saying that I need permission to ask that question?
Well, not necessarily, Mr. Cruz, but I'm trying to get at the heart of this matter. So this is kind of where we are.
Sure.
And we have been talking about Rule 412 for days. We talked about it a lot before this trial started, and we talked about it a lot this week. And I guess I'm just going to repeat what I said the other day, but I'm just going to repeat it. When the state filed their motion and the court heard arguments from both sides about 412, the defense noticed in court orally to the state that the only person that they would seek to introduce evidence with regard to 412 was Chris Melton.
That motion is in writing, Your Honor. We filed a written motion in regards to that, and we had a hearing and the Honorable Court granted it.
Okay. The motion was initially by Mr. Yalamachili. I'm talking about the verbal notice that you gave to the state during our hearing that that's what you would do. Okay? I mean, that's what happened. And we discussed this in court, and you made it very clear that that was the only person you were giving the state notice for. And based on the defense's not giving notice to the state about any other persons for us to be able to talk about whether that would be appropriate, that's kind of where we are. And so every other discussion about any other exception to 412 was prohibited. That's the prohibition, right? And I've said many times that if you, for whatever reason, felt that you needed to change your response, you could file a motion, and I would determine whether it was timely and we would hear it. And so that's where we are. The Chris Melton questions are not off the table. You gave notice to the state that you would seek to introduce evidence about the relationship of Tara Baker and Chris Melton. I mean, I think that's that's not open for debate. And so I think and Mr. Almachilli, I don't want to put words in your mouth either, but my sense of your objection is that you are, once again, concerned that the defense is trying to elicit testimony, either directly or by insinuation, that other persons' behavior or relationship with Ms. Baker could be introduced in violation of 412. Is that a fair statement, or is it something different?
Yes, Judge, that's correct. The way the line of questioning was progressing, it started with a question about Ms. Baker not having a racial bias against any persons. It then immediately went into the realm of intimate details about her life that she wouldn't share with anyone. And so in conjunction of those things, it seemed very clearly to me that there was at least a risk that Mr. Cruz was going down a line of questioning. Now, I think we excused the witness so that Mr. Cruz could proffer to the court what his actual questions would be, which he did not do. He just referenced that the questions were in support of something he was going to argue in closing, which I'm not asking him to give us his closing argument. It's just the direction in that these questions are going. If they're relevant for some other purpose, or I misinterpreted the direction they're going in, then I apologize, Judge, but the state is acting out of abundance of caution. Violations of 412 are serious things, and you can't necessarily unring that bell. It happened twice in opening statements. So when we see a direction that Mr. Cruz seems to be heading in, I'd like the court to take some action, either to, again, instruct Mr. Cruz that that is not relevant or admissible. I guess relevant wouldn't be the right terminology. It's not admissible or proper to inquire into due to his failure to notice the state. And as he said before, there's no evidence to that fact. So, Your Honor, that's the basis of the state's motion in limine. And so I don't know what additional questions Mr. Cruz was about to ask, but it seemed like we were getting to the point where he was trying to skirt that line again.
Okay, and I'm going to ask you a question, Mr. Cruz, and I'll certainly let you respond. The state didn't object to the relevance of the question about whether Ms. Baker had a feeling about race relations or anything of that nature, but I understand, based on the context that you're arguing, that you're referring to the relevance of those questions. So I guess, Mr. Cruz, that's where the court needs to hear, I guess in terms of a proffer would probably be best. What is the reason you're asking those questions?
Sure. And I don't mind giving it to the Honorable Court. I would just ask moving forward that the Honorable Court puts restriction on the state, because I think this is the second or third time I've had to proffer our strategy to the state. I have not once asked this court to intervene to tell me where the state was going with their examination. I do believe if
that's true, though. He shouldn't have to proffer. If she wants to proffer, then it should be done just to her, not in front of the state, because he's given up his strategy in open court. He shouldn't have to do that. What should happen if she's a good judge to be like, look, you know what? Let's all take a break. Let's all go home. Tomorrow morning, defense, why don't you come in 10 minutes early, come and meet me in my chambers. We'll discuss things and we'll put stuff out on court. I'll make a decision based on it. Not having to tell the state everything. Also, the state should never have objected in the way they did, because you don't know where he's going. If he does it, then yeah, he should be reprimanded. If he oversteps the mark, he should be reprimanded. So, you know, he knows the line is. If he wants to push the line, then yeah, absolutely, he should be contempt of court again. But he's not there. So let him hang himself if he's going to do that. You know?
Violates Mr. Faust's
Let me just
right.
answer that real quickly.
Well, Your Honor, it
I'm gonna
violates
let you
Mr.
talk,
Faust's
Mr.
rights
Cruz.
to a fair trial.
Okay, hold on, Mr. Cruz. I'm going to let you respond, but I want to respond to something because you've used this word many times. You keep saying that the court has put restrictions on the defense and not on the state. Mr. Cruz, the court doesn't do that. The court listens to motions and makes rulings according to law, and those rulings are the restrictions themselves. And so it is it is a tremendous mischaracterization of what the court has ruled on and the reasons why to simply say the court is putting restrictions on the defendant. That is not appropriate. And I know that you know that. The court has heard motions. It has made rulings which you may very well disagree with, and I certainly understand that. But the court doesn't put restrictions sort of unilaterally on any party. It listens to motions. It looks up the law and makes rulings to the best of its ability based on those motions and the law. And so the restrictions you're referring to are based on those decisions. So I want it to be clear that this court is not putting restrictions on one party over the other, but it is simply the result of rulings that were made according to law. Now,
Judge, may I?
You may.
Denied motions that they've consented to because, in my opinion, they benefited Mr. Faust. We had a motion to suppress that you denied that the state consented to.
Mr. Cruz, I want to stop you there because you know very well that is completely disingenuous.
That is
Mr.
not
Cruz,
disingenuous.
I'm talking right now.
Yes, ma'am.
You know very well that what you are referring to is actually completely inaccurate. There was, and we are not going to relitigate motions, but I certainly want to make sure you understand that I know that that is not that is a tremendous mischaracterization of what happened. We had a hearing on a motion to suppress that you filed, and the state consented with the defense about one of the allegations. And this court said, that's fine. Provide the court with a stipulation and I'll sign it. I don't have any problem with both parties consenting about part of your motion. That stipulation has not been entered, and I believe that was because the defense has not provided the stipulation to the state. You can respond about whose fault that is, but I don't have the stipulation. But I also denied the rest of the motion to suppress based on the evidence and based on the law. But the one moment you're referring to, Mr. Cruz, and you know this, where the state and the defense consented about your allegation in the motion to suppress, and I supported that. You know that. You know that to be the truth.
I do not.
It is not appropriate for you to continue making a statement that is false.
That's the truth, Your Honor. The same day we received the order denying it, we didn't have opportunity to put a stipulation in because after our motions hearing, either that day or the next day, the Honorable Court issued an order denying all our grounds for the motions.
Mr. Cruz, that's not accurate. I would have accepted any stipulation because I ordered you to provide it to the court. And if both parties still want to give it to the court, it'll be part of the record. It is on the record. It is on the record that will be transcribed. And so that stipulation has been entered and approved by the court, even though it's not in writing. But it has been authorized. Let's move on. And if you would proffer for the court what it is you are seeking to admit, I can make a decision as to whether it is relevant and whether it is admissible. I just don't know what you're trying to do.
The state had opportunity to present the testimony of Ms. Lauren Sherling. Ms. Sherling came in and testified, and the state elicited this testimony that there were no issues in the relationship with Chris and Tara based on, I think the state explicitly asked this question, based on what Tara told you, what was her, I'm paraphrasing, but pretty much what was the nature of her relationship with Chris Melton And, what was the nature of the relationship between Chris Melton, please forgive me, Your Honor, Chris Melton and Tara Baker? And her testimony was that it was good. The line of questioning that we are going down to separate Mrs. Ashley P.V. Hall, who is actually her best friend, not Miss Laura Sherling. Mr. Sherling, I think, knew her for 6 months, is that Ms. Baker, one, and we elicited this when she was testifying, one, she wouldn't talk bad about Chris to other people because she didn't want to make Chris Melton look bad. So Ms. Sherling, who was a 6-month friend, I tell you, I hate to even have to share this because this is what we talk about in closing, but I'm following the Honorable Court's order. Ms. Sherling, who was a 6-month friend versus someone who went to undergraduate with this young lady and who says, hey, these aren't things she would tell people, is exactly what we're using to build our defense in Mr. Faust. It is extremely important if the state wants to bring a witness in here and have them testify to something, that we're able to rebut that. Our position is this, Your Honor. We have the same evidence. I have introduced nothing new. So when the state calls me disingenuous, and I took that I couldn't believe it. When the state calls me disingenuous, but they have all this evidence that they're excluding, they don't want the family to see, they don't want the jury to see, and we have to present it, and then when we are presented, they come up to the judge and say, Judge, he should preview where he's going. I believe it's 412, but I don't know if it's 412. That is an issue, Judge. It is hamstringing Mr. Faust's defense.
Okay.
The only thing we ask is the court says, hey, state, do your job. If you want to prosecute Mr. Faust, present the evidence. Don't come at the attorney. I've had personal attack after personal attack from Mr. Yalomachili, and I haven't even... I have never gone out of my way to say anything ill about Mr. Yalomachili. Even when I see him in the hallway, I speak to him, I'm polite, but I know when we come in court, at some point, Mr. Yalomachili is going to get up and accuse me of something or either ask for me to be held in contempt. Your Honor, we're just asking to present the case. That is the basis of our questions. We just want a sole sentence and a sole argument that says that Tara Baker does not share the intimate details of her private life. So when the state does their closing and they say, well, you heard from Ms. Sherling that the relationship was great, we would have put testimony into the record that, hold on, don't listen to that. This is her best friend, and her best friend is saying Tara Baker was a private person. That's where we're going with our line of questioning, Your Honor. But I would ask in the future that the Honorable Court, if they have a lawful objection, even if they want to make an unlawful objection, they just do it in their place. If it's an issue that the Honorable Court feels, if I'm doing something wrong, Your Honor, you are the power in this courtroom. You are the ultimate power in this courtroom. If I'm doing something wrong, Mr. Yalomachili isn't the one that has to get up and say it. You could tell me. You could say, Mr. Cruz, that is inappropriate. Mr. Cruz, you can't have that line of questioning. When the court gets involved for Mr. Yalomachili, it's when he has a lawful, or even if he wants to, an unlawful objection. But an objection. That's all I'm asking, Your Honor. But that is the proffer in regards to the reason for that line of questioning.
Okay, thank you. I still don't have my question answered. So I'm going to ask you some questions.
Please forgive me.
All right. Well, I mean, there's a lot going on. And so, but I need to be able to address the state's motion. All right. First of all, with regard to the objections for both parties, it is easier, of course, to handle objections right from your place. But both parties have asked to come up to the bench a lot. I'm okay with that, given the kinds of objections you all are making. I know that there are certainly things you don't want the jury to hear, and I am not there are some rulings I want to make that I do not want the jury to hear all of the things that I say, because I think that would not be helpful to either party. And so if you want to continue asking to approach the bench, I'll entertain it. If you don't want to do that, that's fine. I mean, I'm going to leave that up to the attorneys. What I don't understand, Mr. Cruz, is this. The issue with Mr. Melton is different than, I think, Mr. Yalomachili's motion. Mr. Yalomachili's motion alerted the court again to a line of questioning that would seek to admit testimony about other people. Quite frankly, that's it, other people. And that is my question for you, Mr. Cruz, is the line of questioning that you said about whatever the statement was, and I didn't write it down, about race relations, and about
I can answer the question. I know where you're
that's what I need to know. Is
Sure.
And I think, that is what we're talking about.
That is fair.
When we're talking about
That is-
412.
That is fair.
Go ahead.
So a part of my examination of Miss Ashley Peavy Hall, something that I found that it was very important to do was to show how great of a person Miss Baker was. I've read this entire discovery file. Me personally, and I'm not a witness in this case, from what people said, she was a really kind and amazing person. She was assertive. She was straightforward. She didn't have any biases. And I said it to the witness. I said it to the Honorable Court. Let's talk about Miss Baker's life. I said it in opening. That's all I'm doing, Your Honor. But they've taken me talking about Miss Baker to say, well, Judge, he's going down this line. Anything I've said.
Well, I need you to answer my question.
Sure.
Mr. Cruz.
It's about who Miss Baker is as a person. The state has not tried to present Miss Baker as a person during this entire trial. They focused on trying to make him into a person guilty of her murder. My job is twofold, as I mentioned, Your Honor. I want the family to know the truth of what happened to their daughter, and I also have to defend this gentleman here. And if the jury believes he's not guilty, let him go home.
Okay. Mr. Cruz, I understand all that. I do. You've said that many times. I understand that it's your position. But you haven't answered my question. And this is what I need to know. Very specifically, Mr. Yalamanchili's motion, his objection, which he has made many times since we started, were objections to either statements about other people or statements that appear to lead to that line of questioning. That's my question for you, Mr. Cruz,
That's very vague because they've taken a question about Miss Baker and turned it to a 412 argument, Your Honor. So maybe I'm not understanding the Honorable Court's question. I thought the Honorable Court was asking me to explain the purpose of the question about her racial.
I am.
Correct.
I'm not getting the answer. That's why I'm keeping
The answer to that question is through Miss Ashley Peavy Hall, her best friend. One of our goals in this examination is to show the jury who Miss Baker was. We talked about her being a law student. We talked about her being ambitious. We're giving them a profile. The state hasn't given anybody a profile about Miss Baker. But I'm doing it. This is a 24-year-old, 25-year-old cold case. I don't think Mr. Faust is just a victim. I don't think Miss Baker is just a victim. I truly feel the family is a victim too. So what I'm doing is at least, okay, jury, this is what you need to know about Miss Baker. We're going to have a time where they get to know about Mr. Faust, and then we're going to get into the prosecution. We're getting into every aspect of this case. So in regards to your particular question of why we asked about race is to give the jury a piece of a profile to Miss Baker. We asked about her education. We asked about her ambition. We asked if she was goal-driven. We asked about her personality. Was she assertive? We even asked about their relationship. Did you two butt heads? I don't understand, and maybe it's just me, how we get from he's talking about Miss Baker to he's talking about her character under under Rule 412. I'm flabbergasted. My mind is blown. I don't even know how we get to this point based on the questions that I'm asking.
Okay. Mr. Cruz, let me ask you this. Why is your question about how Miss Baker felt about race relations relevant?
Because Miss Ashley Peavy told the detective that everything that she told the detective about Miss Baker, we're introducing. That honorable court.
What are you asserting she told the detective about that?
That she wasn't. She had no racial biases.
Okay.
Is that? And maybe I'm wrong, Your Honor. Is that sexual? Am I being inappropriate by my line of questioning? And I think that's what Mr. Yalamanchili is bringing up to the court.
Well, okay. Now I understand what you're saying. I'm going to let the state respond, and then I'm going to respond. Mr. Yalamanchili, do you want to say anything else now that we've kind of gone through this moment and there's been a specific comment about a statement that was made in an interview?
Right. Well, it's not the question about race relations and the fact that Ms. Baker was not racist. I mean, that's not the issue. The issue is immediately thereafter.
Mr. Cruz, I'll let you respond. You got to let Mr. Yalamanchili speak too. You can't have two people talking.
Immediately thereafter, Mr. Cruz went down the line of questioning with no segue, no change in topic or anything like that, saying, would Miss Baker share the most intimate details of her life? And then aren't there things that Miss Baker would never tell anyone, even if she did them, was essentially the question.
Okay.
I'm paraphrasing just a little bit.
Okay.
And Mr. Cruz is headed down that line of questioning, which seems to go down lines of questioning that try to toe the line around rape shield and create the impression that Ms. Baker may have engaged in some other types of relationships that Mr. Cruz would like to put in the jury's mind without following the appropriate procedures. And I mean, as the court says, asking the parties to follow what the law requires is not handcuffing anyone. It's just applying the law to these proceedings. I would also note that from a relevance perspective, because someone told the police something doesn't make it relevant or admissible in court. So I would respond in that way to that.
Okay. You wanted to say something, Mr. Cruz?
If I may, just to, I guess, kind of summarize things. I hear where Mr. Yalamanchili is coming from. I believe that, first, he has not made an objection to anything that Mr. Cruz has actually said. I want to note that at first. Secondly, I will like to note that it seems, so any comments or questions that have been asked about her intimate life at this point, her intimate life can entail a number of things. It could potentially include sexual things, but it could also include things that are not particularly sexual. At this point, I do not believe that Mr. Cruz has asked any questions that have actually been objectionable. So any objection at this point, I do think would not be ripe. If Mr. Cruz does get to a question that is objectionable, I think that then Mr. Yalamanchili's objection would be appropriate. But at this point, I do not believe that Mr. Cruz has made an objectionable statement or asked an objectionable question. So I would respectfully ask the Honorable Court to deny his request. And Mr. Cruz, I think through this conversation, is reminded of the court's admonitions around 412, and I'm sure he will be mindful of that as he proceeds moving forward. But at this point, I do not believe that he has asked anything objectionable, and if he does, then the state can make the appropriate objection.
Thank you. Is it Hall or Hill?
Hill.
Thank you, Mr. Hill. All right, Mr. Cruz, anything else you'd like to tell the court?
I just don't know what to say, Your Honor. Our cross-examination was stopped just for Mr. Yalamanchili based on his belief that this was a 412.
Oh, dude, just sit. Just sit down. There's no need for you to say anything. Attorney Hill said all he needs to say. Just sit. Just sit. The defense just needs to sit down now. He's just got, that was a good ending by his partner. Just sit. I'm cringing right now. Just please sit down.
Issue. Another thing I would say, Your Honor, is Mr. Faust doesn't feel protected in this courtroom. I don't feel protected in this courtroom. And I feel that the Honorable Court has been leaning extremely favorable to the state. I've been nothing but respectful to the Honorable Court. I've been nothing but respectful to Mr. Yalamanchili's case. Anytime I've approached the bench, it's been because there were sensitive issues that I did not want to address to the jury. I've never once approached the bench and say, hey, Judge, I think they're about to do this. Let me stop them and let me send the jury out. One thing I'd ask, Your Honor, is Mr. Faust is on trial. Constitutional protections apply to Mr. Faust. Mr. Faust has the right to effective assistance of counsel under the Sixth Amendment. He has the right to cross-examination under the Sixth Amendment. He has the right not only to effective assistance of counsel, but his choice of counsel. Your Honor, right now, we don't feel this trial is fair. I'll just say in my place, I do believe the Honorable Court is going to grant his non-objection, so I'm sure I won't be able to ask these questions, and I'll make do with whatever I'm allowed to do. But, Your Honor, I respect this Honorable Court. I would just ask, there's a gentleman here fighting for his life. He is fighting for his life. He has no hope. You're his only hope. We're just asking that we have opportunity to present our case, and if Mr. Yalamanchili has an objection that he needs to make, just make the objection. And if the Honorable Court finds that it's lawful, stop me, and I'll stop. That's all I ask, Your Honor.
All right. Thank you, Mr. Cruz. All right. So with regard to the objection, I think what we're going to do is we're going to put the witness back on the stand. And, Mr. Cruz, you may ask her the question that you proffered, which is, something about, did she share everything with you about her personal life, right? The motion in limine that the state is asking the court to grant has already been granted. I have already granted that motion in limine, and I've talked about it several times. And so you just need to be aware, Mr. Cruz, that you cannot go forward after that question with any insinuations, for example, which I think is what the state is probably concerned about, insinuations about other persons. You can't do that. That would be a violation of the motion in limine that has already been ruled on in this case. It was ruled on again several days ago, but it was also ruled on when we had our 412 motion. So I'm not going to redo a motion in limine. It is already on the record. I will certainly hear any objections outside the presence of the jury. We've been doing that the entire time. I'm not going to, order that you all argue your motions at the table. Things are getting heated. There are sensitive topics. We've made a habit of coming to the bench and sending the jury out, and I think we're just going to have to continue on that thread. But, Mr. Cruz, you can ask the question, if whatever the question, however it was phrased, about whether Ms. Baker shared all of the intimate details of her life. That could be relevant. There has been testimony elicited that Ms. Baker was a private person. There has been testimony elicited that she was best friends with this witness or close friends with this witness. You can ask that question. But you need to understand, you can't use that question to then get into any testimony about other persons. Chris Melton is the one that you noticed the state was fair game, for lack of a better way of saying it. And the state is on notice about that, but no one else. And that's what I was referring to when I said there's been no 412 motion filed. If the defense finds it necessary for them to attempt to go down a line of questioning where other persons were, questions about other persons needed to be had, you have to file the right motion. And I will schedule it. And we will have a discussion. I mean, it won't be timely, but I'll schedule it. I've told you that. But am I clear about that? I mean, the motion that you're asking me to grant Mr. Yalamanchili has already been granted prior to today. And so I'm not going to re-grant it. Yes, sir.
I'm clear. I think you asked me if I was clear. Yes, ma'am.
Okay. Any other questions?
No, ma'am.
All right. We're going to adjourn, and I will see you all tomorrow morning at 9 o'clock. Thank you.
I'm fucking muted again. That was tough by the end. I just want him to shut up. Like, he's not helping his client one bit there. Fuck. I thought the other attorney just put a paw on it. He was perfect. And he went up and said all that stuff again. Just. Right. Okay. So, I think it's going to be spicy again tomorrow by the looks of it. So, yesterday was boring. Today was fire. Tomorrow's going to be even more fire by the sounds of it. So we'll see. I mean, it does seem that they can go into more with Chris when he is on the witness stand, just not with all the other witnesses. But I just don't like the fact that the judge made him say all that stuff, his strategy in front of everybody. I think that was very inappropriate. I also understand why he keeps doing all these antics, because he's in case his client is found guilty. So I sort of understand it, but there's only so much you can do on it. What was the other thing that they were arguing about? I don't remember. But he is right. The prosecution shouldn't be able to just go up and stop a witness just because they presume that he's going to ask a question. So that shouldn't be a case either. And obviously it is important for the defense to elicit that, she was very private with her. Because essentially the defense are going to say in closings that I imagine that this defendant and the victim had an affair or slept with each other. That's how, obviously, the semen got on the body or something. So that's why no one knows that. So that's why he needs that bit of information to say, well, she's very private. Her best friend said she was private and all that. And that's why no one knew about them sleeping with each other. That's pretty crucial for them, I would say. But they also need a DNA expert in, because that other DNA expert did not explain fuck all to us. So, right, you're all kicking me out. I'm going to go live at 9:30 tomorrow. Court starts at 9, but typically they've not been starting to about 9:15, 9:20. I'm going to go at 9:30 because it means we can skip the break then. And then during lunchtime tomorrow, if I remember, I will play the I will play the opening statements again, because a lot of you do not know everything about it. So I'll do that. But anyway, for now, thank you everybody. We shall see you tomorrow. I'm going to close it now because I've had enough. So see you all later. See you all tomorrow. See you at 9:30 Eastern, and we will get going. All right, no move.